Oh, how are we? Daffy Dill, how are you, my darling? Good morning to you. Good morning, Rhonda. Absolutely. How are you, Rhonda? Shit. Let's just do two things at once. Remember, we got the Casitas trial on as well. So there's two streams going on as well. Now, we have a stranger. We put some calls out because we thought something happened to her because she wasn't here yesterday and the chat was quiet, and she's back today. Lady Di, I was like, we need to get some warning signs out. We need to get like one of those bing bing boo to check on you to make sure you're okay, because you disappeared and we're like, where is she? She's never quiet. I'm glad you're back, Lady Di, because woof, we were concerned. Hope you're well, Lady Di. Hope you read your emails before you went to work today. How are you, Rhonda? I know you're over watching the trial, I think, so I hope the trial is going okay. I don't even know what's going on with it, to be quite honest with you. But I'm still streaming it for those that want to watch it. So I think Mexi will be over there. She seems to be in on it as well. But yeah, hope there's a good crowd here. Speaking, I can't do two things at once, so I don't know who's over there. I started it a little bit earlier because it seemed the court was starting up earlier. Hey, Daffy Dill. Hey, Keith. There you go. She's gone again. She's gone quiet. It's like the way I worry about people like Lady Di is if they go quiet, I worry because they never you can never shut them up. So that's why I worry. Hey, Terry. How are you, my darling? Hope you're well. Not seen you I see you briefly, but I hope you're doing well, my darling. Dave, how are you? Boston Labourers Union. There you go. How are you, my friend? Hope you're well. I'm bouncing back and forth. There you go. Bounce, bounce, bounce. I love it. Look at a cheeky me. Look at her. Rhonda, how are you? Good to see you. What about me? I was missing you yesterday. I was like, where is she? I was like, this is not normal. The chat's too quiet and Lady Di is not here. So I do not like it. So, I don't. K Ty, hello. Is the trial? Well, it's a hearing. Oh, the other one, you mean? If you mean the Casitas one, yes, it's in another stream. We got two streams going. We got, I think Mexi's going to be in the other one. So there's two trials. Yeah, it's going on now. Where is it gone? Let me check it out. But it should be going there. Rhonda's over there, so it should be there. If anyone wants to watch that one instead, it's a commentary-free stream. Let me see where the link is. Here we go. This is the link. We've got Standing Stones in there. You got Rehab in there. Dan from Atlantis, Rhonda, Bad Daza. There you go. There's a lot of people in there. Right, hang on. Mexi did it. Fucking, you beat me to it. Literally was about to post it. Thank you, Mexi. You see, she's too good for me. She's too good for me. But hello, everyone over there. Now, there's some interference in the chat. I don't know what's wrong, but then I just saw Dana Leonard. How are you, sir? Good stream last night. I watched a little bit of it, but I was so tired, Dana. Tracy's haircut is gorgeous. I love her haircut, new hairstyle. It's gorgeous. But yeah, hope you're doing well, brother. You're bouncing too. There you go. I'm fine, thank you. Hey, Dave, how are you? There you go. Turtleboy is a hearing. It's this afternoon, Katie. It's later on today, so it's at 2:00 Eastern. So yeah, it should be shown. Thank you, Maxine. Why did I think the trial was done? Because you're not watching it, same as me. I have not watched it. Thankfully, Mexi Texi's all over it because I ain't. I have it open now, so maybe. Oh no, I've not. Where's it gone? I deleted it. I will have it open at some point to say hello to everyone. But there's a lot over the Standing Stones and all them. Dan, so. Taylor Swift, okay, she's on podcast tonight. Everyone, Everybody, yeah. So obviously we got Turtleboy at 2. I hope if it's on Zoom, we'll piggyback from Mike. We'll show it from Mike. But I'm not sure if like any of the networks are streaming it. If they are, we'll stream it. If not, if it's on Zoom, we'll stream off Mike's Young Jerks. So if that's the case. But yeah, we have, if there's Zoom or cameras, then we'll be streaming it. And normally the court allow it, so as in they like it, so they normally do show it. But before that, we've got lots of stuff to do today. We've got lots of stuff. I might play the same things as yesterday because Lady Di missed it all. I'm going to show the Brian Walshe hearing because I didn't show it yesterday because we were watching other stuff. I'll show that. That's like an hour. I'll show that one this morning in the build up to Turtleboy. Oh, there's a few other cases that are frigging wild. Like one of them is a teacher blaming an 11-year-old boy for having sex on play dates. It's wild. Mike B, yes, I saw that. 2:00 tomorrow. So there's another stream. So yeah, I'm looking forward to that. Sounds like the hearing tomorrow related to Proctor's case may be interesting. Several of the defense attorneys for the cases are hinting at wanting dismissals. It's an interesting one. It's going to be a very interesting one. It's going to be interesting what the judge does because the judge is a bit of a predicament with this one because there's a lot of it's going to be an interesting one for all the cases. I think the ruling that the judge makes is going to impact on a lot of cases. So we'll see. Hello, Leanne. Allegedly, much love to Vinny as well. Hope he's doing well. I cannot wait to try custard ice cream when I'm out there in Boston with you guys. We need to arrange that as well. Dennis Sweeney loves ice cream, so we'll make sure that Dennis will come as well. He is obsessed with ice cream, so as I say, Leanne, it's a date. We will have no Abercrombie and fish, though. Let's just put that out there. Please hit the like button. Yeah, please hit it. Don't make me sing. Don't make me sing for likes. That hearing will include Walshe. Yes, it will. I mean, I think it. I don't think it's going to be dismissed, but it should probably be dismissed. But the judge is never going to dismiss it. I don't believe. Wow, it's. Proctor has fucked it for everybody. Not just him. We all know Proctor, but there's so many others that are corrupt and have messed up. And it's all catching up with them now. So we'll see. Happy days. I hope his arm's better, though. Yeah, can't wait for the custard ice cream. Never tried custard ice cream before. But Vinny wants it, so we'll do it. You know it. Oh, hang on. Let me show you this first. I've not watched the whole show yet, but Turtleboy show last night. I've not seen it all yet. Now about Bukkake and his singing Turtleboy. I need to watch it tonight after the stream. Here we go. Right, hang on. I've just managed to see a little bit of this, not seen it all yet. So live. That Joel guy, he pissed me off. Joel from whatever podcast he's on. He pisses me off. I've seen he's got warning for Joe. Let's watch this. Oh shit, where's it gone? Where's my headphones gone here? I've not seen this yet, so I want to see it. Let me go back a second. Here we go. Here we go. Shout out Turtleboy Live. I mean, you all follow him, so it's fine. Kathy, how are you, my darling? Where you from, Kathy? You say morning from thee, and you hit enter. I hate that when it happens.
Yeah.
Good morning.
Oh, then Bukkake was out. You guys see this? Look at this. Got something. So this guy is going around now, apparently doing karaoke in West Dennis. I mean, I'm sorry.
Wyoming, Josh Allen country. There you go. Hello, Kathy.
Talk about a lack of self-awareness. Bro, everybody hates this guy. Like this guy he is the biggest villain of all time. Like if you're this guy, I mean, the ball's on him to get drunk. First of all, you're in your 40s, bro. What are you doing? You're getting drunk doing karaoke and shit. Like everybody, I don't know if you know this, Bukkake, but like millions of people watched that trial and saw you testify. And just read the comments, read the live chat on any of this shit, dude. Everybody thought you were a dink. Everybody was like, this guy sucks. This guy is like arrogant and a liar. And he says he's the Webster Dictionary. Oh God, am I getting the static again? Oh, am I going to get demonetized? I bet you Laura's going to tell me I can't play it because I'm going to get demonetized. I bet you. So Laura, whenever I see Laura check in the background, they usually tell me it's because I have static, but I bet you she's telling me now, don't play this video because you're going to get demonetized for the copyright. Let's see. Yes, I called it. She goes, yes, copyright. So we're not going to play it. We're not going to play it. No, there is no fair use. You can't, because they will, whatever. You guys get
the music
doing that. Let's save the show. Or save the whatever. You guys get the point. Actually, I'll just do it with the volume down. Can I do that?
Yeah, you can do that. Yeah.
Let me do the volume off. First of all, just look at this dude. Look at him. Who does this? He's singing Armageddon.
To be fair, it's probably funnier with the music off because he looks like he's kissing that pole. Looks like he's like mouthing it, kissing it, and deep throating it.
He's singing the "Don't want to close my eyes." Look at him! Look at him! Look at him! Bro, what are you doing? How drunk are you? What is he doing? You're a grown ass man. Like everybody is watching it. Like you're so well known as an international douchebag, and you're like, you know what I want to do? Draw more attention to myself. I want to go on the stage and just draw attention to myself and be a drunken boob and do karaoke. And he's reading off a teleprompter after testifying in front of millions of people that he can't speak English.
Truth.
The English is his third language. He needs the Webster Dictionary. And he's dressed like a fucking tourist. Look at him. He's wearing thong sandals. Look at this guy. Look at him. Make sure. Pound it, bro. Pound it. I mean, this is a guy who still like goes to barstool events and is like, Senators are for the boys, bro. Can I get a picture, Dave Portnoy? Can I get a picture, bro? Yeah, bro. Party, dude. Like, dude, you're a Massachusetts State Police detective. You act like you're like Mr. I'm a really serious person. We do real serious work around here. We investigate murders and we take them seriously. We follow protocol. And I have my elbow up in the stand and my cuffs hanging out. And I'm a real serious detective. And you should know about this. And bro, this is the real you, Bukkake. This is the real you. You and your stupid wife Shelby, right? She sucks. Shelby's got to be embarrassed about this.
Hey,
Bukkake.
Dennis.
She's got to be embarrassed. This isn't even the people in the window are like, dude, look at Bukkake. He's out of control. What is he doing right now? They're like, oh, bro, this is embarrassing.
Yeah, that's not a great
look at him. These guys have to know. So, like, what I want to know is whoever filmed. Oh my God, look at him! Look at him. These guys they're egging him on, right? They know who he is, right? They have to know who he is. Look at him. They're egging him on.
Oh, jeepers! Right, well, we can't hear it, so anyway, that is the Bukkake stuff. Go and listen to it. I don't understand why Aiden gets copyrighted because he's not monetized. So that was on YouTube. Yeah, it's on YouTube, isn't it? So I mean, you only get stricken if you're monetized. But slow day. It's a good day, Dennis. I want to show you the Bukkake one, the Bukkake stuff. Is he monetized now, is he? Oh, I did not know that. I didn't realize he was monetized now. Oh, okay. There you go. I didn't know that. Thank you, Keith. I did not know that. There you go. Well, that's why he did. Like, he's not a sucker like me. I play it and then worry about it, you know? Get the name of the song and listen to the lyric. It says a lot about what he really wants. There you go. Bad Daza think he is now. There you go. Thank you, everyone. I did not know that. So there you go. Like, this is why I'm a dickhead. I would play it. Do you know what I mean? What was the name of the song? What was it? What was the name of the song? What did they say it was? Was it Armageddon? Oh, do you know what? The chat was so much quieter yesterday without this one. Now it's become bitchy again. Now she's back. Is he is he going to testify? Is he? I'm not surprised, Daffy Dill. People said that he would have to. Don't want to miss a thing. Oh, Aerosmith. That's Aerosmith then. I said above with the lyrics. Yeah, Iris by the Google Dolls. What? How? Is that a different song than Dana? Iris with the Google Dolls. What the frick? Because I'm got another one. I don't want to miss a thing from Armageddon. I'm not, as you can see, I'm not a lyrics guy. So it's not Aerosmith. So it's not Aerosmith. So it's Iris by the Google Dolls. Why? Okay. Yeah, I know. Turtleboy said that as well. That's why I went out for Armageddon, because he said Armageddon. Iris by. Now, if this is wrong, then we all know who to blame, Dana. I'm with you. As well. Bad Daza. I thought he said Armageddon as well. What? I'll play this one, but I know the song, but I'm. Sent me the actual video, so thank you, Dana. So we can watch the actual video. So Bukkake. I just want you to know I am. Thank you, Dana. Let's go, baby, yeah. Who's getting ready? I don't know. Okay, he can't sing. When everything seems to be broken, I just want you to know who I am. I just want you to know who I am. I just want you to know who I am. Fucking hell, that's bad. Yeah! I played, dude. There you go. Well, that's Bukkake for you. That was Bukkake. So, are we not glad that we didn't listen to Dana? You know, Dana was wrong again, obviously, but his fault. I'm joking. Thank you, Dana. I didn't realize. Thank you. Again, everyone's going off what Turtleboy said, but it's fine. Right. What have we got here? That was bad. He can't sing for shit. But anyway, sticking with the Massachusetts theme, I've not watched this from yesterday, so some of you know, we're going to watch this. Shout out to Young Jerks, Mike, who I got this from. I know some of you have watched it already. That's fine, but as we know, there's a big hearing tomorrow about all of this. So I think 2 o'clock tomorrow, leading from this. Oh shit! Hang on, let me move that for a second. But yeah, you all know Young Jerks. You all probably subscribe to him. You know, so we go by that. If you haven't subscribed to him, go subscribe to him. But I'm sure you all are anyway. So this is a hearing. As I say, I've not seen it. So I wanted to play it now in the lead up to this afternoon. So we'll see. Hello, Standing Stones. Hello to you, Crystal. Hello, everybody. Mexi's dog's howling. Right, let's go. This is the Miles King one first, I believe, and then we go into Brian Walshe. And Brian Walshe is there as well. Oh fuck! Have I? Why is it paused? It's not me. For some reason, on Mike's side, it's paused. Oh, okay. No, it's expected to start. Oh, I thought it started there. Shit. That's my bad. Hang on, let me find it. Let me find it then. All right, here we go. There they are there. Let's. Not much happening, I don't think. Okay. From about here, I think. Jim's there, pouring his gin.
Watch the session, please be seated.
Right, okay, I will.
Oh, thank you. Number two, 19467, Powell versus Bernardo, Michelle.
Okay.
Right now it's on for August 27th.
Yes, we're holding the date.
I'm ready to do it. If I could keep it on from that, for possible disposition.
I'm holding it for trial, so if there's a disposition, it's gotta be before, we got a final pre-trial conference today, right? So now would be the time to resolve it if it was gonna be resolved, so.
I have to talk to somebody here. So we'll just keep it
I'm
on
sorry,
for
is
trial.
there a plea? Is there a plea deal? Is there an
Not
agreement?
yet, not yet.
Not yet, okay, so we got trial on.
So I understand that you're drawing a line in the sand, but just so you understand.
It's the line in the sand that you drew with the motion to continue the May trial. Right, you folks proposed these dates.
Well, at the time, I didn't know that I was standing in front of the judge. Okay.
Yeah, I think it's Kevin, yeah.
If it is, and the day is over before that. So I'm just trying to judge the schedule, that's all.
Okay?
I'm checking it out for 27th.
Put it out for the 27th.
Thank you, Jackson's Nickel. He looks like him, yeah.
It is.
Okay. You want to put it on for the 26th for change of plea?
That's what I'm saying, I'm just trying to judge these things.
No, I mean, I have flexibility to, impanel on, the 27th, and, start the trial a day later, or 2 days later, or something.
It's not good for me, I have a witness who's gonna be out of state for December first,
Okay. Until,
starting December first through the fifth.
So,
okay. often, I put it on tomorrow or the next day. But I'm not willing to kick off the trial.
Well, you're not gonna throw it on me yet.
I'll file a couple of motions.
And this is a 2019 case.
Well, it's the government, so
I'm sorry?
it's the government, they're avoiding fraud.
I'm sure.
I mean, I'll be here from my own presence, so I can tell you.
All right.
And then I might have to have Mr. McDermott speak to Judge O'Shea.
I'll talk to O'Shea.
Yep.
I'll talk to him. And when I get off the bench, I'll give you a call.
Okay. Yeah, I think that's starting,
What's the case?
I believe it's a murder case, I believe it's the second of September.
I'm sorry, it starts the 2nd of September?
I'm pretty sure.
Oh, I thought you said you had a trial before.
No, that's going down to basketball, that's starting next week.
Okay?
And this is like a drug case that just gets stuck in between. So it's,
No offense, Dave.
The mic's off. The mic is very low down at the minute.
I am not.
Look the site.
going to continue the trial. So
He's not standing by the mic. That's why.
So, and the defendant will not be excused on that.
27.
27.
Good. Thank you.
Okay.
Number 8, Christopher Randall, Mr. Nelson, Mr. Armour. Is Mr. Nelson in the other session? Okay. Can I have a Commonwealth identify herself in general?
Fuck. I was muted. I'm going to skip to the actual Brian Walshe one. Here we go. This should be better. Because you couldn't hear the attorneys in that one. I think Mike had a fucking mare. There's no audio.
Head
Here we
and
go. Let me go back to find it then.
to continue on the week by week.
Thank you, Dennis. Right, the sound does come in now, so.
Necessary to continue on the week by week kind of path that we have been on.
if I don't continue a week by week, as soon as Judge Casper rules, we have a 4-day or 5-day window. I suppose I could enter an order today, which is contingent on what Judge Casper might do. There are a lot of things I could do, but it would be very if this then that, which is problematic for me in fashioning a suitable remedy.
I understand that. I do think that, you know, and this court is aware that there are, that the federal law is significant in this regard.
But so is the state law. And regardless of what the federal law says or doesn't say, you've had custody and possession of these records for more than a year. And this is, you know, we've talked about this already. It's at the very end of the time that this is all coming to a head. And leaving aside the question about whether you control the records, which is the operative language in a lot of the filings, you clearly have possession and custody, and that's what the feds are worried about. Rule 14 says what it says, and our constitutional interpretive case law says what it says in terms of the obligation on prosecutors to review and disclose that type of information. So the court has significant remedies available to it, and that don't involve ordering you to do something in violation of the federal law, okay? But there would be consequences on you and your prosecution of these cases if you did not comply with your state constitutional requirements or your Rule 14 requirements with respect to the material that's in your possession and custody.
But that's why we're acting in the manner in which we're acting, Your Honor. And I want to be clear, as the court now is aware, the order itself prohibited this discussion prior to only recently.
I don't know that. You've given me a December 2024 order. I don't know what was in place in February. I don't know what I think there was a date between February and December where there was another order. I haven't seen those orders.
So I
don't know why you can't give me a copy of what you filed with Judge Casper, or give to defense counsel, to be honest. The fact that it's a sealed proceeding, it doesn't mean that you have to file everything, you have to keep everything that you file in that proceeding under seal.
I'm relying on the advice of our counsel, and we have repeatedly asked for those previous orders. We have been told that those previous orders substantively are identical to the most recent order, that the reason there were multiple dates was if they provided for different people to sign the acknowledgement. That's all the information that I have.
Have defense counsel sought to subpoena the information from defense counsel in the Reed case? Because all of it was turned over to them.
I did speak to one of the attorneys in the Reed case, Your Honor, asking for that information. It was that attorney's position that the document was under seal and that they couldn't give it up voluntarily. And they didn't know what they would do in response to a subpoena. But that's the information that I got from the judge.
Okay.
They don't think that they think that they're bound by the order that they signed.
Okay. Well, all right. Well, you didn't subpoena them. It's not framed. It's not, the issue is not joined. The issue.
If we have a new hearing date, I'm happy to subpoena it.
Mm-hmm.
But I don't have a subpoena for this court date because I thought that might be an abuse of the subpoena power because we weren't going to actually.
No. I agree with you, but we were not going to have evidence today. All right. Well, let me hear from defense counsel as to what one or more think I should do.
So, Judge, on behalf of Mr. King and Mr. Johnson, I'm asking that you take action on our underlying motions.
Oh, so this is this is Scapicio, Miles King, Brian Walsh. Everyone's in this call then. That makes sense. That makes more sense. Everyone's in this call and that makes sense. So I think the background is that Laura McLaughlin told the defense that there was stuff relevant to the case in the FBI filings, but she's not able to share them. So that's the issue. In a way, she's done the right thing by telling the defense about all these things, but she's also saying she can't release them because they're under seal through the Karen Reed trial, and that's what whoever they spoke to from the defense team of Karen Reed, which I imagine is the Anetti maybe, is also saying they're under seal and they can't give them either. So that's the sticking point, is that the FBI are they're all under seal, so they can't share them currently. Is how I'm reading this at the minute. Prosecution is following the advice of their counsel. Yeah, they said it their counsel. Yeah, I don't know who that counsel would be. I don't know. I really don't know who their counsel is. But I get the predicament. They've said that there's expulse, wherever you say it, evidence, but it's all under seal, so no one can share it at the minute. So I presume they have to subpoena the FBI or ask for the FBI. I have no idea how they're going to get around this. I don't know. This is a sticky situation.
That we filed for relief regarding the federal materials in possession of Commonwealth. I'm very concerned that we have 5 days. I was concerned when we were here last time that time the clock was ticking. I know the court was concerned. I know the Commonwealth was concerned. But the bottom line is that if this doesn't go the way the Commonwealth anticipates it will, then these documents are gone forever, and we'll have to file additional motions as to what the court can or should do under those circumstances. So we're asking the court to act on our motions in order the Commonwealth to review the evidence that they have in its custody. In the alternative, we're asking that if the Commonwealth declines to do that, or the court declines to enter such an order, I'd be asking the court to dismiss the cases against my client because he cannot get a fair trial.
That's interesting. If she is in deep shit, that's interesting because technically she's done everything right, hasn't she? She declared all the evidence, but she just can't share it. But obviously, I've not watched this hearing, so I can't comment. But from my understanding, she's done everything right, but they can't share it, which is bizarre. All this is bizarre. Welcome to Massachusetts. It's all fucked up.
The opportunity to review and analyze the information that's been in the possession of the Commonwealth since February of 2024.
Okay.
Judge, Attorney Krusk on behalf of Giovanni Della Santos. Just one suggestion, is there, having practiced in federal court and still currently practicing in federal court, is there any reason that the government cannot make a call to Judge Casper's session clerk right now and find out whether or not it has been docketed and whether or not there's been a hearing order?
I'm sure it was filed by Pacer. I'm sure it was on Pacer and it's been docketed. There's a representation already that it's already been filed, but obviously I would like to know when Judge Casper is likely to see it and review it. She may be on a 2-week vacation hiking in Nepal. And so I don't know.
And that's sometime, I just know anecdotally and empirically, that's information that the session clerk might be able to reveal that it's being reviewed. I understand the position that going forward, we don't need a court date every week, but certainly the posture right now, I think we need a weekly court date. So I think that
I agree with that. And I'm surprised the U.S. Attorney's Office didn't join in a 30-day extension. What's troubling to me is the U.S. Attorney's Office's position in the letter to Attorney Beatty that they're not going to seek a further extension or further amendment of the protective order. So they seem to be saying we've done as much as we're going to do. Now, the information that Attorney Beatty is sharing with us now, or sharing with me now, maybe you folks knew before, that they've agreed to tolling. And again, we don't know whether Judge Casper is going to agree with that, but they've agreed with the idea of tolling, even if it's not an extension, just means we have that 5-day window that's preserved. And that informs me about when I need a next hearing, unless we can get further confidence that we're going to have enough time to deal with this.
Well, I think we need a hearing on or before Monday. Just so it's clear on the record, on behalf of Mr. Della Santos, I'm joining the request that all Rule 14 discovery in the possession of the District Attorney's Office be turned over to Mr. Della Santos, irrespective of any other order from any other court immediately.
All right. Any other counsel wish to be heard? Mr. Cataldo?
Yes, thank you. I think we need another date before the federal court, once they act as Judge Casper acts. We need another date, a short date. And I think it goes without saying that we should order the District Attorney's Office to comply with Rule 14 and go through all of it and meet their obligations to us.
I don't need to order the District Attorney's Office to comply with Rule 14. They have that obligation already. They already have the obligation under Giglio and Brady and related cases to produce information in their possession and custody, which are exculpatory.
They're complying with that.
Well, that's a question that I have. Okay, that's a question that I have in connection with the Walshe filing with respect to the opposition of the motion to dismiss in the Walshe filing, and we'll get to that. But I don't need to enter that order because that is already their obligation.
Can I just make a couple additional points?
Yeah, I was thinking I might hear from Mr. Tipton before, but go ahead. I hear you, and then I'll hear from you.
I think Ms. Cusick is going to represent the Commonwealth on the Walshe case. Because
Okay.
she had filed the pleading that's more specific and responsive to the multiple pleadings in the Walshe case. So,
Okay.
I'll let her chime in at the end, but I do want to note that defense counsel is orally moving to dismiss. The Commonwealth is not on any notice of that, so I would ask you not to take any action in terms of dismissal at this time. I also would note that no counsel has cited a case that outlines this particular procedural posture and how it interplays with Rule 14. And I appreciate that the court is saying that you don't need to order us to comply with Rule 14. And I don't mean to be disingenuous when I say you don't. We take this seriously.
No, I understand that, and I'm not suggesting that otherwise. I'm really not suggesting otherwise.
Defense counsel isn't either.
Yep.
But this is a big deal.
Yep.
What is being contemplated here, and to throw these sorts of terms around is these are important issues for the defendant. These are important issues to the Commonwealth, to the victims, and to our whole process. And this office is committed to and is continuing to work through these issues.
And I appreciate that, and I appreciate the way defense counsel's handled it, and that's the reason why I'm taking it in sort of an incremental way. I understand the sensitivity of it. At the same time, I'm trying to get us to a point where it is a non-issue, okay, where we can be satisfied that the documents, that we don't have to parse control versus custody versus possession, okay, and what that means under Rule 14 in this particular kind of a case. Because I'm not sure that there are cases that we'll find, certainly not in Massachusetts on this topic, and certainly not under Rule 14 as it's been recently amended. So I think we need to know what next steps Judge Casper takes, and we need to respond accordingly. And give Judge Casper the opportunity to address these issues, understanding their sensitivity.
Can I just respond briefly? Sure. I know we talked about the Commonwealth talked about a response that they made in Walshe case. They haven't responded to either of the motions that we filed on behalf of Mr. King or Mr. Johnson. I don't have a copy of their response in Mr. Walsh's case. So to the extent that they've known about these motions since they were filed back on, July 18th, 2025, they've yet to respond and oppose it in any way. And now are we supposed to, the defendants in this case, are supposed to keep track of what's going on in Walshe to know the common position?
I understand that particular predicament, and I am happy to set a schedule for the Commonwealth to respond to your motions. I don't think I'm prepared to address the Walshe motions just yet, but I want to hear from counsel on them. The issue that I raised, that I had a question on, I'll see counsel on the Walshe matter if they wish to address the court separately. Mr. Tipton and Ms. Porges, I think you're up. I have a motion to dismiss or request for alternative relief. I'm inclined to go gently on this issue and see what Judge Casper does in terms of either giving us additional time to consider this. Let me just...
Okay, I've teed it up as well, so we can hear what Emily D. Baker thinks as well after this. I just found her stream, which we'll watch after this now. Hang on, let's go back to this.
Ask again, Ms. Beatty, to say exactly the relief that was sought from Judge Casper. One, besides leave to intervene, what else did you ask for?
We asked for permit modification or a court order that would permit the Norfolk District Attorney's Office or outside counsel to review the materials. We also asked that we be permitted to retain the materials for a period such as 6 months so that defense attorneys could pursue their own avenues of obtaining the materials. And I just have 1 minute. we ask that the court toll the destruction date in the protective order until after the issues, bless you, until after the issues raised in the motion are fully resolved. And as I said, we asked for oral argument. And I'm happy to ask our counsel whether or not we can share these pleadings, but I'm not prepared to share them at this time.
If you probably can, Judge, I'd like to be heard briefly.
Yeah, hang on one sec, Mr. Tipton. So the second to last paragraph of the first Assistant U.S. Attorney's letter, dated August 5, says, in the United States' view, it would be inappropriate for the Norfolk County District Attorney's Office or Defense Counsel in the other matters to seek to intervene in the U.S. District Court matter and to move to amend the protective order.
Yes.
That sounds like, other than the agreement with respect to tolling until Judge Casper can decide what she needs to decide, you're going to be faced with an opposition by the U.S. Attorney's Office to your motion to intervene.
I agree with that assessment, Your Honor. And we took the steps that we took, notwithstanding the position of the U.S. Attorney's Office, and we reached the tolling agreement after this letter. So my point that I'm trying to make is, notwithstanding their substantive point, I do not think that they are trying to put this court or this district attorney's office in the position of violating either a state court order or a federal court order.
Okay. Mr. Tipton.
Thank you, Your Honor. I mean, I heard you say you were...
Hang on 1 second. Can everybody hear Mr. Tipton? I have difficulty hearing him. Well, hang on a second. Let's see if Mr. Tipton can adjust things on his end so that he can be heard better. Maybe you can increase the microphone or...
I just did. Can you hear me now?
A little better.
I'm practically yelling here, so I'll keep yelling.
No, I really can't hear you, Mr. Tipton. I'm sorry.
Maybe I should try to join
hell.
using a different computer real quick, but I don't want to waste the court's time.
I'd rather hear you.
Judge, can I make a suggestion?
What's that?
Mr. Tipton calls my cell phone, I can put it on speaker and everybody can hear.
How would that be?
Fine with me.
Okay, do you have, I don't need to ask you specifically, do you have Miss Capiccio's cell phone number?
Yes, we're dating.
I don't think
Judge,
so.
I can share it with Mr. Tipton right now.
All right, very good.
And I'll call in.
Fucking hell.
Or I can just call you right now.
You can call
Mr.
me.
Tipton, this is Jim McDermott.
Go ahead, Jim, try that.
Sure.
Go on, Jim. Come on, Jim. Be a hero, Jim. Jim's phoning him.
All right. Well, here you are.
Can you hear me better?
Hang on 1 second. Why don't you identify yourself for the record?
Larry Tipton for Miss Walshe.
Echo.
You able to hear that? All right, Mr. Tipton, we'll hear you.
Just briefly, Judge. I think Liebman, whether it's the government opposes it, but Liebman seems to make it clear it's the Commonwealth's obligation to get materials from the federal government. There's no question when you read those two cases that is exactly what the SJC said.
way back in the 1980s. Secondly, the Commonwealth has failed to inform this court or any party what the exact basis is that they're relying on that says they can't review the documents in their possession and custody for Rule 14 information as defined by Rule 14. Now, I'll just say that when we were in Plymouth, they produced a December 2024 protective order. There was one they let us read it. We couldn't copy it. We had to hand it back. We did. There is a paragraph in it that seems to touch upon the issue at hand. But that paragraph, and I won't repeat it, but I think the government knows what paragraph it is, and it does not, in our opinion, prevent the government from reviewing the documents under Rule 14. It does have language that says you can't use the materials in any other case other than the read matter. But that's not what we're asking for. And for the government to continue to act like a paragraph that says you can't use materials in another case means they can't review them under their obligations under Rule 14 is creative thinking, creative interpretation, and it's simply running away from their obligations. And finally, the only other thing I have to say is what we've said repeatedly, and it was based on what the government told us beginning on July 17th when this issue became known. And that is, why haven't they explained then why Attorney McLaughlin, Assistant District Attorney McLaughlin, did in fact conduct some type of review of these materials and gave certain information to either the prosecutor in their office and our defense counsel. Now, granted, I was never told they gave substantive information, but they apparently gave sufficient information to either their DA or the defense attorney. And that is not addressed, once again, in the government's opposition today. And I have argued that since I was told that on July 17th. And I'll just add that when we were before Judge Ferner, and she read that, and I understand that she cannot rule on this issue because of a judicial conflict, but she confronted the Commonwealth about that very issue. And the government refused to answer. And so I asked this court, why can't the government simply explain that? Why they did it in one case, why they provided information to either their DA or defense attorney in an unrelated case, and why are they simply refusing to do so now based on language they have not produced anything, but they still not produced the specific language? So I understand the court's not going to rule on our motion to dismiss today, but the last thing I'd say is I hope that this court will schedule some type of status hearing no later than next Thursday or Friday. And if nothing else, order the government to stay in touch with the federal authorities and have an immediate update about the status of their motion to intervene. And that's all I have right now, Judge.
All right, thank you. Mr. Tipton, are you connected? You can hear us through the regular Zoom, is that right? I see you nodding your head. Okay, very good. If you want to make another point, jump in and we'll call you again. But I don't want to cut you off. I appreciate the positions. It does seem to me we need another hearing, informed to some extent by what Judge Casper does. Is there other counsel that wish to address the court? I do have one question for defense counsel in the Walshe case. Who's speaking on behalf of the Commonwealth in the Walshe case?
Your Honor, Tracy Cusick for the Commonwealth on the Walshe case.
All right, so I have your response to the motion
Your Honor, a bit of housekeeping, if I could. That was a response to other motions. We received Mr. Tipton's motion to dismiss.
No, I'm sorry, I misspoke. This is a response to the motion for relief regarding federal materials. It's not a response to the motion to dismiss. But in your response to the motion for relief, you say the Norfolk District Attorney's Office is aware of its obligation under Rule 14. It's one of the last lines in your opposition, but you do not say whether you have or haven't complied with it. So I really don't know how you're interpreting Rule 14. How are you interpreting Rule 14?
Your Honor, we are interpreting Rule 14 as it is written, as we understand it to be written, that our obligation is to produce materials favorable to the defense, that our obligation is to, if we're aware of them, to inform the defense of those materials. We are aware of our obligations under Rule 14 in this matter, Your Honor.
But that doesn't really answer my question. We have unique circumstances here. Is it your view that even though these are nominally controlled by the feds, that you don't either possess them or have custody of them?
Your Honor, it is our view that doing what counsel is asking would be violating a federal protective order.
Reviewing the documents would violate a federal protective order?
In conjunction with a different case other than the Reed matter. In this case, we do have the unusual circumstance of someone assigned to the Reed matter is also assigned to this matter. And
so your position is even reviewing the documents, reviewing the documents in this context is not required by Rule 14?
Your Honor, I believe reviewing the documents in this context would be a violation of a federal court order.
But that's a different question. The question is, does Rule 14 require you to review these documents?
I don't believe it does, Your Honor, in the current posture of this matter.
And is there anything you can cite to me that would support that position?
At this point, Your Honor, I would say there is currently a federal protective order. We are officers of the court. We are required to comply with that order. And I would suggest it is clear there's the balancing of that federal order and the Rule 14 requirements of which we are aware. In this case, I don't know if the court had a chance to read in detail the Commonwealth submission.
I did.
There have been prior TUI requests by both the government and by the defense in this matter. And again, the court has the response we received from that as well.
The TUI request, though, is a different question than whether the Constitution, Massachusetts Constitution, or the federal Constitution, or Rule 14 imposes on your office an obligation to review documents that you're in physical possession of. And I don't really, I know that, I don't want to say I don't care, but it's not particularly material to the question of what the Constitution requires of you that a federal prosecutor somewhere said, I wouldn't give it to you independently.
I understand that, Your Honor. At this point, I don't believe we are required to review those materials in violation of the federal protective order. But certainly I would ask for some time to respond to the motion to dismiss that was filed this morning.
Yeah, sure.
And again, if something, for example, if something was in plain view, that might be something that would cause a person reviewing those materials in the Reed matter to bring that to the attention of the federal authorities or to others to say they're aware of information in the custody of third parties. Certainly nothing like that has occurred in this case. No one has indicated they're aware of any materials In the possession of third parties?
Okay. I'll give you an opportunity to address the motion to dismiss. We'll play this out a little longer and see what happens with the motion to intervene and motion for additional relief. I may issue an order in response to this argument, explaining why I'm doing what I'm doing. And I'll schedule a hearing for, I think, early next week. I could do the end of this week too. I'm here, but I think the early next week is probably enough time.
I think the order expires on Monday.
The order expires on Monday. That's true. So maybe we should do it before the end of this week.
Could we do Thursday, Judge, potentially?
I have that flexibility, and we should know more from Judge Casper by then.
I could do Thursday morning if anyone could do Thursday morning.
This week?
Oh, Thursday afternoon, sorry. Thursday afternoon, yes.
I'm on trial.
I could stand it for you, Judge.
Okay.
Thursday afternoon? Yes. Yeah, Thursday afternoon at 2 I could do if I'm just trying to give us some time.
Yeah. I'm flexible given what everybody else's schedule is. I think 3 days is probably enough time to get a read, or 2 days. It's only 2 days, but get a read from the federal court as to when they're likely to address the issue.
Not do Thursday, Your Honor, but Attorney Scatticcio can stand in.
I'm happy to stand in.
Okay. Mr. Tipton, with a thumbs up or thumbs down, are you able to do Thursday at 2, even if only on Zoom? That's a thumbs up. Okay, Thursday at 2. Thank you. Attorney Beatty, what do you think?
That's fine, Your Honor.
Thursday at 2?
And Judge, in the interim, may we get a copy of the Como motion to intervene?
I'm not prepared to provide that at this time. I will consult with our counsel, and if he advises us that it's appropriate, I can do that.
At a minimum, I would like a copy shared with myself and all counsel, even if the content of any confidential information or confidential material has to be redacted from that filing. So I don't know if in your filing, because you're obviously privy to the confidential information, not necessarily you, but others in your office are privy to confidential information.
Not the reason that I'm not sharing it. There's
Okay.
nothing in there that's confidential. That's not the reason.
So if the only reason is that it relates to an impounded proceeding in the federal court, the fact that it was filed in that impounded proceeding, I don't believe entitles it necessarily to be impounded for all purposes.
Again, I'm going to rely on the advice of counsel.
I'm not suggesting you do anything else, and I'm not ordering it to be disclosed right now. I'm taking your representation as to what relief it seeks, and we'll deal with this again on Thursday at 2.
And I think the other concern would be that if we shared it with counsel, what would they do with it as well? I think that's the...
Well, I think we're trying to keep apprised of what's happening in the federal court so we can make the decisions most intelligently here, and so that I don't do anything rash.
No, I appreciate that. I would ask for an agreement that it not be shared or disseminated outside of counsel. That's what I'm saying.
Every piece of paper that's been generated in this issue has had a check of order. We don't have a problem with that, Judge.
Okay.
No objection on behalf of Mr. Dela Santos on that limited discrete issue.
Okay, and with respect to, so that's Mr. Cataldo?
Okay.
All right, any problem with that, Mr. Tipton?
No problem.
Yes, no. He's shaking his head no. Okay, very good. In the Walshe matter, I have the Commonwealth's motion for protective order, August 5, production of chats, and Commonwealth's motion for state court protective order covering material subject to federal court order. Those were signed by prosecutor and defense counsel. I've allowed them and issued them as so ordered. So.
Yeah, I'm calling also submitting for Miles King and for Sean Johnson as well. That's been endorsed by both parties.
Okay.
And I did make one amendment to the King and Johnson on page 3 in that paragraph saying, because the Commonwealth agreed that I could share the information with my clients, but not the actual document. You could get a copy of the document. So I made that change on that. I just want to bring to your attention, Judge.
Ms. Hickman, did you see that?
We did. ADA Beatty saw it as well, and we are in agreement with that language.
Okay, so it would read, let's see.
The defendants are able to view the chats, Your Honor, but they just cannot get copies of the chats that are being produced.
Not duplicate or provide a copy of the text messages to any other person?
Correct.
Okay.
And Your Honor, I will get the printed for Mr. Cataldo and for Mr. Kowski, and I'll submit them by the end of the day so they can have their text message, the chats as well today.
I'm prepared to sign one subject to the same modification, Judge.
Okay.
It was emailed to me, but I was already en route to the courthouse.
All right, let me just act on these with respect to Mr. King and Mr. Johnson.
And I just had one issue I wanted to address before we conclude.
Sure.
I'm not going to be here Thursday on behalf of Mr. De Los Santos, but just so I'm clear of the landscape, I know we're keeping it a short day so we get a better appreciation of what's going on in federal court. But if I understand this court correctly, are you also contemplating an order that would order the Commonwealth to begin reviewing those materials for potential Rule 14 information?
Right now, I'm contemplating an order that explains why I put this off 2 days. I may have time to do that today, and I may not. Maybe not till tomorrow, but I am. So we'll see how far I get on that.
All right.
Okay, but in any event, we'll have further hearing on Thursday. Okay. Anything else?
Thank you, Mr. Clerk.
Okay. There is a protective order on Mr. De Los Santos related to promises and rewards and inducements.
That's with a different DA.
Okay. But Joe, just before we conclude, I wanted to address that today, right?
Yeah, okay.
Oh, you just fired this, right?
Yeah.
All right. Can you just identify yourself for the record?
Good afternoon, Your Honor. Jennifer Player for the Commonwealth.
Okay. And this is in the Chanchillo, De Los Santos, and Johnson matters.
Yes, Your Honor.
Okay.
Good afternoon again, Your Honor. Rosemary speaking on behalf of Mr. Johnson.
Okay.
Your Honor, the Commonwealth.
Hang on. And Mr. Krowski?
Attorney Krause on behalf of Giovanni De Los Santos.
Right.
And Attorney Joseph on behalf of Bianca Sanchillo.
All right. And on each of these three cases, I have the Commonwealth's motion for protective order regarding witness identifying information.
Yes, Your Honor. The Commonwealth became aware the week before last in speaking with a sergeant from the State Police Violent Fugitives Unit that there was an individual that was involved in assisting them in the apprehension of Mr. Johnson, who they were unable to locate for approximately 8 months.
So I presume this is nothing to do with Walshe. This is a different case. I'll leave it there for a second, but what I'll do is I'll go Bad Daza said that EDB covered it, so where is this gone? EDB. This is her summary. Let me go back here.
Ever came back. So let me go see if the pool camera ever went back and shared. They might not have. I'm going to reach out and ask them if they recorded the rest of the King hearing. But the court cut the Zoom feed and the pool camera cut before any of these hearings ever got started. So, what happened in the Miles King hearing today? We don't know. Because by the time they finally got to the Miles King hearing today, the Zoom hearing that had been streamed was gone, and the court stream ended before they even got into all of these hearings. The access to what is going on in court at times is incredibly frustrating.
Preach. It is fucking really frustrating. I mean, Massachusetts make it so difficult to access stuff. I understand, and I'm grateful that they do allow access, but They make it so hard to access stuff. Even on Zoom, they make it hard.
We just need our own cameras at this point.
Yes.
Okay.
Yes. We agree.
I'm going to have to check the docket. We're going to have to see what happened. But the host of the Zoom meeting ended the Zoom meeting. So we won't know what's going on with discovery in the King case until we check the docket and it's updated. So I will check the docket and see when it's updated. However, there is going to be a hearing on Thursday. So we will see what's going on the hearing on Thursday, and we will figure it out. I'm frustrated. You're frustrated. We're all frustrated. Maybe, just maybe, the pool camera that was in court will post the rest of the hearing. I will reach out and ask, because I want to know what happened in the King hearing, but what we heard the DA say is that the court has a filing that shows what was turned over and when, but does not have a filing that shows which documents are exculpatory, which means the court at some point is going to say, go do this. Michael J. Money said, I want so badly Baker Media pool cameras. I do too. It is difficult to navigate and expensive AF. But yes, same. We are trying to figure out how we can make that work. So,
that'd be cool.
Yes.
That would be cool.
But, however, I did see Sue O'Connell from Boston 10 in the courtroom. So let's see if she posted anything on the Bird app. Nope. I mean, I saw her in court when we will have to wait and see. Here's what we learned today in the extensive discovery hearings that were ongoing in, I think, 4 separate cases with 5 separate defendants, including the Brian Walshe case, which many of you know of. It's a higher profile case, the Miles King case, and others. The fight over federal discovery is not done. And the prosecution, if the best I can summarize this, the prosecution is in a unusual and difficult position with regard to the federal discovery. We're not going to talk about the late discovery at the moment. With the federal discovery regarding Proctor and whatever else. The issue with the federal discovery is that the prosecutor on the Walshe case, one of them, is Attorney McLaughlin. Attorney McLaughlin was also on the Reed case. Attorney McLaughlin is aware of what is in the federal discovery that was turned over to them in the Reed case via a TUI request. The TUI requests in the other prosecutions were rejected by the feds. They sent the request for discovery and the feds said, no, we're not giving it to you. In the Reed case, it was turned over. However, there's a federal protective order with the information in the Reed case. It cannot be used and disclosed in other cases. It does not say disclosed. The court read the language verbatim and it said it cannot be used in other cases. Here's the problem. Attorney McLaughlin knows that it exists. And the Rule 14 obligation for Attorney McLaughlin is that if you know of anything that exists, you have to disclose it to the defense. But they don't have it such that they can turn it over because of the federal protective order. But the judge said, but you have it. Even though you don't have it. Someone in the DA's office has this information. But the federal protective order says you can't use it in another case. But you have it. And because Attorney McLaughlin is aware of it, she has to disclose to Defendant Walshe's attorney, I am aware that this information about the lead investigator exists. It's potentially exculpatory. It's at least impeachment as to Proctor, the lead investigator. So I have to tell you it exists, but I can't give it to you. because of the federal protective order. But I have to disclose it to you. And the court's saying, but if it's disclosed and then you can't turn it over, aren't you obligated to review it to confirm that there is no exculpatory material in there? And the Commonwealth said that their position is they can't review it to determine if there's potentially exculpatory information because of the federal protective order. So do you see the circle that we are in now? It's been disclosed. It can't be turned over, they say, because of the federal protective order. It's not being reviewed further as to the Walshe case, because when Attorney McLaughlin went through this, she was looking at it for the Reed case, not the Walshe case, and can't review it again for the Walshe case because the position of the Commonwealth is that they can't, reviewing it is using it in another case and they can't do that. But she can't Men in Black flashy her brain and forget that it exists. And Attorney McLaughlin knows it exists and has to tell the attorney because she knows it exists because she reviewed it for the Reed case. But she can't turn it over to them other than knowing that information exists regarding Trooper Proctor. And she can't review it again because of the federal protective order. But the defense has a right to any potentially exculpatory information. And the Commonwealth won't affirm that it's not exculpatory because they haven't reviewed it again. And the defense is like, well, then you need to turn it over to us. And the Commonwealth is like, we can't because of a federal protective order. And the court's like, what are the feds going to do? And the Commonwealth made a motion to intervene in the federal case to get the discovery. And the feds, in the letter that the court read on the record, said, we think it's inappropriate for either the defense or the Commonwealth to intervene in this case. So the feds are objecting to the Commonwealth of Massachusetts intervening in the federal case to get this discovery. So they are disinclined to acquiesce to that request and turn it over. The court at one point said, so has anyone subpoenaed the Reed attorneys? And the attorney that spoke in court said, I think it's an abuse of the subpoena power to subpoena Karen Reed's defense attorneys to try to get this information because they're covered by the same protective order that the Commonwealth is. And I lost my mind and said, it's not the job of Reed's defense attorneys to turn this information over. And they're subject to a protective order. It's the Commonwealth's job. And the Commonwealth's like, but the feds told us to fuck ourselves. So, I mean, my summary. So what are we supposed to do? So we are in a very strange, every time we're in Massachusetts, we're in a very strange.
Yeah, it's fucking Massachusetts. Every time. I agree with her. So, oh my days. So there's a hearing tomorrow. They are fucked. I mean, I don't know what they're going to do. I really don't know what they're going to do. I really don't know what the judge is going to do. I don't think the judge is going to dismiss the Brian Walshe case, but what's he going to do? I literally haven't got a Scooby-Doo what he's going to do. Look at that, Scooby-Doo. What's he going to do? For whatever, I mean, this does happen in other states, by the way. It does happen in other states, but it seems we always come back to Massachusetts and there's always some sort of fuck up. I'm glad she said that because I'm just as confused and she seems to be confused as well. That McLaughlin handed her over, but then she can't give anything else over. So she, one hand she did the right thing, and then on the other hand, the prosecution was like, well, we can't do anything else. Oh my days, this is so confusing. How many more people, like, so was it last week or the week before or 3 weeks ago? Wicked like you said it, that in Massachusetts, there are a lot of people now being released from jail because there's not enough attorneys to represent them. I mean, it just sounds like a mess. How much of a mess is it in other states? Because maybe we hear so much of it in Massachusetts, we don't hear about other states. But I know it's bad in other states, but this is just... We saw yesterday how bad it was in Arizona. There you go, public attorney strike. Thank you, Wicked Psyched. Arizona yesterday with the prosecution. Like, can you imagine the case yesterday where the father left their child to drown for 7 minutes and just unsupervised for 10 minutes. If that was Massachusetts, there would be no question about it. Yeah, take it forward. So I'll give them that. They prosecute everything, it seems. But wow, it just seems... I'm just glad that EDB is confused, because I really don't know what the judge is going to do with this. I don't think he's going to dismiss any cases, but how is he going to rectify this? The times like this, I'm glad I'm not a judge or an attorney and stuff like that. Can you imagine if Brian Walshe? Wow, okay, we won't go there. But so there you go. That was a bit from yesterday. What's the time now? 10. Aiden's hearing starts in 3.5 hours. So I thought after that, confusion. We'd watch something that's a little bit about judges. Judge Bev is not in here, but she should be here maybe. It's unbelievable. How can you not, though? There's obvious bullshit going on. Yeah, absolutely. Lots of bullshit. I mean, it seems like there's a lot of bullshit in your state as well, me Josie, but more from the prosecutors than from judges. Ugh. Right. People love judges, and we're going to see more judges from Massachusetts. But let's take it out from Massachusetts for a second and watch this. Top moments when judges lose their temper. I'd be honest with you, I would not want to be that judge, because whatever he does, he's fucked. From what I understand, and I don't understand much because, you have to be close to it. You have to probably be one of the attorneys, because we don't really know what the paragraphs were they were discussing and stuff like that. Is the right thing to do is probably dismiss it. Dismiss these cases. But I can't see him doing that, so... Anyway, I just thought, let's chill for a little bit, for like 40 minutes. Let's just chill. Is bitch ass Schroeder? I don't know. We'll see. Seriously, Josie. We'll see. So these are like judges from various cases, how they lose their shit and stuff like that. So I just thought it'd be something lighthearted to watch for a little bit as we build up to the hearing this afternoon. So I don't know what judges there are on this. I don't know. So, oh, fuck, wrong way. I'm yawning. That's never a good sign when I'm yawning. Don't you get brazen with me, Josie. It's me, Josie. Right, that's the Schroeder line. Right, let me get this down here. Nothing. I was saying this. This is about 40 minutes or so. I know I got Dunkin'. No, actually, I don't have Dunkin' in this. I need to buy some Dunkin'. I need to buy more Dunkins in for this. Right, here we go.
For what are debunked, frivolous, sovereign arguments. And they want to say that they're not happy about it.
I mean, she is hot. She is hot. This judge, she's hot.
What is the problem?
And the stranger was the one that actually shot you, not Mr. Barrison. That's the same situation.
And that you had contact with her on the 20th. There was some physical.
Contact with her on the 20th.
Mr. Brooks, this is my time. You need to not interrupt.
That's the reason why the charge was dropped.
Mr. Brooks,
the state
you need to stop.
Specifically wrote you, Your Honor, and said that they know it was no incident that day.
Mr.
And
Brooks,
now you want to sit up here.
Do not interrupt me, or you will be removed to the other
courtroom. And now you want to sit up here.
Stop.
And try to add something in that you know for a fact never even happened. You want to sit up here and talk about who has grace and all this. You talking about someone with 5 kids that don't have custody.
You need to stop right now, or you will be removed.
Remove me then.
All right. He will be removed. He cannot simply stay quiet when this court talks.
I never saw Brooks. I've never seen this before. Never seen it or watched it.
Anyway, I don't consent to this. Just like I told you, I don't know the.
We'll be in recess until he's
I don't
moved
even
to the other
understand
courtroom.
the true nature and cause.
Implicit adoption of what he was saying. This improper arguments. According to court should.
Okay, but what you are doing right now is highlighting something and making more of a spectacle. So if your office in general does not want to facilitate and or incite violence, then we need to just sit down and move on. That's it. There were 18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, you know, we're moving on.
But is the court going to do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil.
What the fuck is that? That's an attorney. Hang on. What happened here? So an attorney stuck a finger up at the judge. What the fuck? Hang on.
Upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking. Ms. McNeil, be quiet.
Oh.
When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. It's being
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that.
Here we go.
And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not a motion.
Excuse me. I did. I granted.
We did not move
That
to
was
reconsider.
their motion.
We have not filed
forgive
any
me.
motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you without any advance notice to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect.
I'm not going to rehash the motion. Yeah, that's absolutely untrue. No. Your arguments of record, my comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time. You should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor.
So, Robin G, this is Aaron's man. Hang on. Aaron Hack loves this guy. Loves him. These are great attorneys.
There have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities, Wigmore and evidence, Judge Weinstein, Colonel McCormick. It's the crime, the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense, that's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
That's not a subpoena. The subpoena is when you actually get the subpoena paperwork by mail.
Yeah, that judge, you are right, Wicked. He did have an injury, and I think he went downhill from that.
Or I don't.
Mr. Brooks, you need to ask a question.
Can I get to it, Your Honor?
No, because you're trying to define something, which would be testifying, which you cannot do at this time. So the jury will disregard his last comment, but go ahead and ask a question of this witness.
You something else. Wow.
Mr. Brooks, that was inappropriate.
The fuck? Let's hear what he said.
Go ahead and ask a question of this witness.
You something else.
You suck something else.
Wow.
Mr. Brooks, that was inappropriate. Do you have any other questions for this witness? Please ask them. would like to get through one more witness, but I want to take a short comfort break for everyone. So I'll rise for the jury. Thank you.
That is Darrell Brooks, Space 11. So this is Darrell Brooks. He represented himself. I've never watched the trial, but it's spicy, I think.
Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks,
telling them the truth.
stop. I'm putting you on notice that you are on the verge of this court creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
that is why
prove it.
your questions
Prove it.
are being
Prove that it's
objected
frivolous.
to,
Prove
and
that
why
it's frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back
And
in
prove
5
it.
minutes. Thank you, everyone.
I don't agree to an estoppel. Can you prove
away from the jury? How anybody in their right mind could listen to these proceedings this morning and report that, much less Elizabeth Williams in the New York Times, why they have her covering this case when she
I
wrote
don't
it.
want to
No,
go
no,
down.
Judge, I
No,
wanna-
Attorney Pattis, I
May
don't,
I
I
please be
just,
heard?
no.
No, may I be heard?
No,
Because I'll do it on the
no.
courthouse steps under
You-
3.6B
then
if I want,
suggest
if I
you-
have to.
Attorney Pattis, I have made it so clear that when I'm speaking, you have to stop speaking. You've got to you just can't push it like that. You are welcome to leave this courthouse. In fact, you're welcome, I suppose you could stay in the courtroom and say whatever you want, but when I'm on the bench and I tell you to stop speaking, you need to stop. I'm going to say this again. I don't know how I'm not making myself clear, and maybe it's my fault. I do not want to sanction an attorney. I do not want to fine an attorney. I have gone almost 2 decades as a judge and never had to do that. And I don't want to do it now. But if we have a continued problem where you're talking over me, I don't know what else to do. I've asked you, and I say I'm literally almost begging you. I have no recourse but to do that. So I'm not asking for your response, but you are certainly welcome to say whatever you would like to say when we're not on the record in the courtroom. That's your right to do so. And I know that you will abide the rules of professional conduct along those lines. I want to just get back and say this. I am responsible for what happens on the record in this courthouse, in this courtroom, and I am not responsible for any other issues. So I don't want to respond to that or go down and address any such statements. My concern was that there were safety issues, or that there were statements made to the families, the plaintiffs, or to Attorney Maddie, given that we had the issue earlier. But I am so happy that that is not the case. So I think we can move on from this issue. And I think hopefully you will use your powers of persuasion and we won't have any further issues where Mr. Jones is suggesting that the jury not follow their oath, frankly. So can we please move to the earlier filing about the curative clarifying charge?
May I be heard just under Phillips v. Ward?
I don't think so, Attorney Pattis. I'm not giving you the opportunity. It's not a give and take here. I've said what I've said, and I think that is all I'm going to do on the topic. So are you prepared?
I'm begging you for an opportunity.
No, not at this, Attorney Pattis, no, I'm sorry. Do you want to be heard on your, the curative charge now?
I have one more issue to raise with regard to the press conference, Your Honor.
Well, I'm not giving Attorney Pattis any further opportunity to address it. I think there's nothing at this point that I need to do. If you disagree, I encourage either or both of you to file something in the file.
No one was jumping up when they were referring to the defense children. No one jumped up to try to tap down that rhetoric. That is the rhetoric that I'm talking about. That is what I'm trying to be very clear on. Jeff, Marcus, the state, they can hide behind their arguments, but we all are witnessing what is occurring in this courtroom.
Which is myself. I'm a judge,
And
I understand that I'm in
Thank you,
charge
Judge.
of the decorum. And I feel that 99% or a great percentage of what has been said has been appropriate. Everybody has maintained decorum, but for a few comments, it's best to just move on as opposed to highlight them.
This is true, Judge, but I am witnessing a building of momentum, and I'm encouraging the court to direct the state to tap down on that momentum so it does not reoccur and it does not become a theme. Thank you, Judge.
Your Honor, for the record, the only thing the state has said to any of these witnesses when they get up is, would they like to say something on behalf of the victim they're representing? There's been no encouragement.
Whoa. Hang on. Is this not the attorney for Ashley Benefield? The ballerina? Hang on. Is this not him?
Or inciting a victim they're representing is, would they like?
Yeah, it's him. This is Ashley Benefield's attorney, the ballerina. If it's not him, then he's somebody just like him. There he is. I'd never seen him before, and I just noticed him now.
Say something on behalf of the victim they're representing. There's been no encouraging or inciting, as Mr. Weeks has put on this record. That is a blatant falsehood and a recreation of the record. As far as no objections being made, it's the defense that could have objected. It's not the state's duty to object to their own witnesses when they're testifying.
Okay. Listen, I've already heard. If you have anything else to say, you can put it in writing at a later time. I've heard from both sides more than once. That's going to be it. I've made my decision. Like I said, 99% of what's been testified to has been appropriate. I do not.
Yes, that's a Black Swan one, Robin G. And this judge is gorgeous. Absolutely gorgeous. Like literally absolutely gorgeous.
I want to highlight the few things that were said that were perhaps not appropriate, and let's move on.
Judge, I'm asking for 20 seconds back.
You can have as many seconds as you want in writing, and you can put all of your objections in writing. They've been made multiple times from your chief assistant, from Ms. McNeil, and I don't want to hear anything else. I've already heard it. Is there something that has not already been argued?
Yes, ma'am.
Okay, exactly what is it?
Judge, before Mr. Schachter took the podium and testified before this court, I wanted to reflect that both Mr. Marcus and Mr. Satz looked at the statement prior to the reading. And so their implicit adoption of what he was saying, of this improper arguments, in the court should chastise.
Okay, but what you are doing right now is highlighting something and making more of a spectacle. So if your office in general does not want to facilitate and or incite violence, then we need to just sit down and move on. That's it. There were 18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, you know, we're moving on.
But is the court going to do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, What is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper and speaking to
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper, and for this court to allow that kind of testimony is also improper.
I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it.
Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender.
Okay, I'm going to the back. I messing with her. I mean, woo. I mean, she's feisty.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when their children...
She brought up her children multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down. Sit down.
Judge.
Sit down, Mr. Weeks.
Please do not summarily dismiss me.
I'm summarily dismissing
I'm asking
you.
the
Go
court.
sit down.
I'm asking the court. I asked the court to go sidebar.
Go sit down. You don't threaten the
Judge,
court's children.
everyone
Your
in this
assistant just
courtroom-
did that. Go sit down.
No one in this courtroom had to endure what we had to
Go
endure.
sit down. Miss McNeil has made her children a spectacle more than once during this trial. That was her choice. You have absolutely no right to have one of your assistants come up here and suggest something about my children. Now, please go sit down.
Judge.
You're inappropriate and out of line.
So this case is from Florida. This case is if you remember, the Nicholas something. He shot a high school shooter, Nicholas. I don't remember his surname. Basically, he's the reason that the death penalty is changed in Florida. So during this time, you needed 10 from 12 jurors to agree to death penalty to get the death penalty. And I think it was like 8 or 9 that agreed to the death penalty in this trial, and that's why they changed it to 8 out of 12. I mean, I'll be honest with you, she's way over the top here. She's like, whoa, uncontrollable, but she's still damn fucking sexy. I mean, she's really beautiful, even though she is completely lost it, but still, yeah.
Go sit down.
Judge, may I have a brief recess?
No. Go sit down.
May I have a brief recess so I can speak to my attorneys?
We're moving on with the sentencing, Mr. Weeks.
So I can have a brief recess?
No.
Thank you.
It's 1:36. Thank you.
You know it, J-Man. You know it.
What's the nature of your objection, Mr. Shellhorn?
Judge, I think there was a question there suggesting that the attack, the dog bite, and I think there was something else was going on before any shots were fired.
I don't even know what I don't even know what the factual basis is for that.
Judge, I can ask a witness.
No, you can't. No, you can't. Not without a factual basis. You just can't ask for speculation. That's what you're asking for.
I'm asking you a question whether or not.
There's no evidence that it happened before. None.
Judge,
not a scintilla of evidence on the record so far that supports that question.
If a witness says that something happened, I can't ask them if
you've asked them 500 questions about what happened, about her recollection of it, which is fine. Now you're asking, well, are you sure it didn't happen before? You have no basis to ask that.
Her recollection is horrible.
No, it's not.
She's changed her story over and over.
It doesn't matter. It doesn't, Mr. Belinkus, it does not allow you to suggest to this jury to engage in speculation, which is what you're doing. Your client doesn't remember the incident, according to the expert reports. So that's not a factual basis for you. And there's nothing in this record to suggest that any of this happened, the beating, the phone, the dog bite, before. In fact, we have a 911 call where it's patently obvious that the dog is in the area because it is incessantly barking and heard over the 911 call, which is after the shooting. So you need a factual basis. That is black letter law 101.
My factual basis, Judge, is that these people, both Cataract and Goodwin, have a motive to lie with regards to what happened.
Hey, Mike, hang on. These are mixtures of trials. I don't know which trial this one is, but shout out to you, Mike. I did give you a shout out earlier on. We did use your video from earlier on from yesterday's hearing. So much love to you, Mike. Hope you're doing well, bro, my friend. And everyone, all the young jerks are good as well. But yeah, I don't know. These are mixtures of trials. They're fucking... Ooh, they are psychotic, a lot of these. But it's all about judges losing their shit, basically. Essentially. So that's what it is. But yeah, shout out to you, Mike. I mean, everyone here is subscribed to you anyway. But, just want to show you the love. And thanks again for allowing us to use your content from yesterday. Anyway, here we go. Hey, Heather, how are you, my darling? Nice to see you. Hope you're doing well. I love the Davis, I'm used to the IES because that's where I am, DAVIES. But still, I'll take it. Hope you're doing well, my darling. Right, let's go back. Do you know what? This particular trial, I don't know. I do not know which one this one is. I bet it did. I bet it did.
They filed a lawsuit. There's hostility.
But again, even assuming all that's true.
So why?
There's no evidence. No, but there's no evidence in the record. That's like saying, well, isn't it true that a stranger drove down the road when Michael Barrasone was there and got out of his car, and the stranger was the one that actually shot you, not Mr. Barrasone? That's the same situation. There's no evidence in the record that happened. You're just you're trying to create in the jury's mind some alternate issue without any facts in the record to support it. Now, if Mr. Barrasone were going to testify about something, that's different. But the experts have said he doesn't remember anything about the incident.
Understood, Judge, but again, whatever ruling you make, obviously, I abide by. But in this particular case, this witness's testimony, as well as her boyfriend, which are basically the only two pieces of evidence.
No, and the 911 call,
okay,
which lays out exactly what happened immediately after the shooting.
Immediately after the shooting, and I believe I can question the timing of the shooting based on their inconsistent statement, their motivation to lie.
No, you're not going to, not to create some alternate universe scenario without something in the record.
I can't get anything in the record, Judge, unless I could ask these questions.
No, there's plenty in the record so far. There's plenty in the record so far, but nothing in the record to show that the beating, the dog bite, and everything happened before the shooting.
Oh, Mr. Goodwin is going to testify, Judge. The Mrs. Cataract disappeared for a significant period.
All right, well then ask him that. Ask him that question.
It's implausible for someone to be shot.
Mr. Blinkus, I can't predict what's going to go on the record in the future when other witnesses testify. If the scenario changes, then you can ask it then. At this point in time, there's nothing in the record to suggest the scenario that you want to ask in a question for the jurors. There's not.
Judge, okay.
That's my ruling. End of it. All right. I'll go off the record now because you have to.
Speculative.
Overruled as to both. The witness may answer.
Yes.
And you had torn ligaments?
Objection leading.
Overruled.
You say that in the question before?
Yes.
And were those both in the same leg?
Objection, leading.
Sorry,
Yes.
overruled. If we
Yeah, of course.
just wait when there's an objection. I'm overruling it. It's relevant.
I thought that was Brooks because he was just speaking about the judge. You listen to him, you can hear him. So, oh yeah, sure, judge. Yeah, sure.
It's not leading. The witness's answers may stand.
I mean, yeah, you overrule every objection.
And the jury will disregard the additional commentary made by Mr. Brooks at this time.
Judicial misconduct at its finest.
And which leg was that, sir?
Objection, action, answer.
Overruled. You may answer.
Voy a contestar la pregunta. El pie izquierdo. My left leg.
Did you have to have surgery on that leg?
Objection, leading.
Overruled.
Anulada. Sí. Yes.
Let's see what y'all.
Just one?
Nada más una cirugía.
Trying to get.
Dos. Two.
That's not gonna work either.
Mr. Brooks, you are advised to stop with the commentary.
No, I'm gonna say what I want.
You called this witness. I'm going to take a break right now and excuse the jury and this witness.
All right.
Oh my days! How did I not watch this trial? Darrell Brooks. I didn't realize he was this bad. He commentates on everything. He just speaks over the judge. What?
What you're doing is judicial misconduct. Judicial misconduct. But you don't want the jury to hear the truth. That's not fair to the jury. They have a right to hear everything. I'm not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
Mr. Brooks, please stop.
No, there ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are being
please, nothing.
disrespectful.
You always
The
gonna
witness
find
may
some
step
reason to
down.
say somebody's being disruptive because they want the truth to be out there. Man, quit it. You're supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be
Okay,
present
and
in this
Under
courtroom
what law and
during
fact can you do that?
Illinois versus Allen.
Okay,
sir.
but the fourth option that you made up, that's not even in the law?
Mr.
Because
Brooks,
you can't do that.
I need to make a
By law, you
ruling.
can't do
I
that.
need to
And
make
you
a
know you
finding.
can't.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom. He will continue in the neighboring courtroom. Please make sure he has his objection signed and a pad of paper.
So is that
he can.
So is that holding me in
meaningfully
contempt?
participate, and I will make a ruling when I.
So are you holding me in contempt? Is that civil or criminal?
Hey, Compo.
Now have a chance and a right to come in here and say what they're allowed to say and what they're legally allowed to say. What the defense is doing is illegal to try and curtail these victims' rights under the law, and it's unconscionable. These victims have a right to express themselves. I have not gone over what their statements are because under the law, under Chapter 960, they don't have to tell me what they're going to say. They can ask me if they need guidance, and I will provide it to them. But they have a right to address this court. Thank you, Your Honor.
All right, State, you can go ahead and call your next witness.
I just need to say that the defense is not attempting to curtail the limits of the sentencing proceeding or the rights that the victim's families have. We are not trying to do that. But the state attorney's office knows that what is happening here is beyond what this victim's families are constitutionally protected to do. You can say whatever you want to Mr. Cruz. You can attack him and say whatever you want. But your honor knows that what is happening here is not permissible.
Ms. McNeil, stop suggesting that I know that something is impermissible and that I am allowing it to happen. You're finished. I've heard your objection. It's noted. State, go ahead and call Ms. Ramsey. Oh, why are you standing there?
To help me.
Okay, who's questioning this witness? Hello, which witness? Your next witness.
These don't have anything to do with it.
Yeah, we're just entering them.
These are just records. We're just doing it now.
So is it a secret who's going to be questioning your next witness? Because I'm going to find out in like 3 minutes. Who was doing it?
If the records don't relate, but if we call the witness, it will be me. I'm assuming you're talking about that.
Who is your next witness and when are they being called and which attorney is going to question them? Let me be clear if I wasn't before. Because if these don't have anything to do with your next witness, then why are we having the jury wait outside right now?
Just because we were trying to move everything in because in terms of timing, we do it now.
In terms of timing, it would be much better to do it during the lunch break when the jury needs longer than you all. So we'll go ahead and pass on this. Let's bring the jury in, please.
Your Honor?
Yes?
At this time, the defense rests, other than putting in our records.
We're not playing chess.
What? That was bizarre, though. You called in a witness, and then you decide to rest. So they're playing games then. No wonder the fucking judge is a psycho. I would be a psycho as well if they're playing games like that.
I mean, will you please take the jury back in? Thank you. All right, go ahead and bring your records.
2B, Nicholas Cruz Henderson, episode 1 record.
Let me just stop. State, are you going to have anything ready for today?
No. We're accepting.
There was 80 witnesses.
We're waiting for 40 more witnesses.
I just want to say this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision until this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly, I have never experienced a level of unprofessionalism in my career. It's unbelievable.
So Judge, if we had any pretrial matters, you asked us to be here at 9:15. We were here at 9:15 to discuss pretrial matters. I have been practicing in this county for 20 years.
You know what, I don't want to hear it, I don't want to hear
Well,
it.
Judge, you're insulting me on the record in front of my client, and I believe that I should be able to.
Okay, you can do that later, you can make your record later, but you've been insulting me the entire trial. So blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So quite frankly, this has been long overdue. So please be seated, you can receive the evidence, I will receive the evidence, and then you can put whatever you want on the record at the end. Go ahead.
2B, which is Nicholas Cruz Henderson records, episode 1.
I'm sorry?
Episode 1, Henderson records for Nicholas Cruz.
2B?
I'm sorry, 2B is it.
Is there any objection to 2B as in Victor?
I'm sorry, what was that again, please?
I can't read. Oh, Henderson Behavioral Health, episode 1.
That's fine.
Without objection, 2B will be received as 93.
2W, Henderson.
Referencing State's Exhibit 190. Captain Chapman, do you notice blood marks here in the water?
Objection, Your Honor.
The objection is sustained.
Did you observe blood marks in the water when you were there that evening?
Calling for speculation.
Right.
He is calling for speculation as to what discoloration in the water, if there is any, is caused by.
I'll lay more of a foundation, Your Honor. Captain Chapman, were you familiar with the scene as this picture depicts?
Yes.
Did you personally view what this picture depicts?
I did.
Are you familiar with the discoloration, and did you observe the discoloration in this photograph on two different areas?
I did see that.
Was that discoloration, in your opinion, consistent?
Objection. He's not been qualified to give an opinion about this matter.
I didn't hear the complete question.
In your estimation, and
Your Honor, objection, and if he's going to pursue this frivolous line of questioning, I'd ask the jury be excused. No evidence whatsoever.
Objection is overruled. Let's pose the question.
In your experience and observation, having observed the scene and all the matter that was there, were those lines in the water consistent with blood?
Objection.
Objection sustained.
Thank you.
I don't need to be thanked for any ruling.
No, I'm sorry, Your Honor. Expressing my gratitude is improper. I appreciate that.
Thank you, Your Honor. And I'll have just one last question on, and I understand the court's ruling. Captain Chapman, are the substance there that you identified as having observed, are they in a straight line? Are they in straight lines?
Yes.
Your Honor, I'd like to make a motion to strike his questions about blood from the record, and the jury be instructed to disregard those questions.
I've informed the jury that they're to disregard any question.
I don't, Wikisite, but just a reminder, there might be a retrial for Murdoch on this one. There might be a retrial. Also, J-Mac, I'm winding you up, by the way, J-Mac, you know that.
Question when I sustained the objection. They were previously instructed on that.
Yes, sir. Thanks.
Yes. Yes.
No further questions, Your Honor.
Any further
No, Your Honor.
cross-examination? Thank you, sir. You may step down. If you'll turn the lights up, please.
Jury can come on out.
Oh, fuck,
Civil
you
matters?
go.
No.
I was told to pay for something under a civil statute.
Mr. Brooks, I am not the custodian. Bring it up with the clerk of court.
How
I'm
can I
not
bring
addressing
it up
it.
with the clerk of court? How am I supposed to do that? So that makes me wonder if it's a
Mr.
civil
Brooks,
case.
the jury's coming out. I'm not
If
going to
it's-
address your request
if
for
it's
open
civil-
records.
if it's
That's,
civil,
I'm not
then
the custodian of the records,
who's
sir.
being sued? My Sesame Trust is being sued? Civil is a
Mr.
civil
Brooks, this
matter.
is an irrelevant matter that you're attempting to bring up in the presence
If it
of the
was-
jury. The
I
record
was
should
not. I was
reflect
trying to
these
bring it up
interruptions.
before the jury came out, Your Honor.
And I told you I wasn't going to address it. Please.
Okay, so it's a civil matter. Who's being sued? My Sesame Trust? Because how can I be?
Mr. Brooks, you're talking about an irrelevant matter between you and the
It
clerk
wasn't,
of court.
it wasn't irrelevant
So-
when I got the paperwork from the clerk of courts. I was simply
Mr.
trying
Brooks,
to address it.
I'm not going to address it. The jury will
So I'm
disregard
being
these
sued?
irrelevant
This is a civil
comments.
matter? We haven't addressed subject
All right,
matter
thank you,
jurisdiction yet at all either?
everyone. Please be seated. The jury
So
will
we're not gonna
disregard the
address subject
statements
matter?
Mr. Brooks is making about subject matter jurisdiction. They are a misstatement of the law.
Yes, no,
All right,
they're not.
and
Just like this is a civil case.
Mr. Brooks, the jury's here. Please
Just like
show
this is a civil
respect
case.
and decorum.
According to this document, this is a
Mr.
civil
Brooks,
case,
please stop.
which means someone is being sued. Civil is a suit.
Mr. Brooks, you're talking about an irrelevant
I have
matter.
the
I'm
paperwork
starting
sent
the
by the
trial.
paper course right here that says it's a civil matter.
Mr. Brooks
So
has
what's
nothing
being
to
sued?
do with
My
this
Sesame
case.
Trust is being sued.
I have no idea what you're talking about. So,
I got the paperwork right here.
all right, I'm
How
going
do
to
you not
excuse
know
the
what I'm
jury
talking
right
about?
now, given this disruption. I'll rise for the jury.
This should be properly addressed before the jury even comes out. That's why I tried to properly address it before we even went on the record.
Mr. Brooks, stop.
I'm not gonna, this is,
You are not
I
being
was given
respectful
this
to this
paperwork by you, Your
proceeding
Honor.
or to
With all
this
respect.
jury. No, it's not with all due respect.
with all due
Stating that doesn't
respect,
make it
I was given
respectful.
this paperwork by you.
Mr.
from
Brooks,
Monica Paz.
stop talking
the
till the
clerk of
jury
court.
is out.
Okay,
Thank you.
so why couldn't we address this before they came out?
I'm
That
not
was the
going to
time-
address it,
That was
bottom
the time
line.
to address it, though. We're supposed to do all the addressings before the jury comes out, before we start the matter.
Please
I was
be
trying to
seated.
simply address paperwork that was given to me by you, Your Honor. That states that
Mr.
this-
Brooks,
it states that
you have
this is a
interrupted
civil
me
matter.
repeatedly. You are on the verge of being removed to that courtroom. I don't want to
On-
do
on
that.
what-
I want you to stay here.
On what
But
fact of the
you
law, Your
keep
Honor?
interrupting me and bringing up irrelevant matters. I told you yesterday, as a courtesy that was provided to you, so that you would frankly not complain that you didn't get it as quickly as possible. Okay, I am not the custodian of the records. If you have an issue with what was provided to you, how it was provided to you, then take it up with the clerk of
She
court.
can't
But
charge
from now on, I am not going to be the messenger and give you documents that you request to the custodian of the records or from the custodian of the records. They will simply have to be delivered to you at the jail. But that is in response to your discussion or whatever we want to call it this morning. I'm not taking it up. All right. It is irrelevant.
It needed to be noted for the record.
It doesn't
Because
need
it
to be
was-
noted, sir.
You
All right.
gave
The
it to
jury's
me-
coming
you gave
back
it to
out,
me
and I'm
open
going
court.
to warn you, if you bring this up again, I will pause and I will remove you to the next courtroom for being disrespectful, for being interruptive, for being disruptive, and for bringing up irrelevant matters in front of this jury. You will forfeit your right to be present for the direct examination of this witness.
I object to that.
Did you
Your Honor.
hear what I said,
No,
sir?
I did not. I object to that, Your Honor.
Well, you can
And-
object, and your objection is noted, but if you
For the
interrupt
record-
when this jury
for
comes
the
out,
record-
they will go, I will have them taken out again, and you will be removed to the next
For the-
courtroom.
You can't, what is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the
And-
other cases that
and it
I've
doesn't
cited
say
previously.
anything-
I'll make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt.
That's a
Yesterday,
mischaracterization
sit
of the
down.
record.
Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 15 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't
And-
verified by proof any of what I
And
said,
none of
Your
that
Honor.
is required, sir.
Because it
And
is. You can't verify.
your
it.
belief
Where's
that
the
that's the
subject matter?
law
Where's the subject matter
doesn't make it
jurisdiction?
so, Mr. Brooks. Your belief that these are legitimate legal positions
They are.
doesn't change the law and doesn't make it so.
It's
So,
clearly
again,
relevant because you didn't want to.
I'm going to step off and give Mr. Brooks 5 minutes to cool off. And when that
I don't
happens,
need
I'm
to
bringing
cool
the
off.
jury
I'm not
out,
angry at all.
and then we will
I just wanted
continue.
to. I don't.
State believes that all exhibits should go back. Again, I understand the court has concerns over the still image. I understand that might be in a little bit of a different category, but in terms of question number 5, and while I have the floor, I'll just go through what they are. The FBI aerial with all person of interest marked, that would appear to be the defense exhibit that they neglected to mark and has now been accepted. The state also has one, which is Exhibit 25, which has Mr. Rittenhouse and Mr. Rosenbaum marked, but not the Zeminskis. So I assume they mean the defense exhibit, but we could send both back or have them come down and view it, however we do that. The drone video is 73. That's the full unedited exhibit that's been in evidence now for over a week. The zoomed in still image, we all have talked about that and beating that horse to death, so I'm going to skip that for now. Then the full event video in regular and slow motion, that seems to be the drone video, as that is the only video of incident 1 that was played in slow motion, just as the only video of incident 2 in slow motion was Dr. Black's. So their expert video was submitted. Our expert video is, I believe this is actually 6 videos that they're asking for, which is the drone video. It's spliced out. So it shows the first third of the incident, the second third, and then up until the end of the shooting. And it's in regular and slow motion. And that's exhibits 581, 582, 583. I'm sorry, S81, S82, S83, S84, S85, and S86. And we believe that the jury should have full access to them. They should have full access in this room. And that's our position. I do not believe a technical reality, shall we say, or an unknown technical incident should result in a mistrial.
How would we object? How would we object to something we didn't know existed until it was over?
I didn't find that point particularly persuasive. But anyway,
It's impossible. So it's impossible for us to do that. And if everybody in this room that's a lawyer has been a prosecutor. Your job is fairness and being a truth seeker. It's not debatable that it's not fair what happened. We can sit here all day and say it's been played. We didn't know. How is that reasonable?
Well, I persistently warned the state that, there's a day of reckoning with respect to these things. My feeling is I had my qualms and I decided, well, I'll let the jury hear it. I think I made the comparison the other day of the breathalyzer, where the officer doesn't have to be familiar with how the operation, how the breathalyzer does the analysis. But that's a device that has been sanctioned by the courts, and I just don't think we're at that place with this, and particularly if they've got evidence. I didn't see that in your motion about the manual.
We've learned it since I filed the motion.
Well, if they've got the manual, I don't know. It may be. I forewarned you. You've pressed with this, and that's fine. I've let it in, and my view on it now is where we are. We might as well follow through with it. And if they've got everything correct and it's reliable, then they won't have a problem. If it isn't, it's going to be ugly. All right.
Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters at your deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right? Remember the court's admonitions, ladies and gentlemen.
Is this is the YSL one? I think. So Boston Lisa, this is just a combination of lots of different states with different judges all losing their tempers, basically. So.
All right, please be seated. Our jury has left us. All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to this honorable court's attention? 1. And 2, how do we just violate court orders? So yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I'll admit it is next court exhibit in order of the state's presentation anyway. So, all right. So that'll be court 1 for purposes of the trial. So, Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Don't represent Mr. Ryan.
Mr. Blaylock, then.
Excuse me. I would never said this ever. That's it.
So what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before this honorable court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
Brought up to this honorable court, outside the presence of everybody. We're an opening statement. I am lied to. I am saying that. I am lied to. Or if anyone else got that exhibit, I did not get that exhibit. And I see everyone say shaking no. And now it goes against the court's word. We are bound, duty bound to follow some of the court's order.
I'm going to join in the objection on behalf of Mr. Steele.
Let me see the.
I can put it back up,
Yes,
Judge.
ma'am.
And Your Honor, while I am putting that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that, I ruled upon that last week. I did. That we were not, I would take it as it came in this case. And if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
and Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have
all right.
The slide.
Well, now court one for purposes of the motion for mistrial. All right. Okay, on slide 11 of 65, that I see where you have that at the bottom, represented by Brian Steele. So we can leave that for the time being. Leave it for the time being because it is what was it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time. So,
Your Honor, I'm not supposed to ask for a re-occurrence report for my mistrial before the next process goes on. I'd like you to do me a courtesy, if you would, and allow me to do that now and preserve the motion for mistrial.
You've made your motion for mistrial, and the basis. And I'm going to mark the whole state's presentation as court one for the purpose of your motion, and it will go in as stated.
And I have two other issues I'd like the court to just take up. One is just remember, I know you ruled on it, but the state said earlier today.
All right, Ms. Love.
Yeah. Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at
I'm going
trial.
to deny that portion. But to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it, and also subject to foundation, just like this. So I assume that what you told our jurors is what you expect the evidence to show. Yes.
Yes,
All right,
definitely.
so I'm gonna overrule that part of his objection. What about the last thing you mentioned?
She drives a bus, yellow bus, yellow bus. Erin Hatchie drives a bus all day long. So, Scott, I've messaged you with a link on Messenger. If you can't access it, let me know and I can maybe message it to Timmer or something and he can text it to you or something. But yeah, I've send you the link. So hopefully when Scott gets there about 1 o'clock or something, he'll jump on and we'll get some action from outside the courthouse of Aidan's hearing. We believe that the hearing might be rescheduled to 3 o'clock instead of 2. As Scott says, one of the ADAs may be delayed. But we'll be outside the courthouse with Scotty. Thank you, Scott, for doing this. Unexpected, but thank you, my friend. No worries, Hack. You be.
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name on
I got
here.
that, but he's talking about, is there anything else you're going to use in open you haven't shown to defense counsel? He's telling us, well, I said that. I told you to do that a week ago.
Your Honor,
because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Ms. D. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, Ingram, can you find out if our jurors are ready?
Are they with them?
Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor, we have a few. Your Honor, Jay Apt on behalf of Mr. Kendrick. Can we have 5 or 10 minutes to review whatever Ms. Love is going to send us?
You can take a comfort break, and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch. Okay?
Thank you, Your Honor.
Who's talking?
Max Sharp.
Yes, Mr. Sharp.
On behalf of Mr. Stillwell. We've been operating pretrial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial. And if Your Honor...
I'll apply the Harvey rule unless you tell me otherwise.
Okay. There you go. So just so you know, so Aidan's hearing probably will be around 3 o'clock. Thank you to Scott McGuinness, who said he'll jump on to show outside the court. But until then, I'm just going to jump around a little bit. The Brian Walshe stuff we covered super quick this morning. I didn't really think that we would. Right. I'm enjoying these ones. Right, this one. I'll do it another day. I promise you I will, Lady Di, do it another day. I have no interest in YSL, so that's why I will play it, though, another day. I promise you. Right, this one is 6 of the funniest moments in high-profile cases. So I'll cover this one. 6 of the funniest moments in high-profile cases. I'm interested in this one to see.
You poured yourself a mega pint of red wine, correct?
A mega pint.
I'm winging it, Your Honor.
You smoked before you came here today?
I did not.
I should have.
Sometimes you just can't help but laugh at absurd moments in court. From attorneys to defendants to witnesses and even jurors, you just never know what someone is going to do or say. Here are just a few examples of the law's lighter moments. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Now, a little bit of a recap here. So Depp had sued his ex-wife, Amber Heard, an actress, for defamation after she wrote an op-ed piece for the Washington Post claiming that she was a domestic abuse survivor. Depp argued that although he wasn't named in the article per se, the op-ed was clearly about him. He said that the false claims damaged his reputation, it cost him acting roles that would have furthered his career, and Heard ended up countersuing Johnny Depp for statements that was brutally honest.
You are a pretty big fan of Johnny Depp, aren't you?
I am not. To be honest.
Or when a witness gave a very blunt response.
And Mr. Depp was trying to urinate in the foyer, wasn't he?
No.
Mr. Depp had his penis out of his
Objection.
pants, didn't he?
I think I would remember. Relevance. Mr. Depp penis.
I'll allow. Next question.
Or when a witness that used to work at the front desk of a building.
This was one of my favorite witnesses in that trial. This was one of the favorite witnesses. This is amazing. So chill.
Building where Depp and Heard lived actually drove in his car and vaped during his videotape deposition testimony. Never saw anything like that one before. And I'll tell you, his comments were pretty funny.
But in fact, you don't recall seeing Amber Heard on May 24th, correct?
I don't remember. I don't even remember what I got for breakfast. They come down. They say, somebody tried to get into my unit. There's scratches on my door. And like, I'm really sorry, but who will think is going to get into your unit because it saw some scratches on the door, like, 4 inches above the door? Because the dog was scratching the door, was trying to get in, and they thought about someone trying to break into the unit.
But during the trial, it seems that some of the more memorable comical moments came from when Johnny Depp took the stand. And that's the moment that we want to focus on. Because his back and forth, particularly with Heard's defense attorney when he was being cross-examined, it brought out the laughter, including these wisecracks that were so quick, you really have to pay attention to what Johnny Depp was saying. Take a listen to a combination of some of this back and forth.
And you may have been drunk in that video, correct?
There's a possibility of that, yes, sir.
You poured yourself a mega pint of red wine, correct?
A mega pint.
Yeah.
I poured myself a large glass of wine.
Right.
I thought it necessary. I once gave Marilyn Manson a pill so that he would stop talking so much. Yes, it's a stack of hit pieces.
Yes, the first one is called
by Ms. Heard's publicity team.
Mr. Depp, we're going to try to get through this as quickly as possible. And the next article is an article from May 7th, 2016. It's entitled Johnny Depp, Friends and Family Seriously Concerned About Him. Here's Why.
Yes, correct? How did they know?
The next article, May 25th, 2017, a year and a half before the op-ed was published. An article entitled, Where Did It All Go Wrong for Johnny Depp? After a string of flops and a ton of bad press, Johnny Depp's star power looks as wobbly as Jack Sparrow on a plank. Did I read that right?
You read that very, very well.
The next one, Hollywood Reporter, May 27th, 2017. Headline, Pirates of the Caribbean, The Diminishing Returns of Johnny Depp. Did I read that right?
You certainly did. Hollywood Reporter were very nice to me. He asked her what she would like for him to cook. That's hearsay, I guess.
Go ahead. I know if the sheriff's offered for the truth of the matter asserted.
He got it.
Okay, all right, well then.
I'm learning.
I gotta say, it was pretty entertaining. And I don't know, it seems like the jurors, they liked Depp on the stand because all comical moments aside, this was a trial about abuse. And in the end, jurors in Virginia agreed with Depp that Heard's abuse claims were false and defamatory, although they did believe that one of Waldman's comments made on Johnny Depp's behalf was defamatory against Amber Heard. So the jury awarded Depp more than $10 million in damages, but also $2 million for Amber Heard.
You know, we've all probably had a night out where we had one too many drinks and woke up the next morning feeling awful.
A separate courtroom several times during the course of the trial so that he wouldn't interrupt court proceedings. He could still monitor what was going on. And, you know, more shenanigans ensued, with Brooks sometimes taking off his shirt, building a fort out of evidence boxes, waving his arms.
Shut up.
So he could be seen on camera, refusing to wear the headphones so he could hear what was going on. Just incredible. Just incredible. Brooks, I should tell you, also identified as a sovereign citizen, meaning he doesn't acknowledge regular U.S. law as something that he's governed by. And several times he objected to even being called Darrell Brooks or Mr. Brooks. So with all that in mind, here's a sampling of some of his more ridiculous moments.
I'm winging it, Your Honor. Respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state.
I don't see the relevance to this.
Your objection is noted, it's overruled.
Are you a party to this matter in any way?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained, it's not relevant.
Do you have a claim in this matter?
Objection,
Grounds.
Sustained.
Have you read the complaint in this matter?
Objection.
Grounds.
Not relevant, sustained.
Objection, I do not consent to being called that name, nor do I know any individual by that name, Your Honor. Objection, hearsay, and speculative.
It's neither one of those things.
Can we address the subject matter jurisdiction before the juror comes out? The jury comes out?
We've already done that.
And is that a judicial determination that you're making not to address the subject matter jurisdiction, which has yet to be proven at this point? It has not been
Mr.
verified.
Brooks, please, the jury's coming out.
Come on now. We got to cut that out. You know you have to prove subject matter jurisdiction. You know that.
I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one.
Mr.
I got one
Brooks.
ear that work, and I heard that.
This
Come on, man.
Yeah, shocker. His legal arguments weren't that great. And it also didn't help that you had photographic and video proof that he was the driver of the car. And also eyewitnesses too. Literally people on the stand saying, yeah, I saw him driving the red SUV. Well, with all of his antics aside, Darrell Brooks was convicted on all 76 charges, including 6 counts of first-degree intentional homicide. He was handed down 6 life sentences in prison plus 700 years, becoming young rappers on trial for double murder. Jamel Demons goes by the stage name YNW Melly. Police believe Melly shot and killed 2 of his best friends inside of an SUV in 2018 as they were leaving a recording studio. I'm talking about fellow YNW group rappers Christopher Thomas Jr., or YNW Juvie, and Anthony Williams, or YNW Sack Chaser. Investigators allege that Melly and another friend then staged the shooting to look like a drive-by. And one of the things that prosecutors wanted to do was hear from other people who were at the recording studio that very night to try to pinpoint any issues, any conflict between Melly and Juvie and Sack Chaser, as well as maybe any problems in Melly's alibi, namely that he wasn't in the car when the shooting went down. And an important witness was Travion Glass, because he testified that Melly changed his clothes from the time before the killings to when he saw him afterwards. Very suspicious there. So at one point, Glass was being questioned under cross-examination by Melly's attorney, and clearly they wanted to establish, is he a reliable witness? But during his cross, Glass made a comment at the end of his testimony that definitely lightened the mood a bit, in what, of course, was a very serious case.
So you smoke a lot of marijuana, right? Possibly. Well, you smoke it anytime you get a chance, I think is how you phrase it.
It's your ex. Yeah.
That was your ex.
I smoke when I smoke.
You smoke when you smoke?
Yeah.
And when's that?
When I smoke.
And when was that?
When I smoke.
You didn't see any friction exuded that night of any magnitude?
I did.
You did?
I didn't.
Okay, you did. Anyways, with respect to your daily marijuana regimen, did you smoke before you came here today?
I did not.
Okay. I have no. Thank you.
I should
I wonder if a lot of people thought, I can't blame them. Not easy facing cross-examination. Maybe that would help a little bit. Look, it was an interesting case to file, and it had an even more interesting verdict because the jury couldn't come to a unanimous decision on the double murder charges. So a mistrial was declared by the court, and a new trial for YNW Melly has been scheduled for October 2023. Okay, as we recap some of the funniest moments that we have seen in our trials, moving right along to the trial of the now infamous Alec Murdaugh. The once prominent South Carolina lawyer was accused of shooting to death his wife Maggie and son Paul at their country estate back in 2021. Now, toward the end of this very lengthy trial, before the jury got the case, the judge ended up dismissing a juror. And there were reports that this juror might have had conversations about the case outside of the courthouse. Not allowed, clearly not allowed. So to be on the safe side, Judge Clifton Newman let her go, replaced her with an alternate juror. Now, she's not identified or on camera in the clip that we're about to play, but just listen carefully to the very interesting item that she brought to court with her.
And in fairness to all the parties involved, we're going to replace you with one of the other jurors. Have you brought everything that you have outside of, you left some stuff in there? What do you have in there?
A dozen eggs.
Say it again?
A dozen eggs.
A dozen eggs?
Yeah, one of the other one of the other jurors brought in eggs for everybody.
Oh,
So
okay.
the eggs in my purse, they got water.
All right, well, you're gonna leave the eggs? You wanna leave the eggs or take the eggs? You're gonna take the eggs. So, Mr. Bailiff, can you retrieve from the jury room her dozen eggs, her purse, and what else? And a bottle of water. You can get those things from the jury room. So they're gonna get your things, and then and once you're removed from the jury, you can't go back in the jury room. We'll have to tell them goodbye for you. Okay, all right. Well, thank you very much. Ed, you can go. Thank you. We get a lot of interesting things, but now a dozen eggs. It's certainly pretty interesting.
Hey, jury service is a tough business. Maybe she thought she'd get hungry. Maybe cook up some eggs in the jury room for everybody during deliberations. That would be nice. I am thinking, though, don't you have to refrigerate eggs? Yeah, that's a bit concerning now that I'm thinking about it. Anyway, not easy being a juror. Not easy being dismissed after hearing all this evidence. And really not an easy case to hear. Really sad when you think about what happened here. And in the end, the jury that did stay on, the jury that did deliberate, they found Alec Murdaugh guilty of the murders of his wife and son. All right. Sometimes it's the courtroom demonstrations that bring the levity to a trial. Let's go to California, where Robert Durst was at the center of one of the most complicated crime stories in years. So in 2021, he went on trial for the murder of his friend Susan Berman, who was found shot to death in her home back in 2000. Prosecutors allege that Robert Durst, the real estate heir, killed Berman so she wouldn't speak with police about what she perhaps knew regarding the disappearance of Durst's first wife, Kathy Durst, who went missing in the 1980s. Not to mention that at one point in Durst's life, he shot and killed his neighbor Morris Black when he lived out in Texas. Durst actually went to trial back in the day for the murder of Black. He was acquitted of the murder, argued he acted in self-defense, but Durst pled guilty to tampering with evidence for chopping his body up. Yeah, stay with me because I know it's kind of hard to find humor in a case like this, but during his criminal trial in 2021, again for the murder of Susan Berman, a very frail and sick and wheelchair-bound Durst sat on the witness stand as his attorneys reenacted what Durst says happened between him and Morris Black inside that home. And in a moment of what is really dark humor, Durst's attorneys ended up on the floor during their reenactment, and the courtroom just erupted into laughter.
What happens next?
Don't move the
The gun went off. What?
The gun went off.
Where was you and where was Morris Black when the gun went off?
Lying on the floor of the kitchen.
So you fell backwards? Oh,
Mr. Chesnoff has done his best Hollywood falling back. Like still grasping the gun, finger on the trigger.
In Galveston, I could get down.
And we'll stipulate that Mr. DeGuerin got down with him. Then he won't actually have to do it.
Where's the television camera?
This is my favorite part of the whole trial so far.
I don't know who to root for here.
All right, Mr. Lewin, why don't you describe it? I can't see it.
So we've got Mr. DeGuerin playing Mr. Black. No, Bob. I'm sorry, Bob is on the right side, and they are both. Well, I describe it. Okay. I'm not sure that I want to.
I'm glad you have a mask on.
All right, so we're both on the floor. My left elbow's on the floor. My right hand's on the gun. Your right hand, or Bob Durst's right hand is on the gun, on the top of the gun. Morris Black has got his finger on the trigger. Is this when the gun goes off? Bob?
Yes.
Can we add that at the time the gun is going off, both Mr. Durst and Mr. Black are flat on the floor?
That's what was being reenacted.
And would also be directly behind where Mr. Black was sitting.
Okay, that's what they reenacted.
No, it's in the doorway. I've got plenty of help.
Definitely a lighter moment. And when the judge asked Durst if the reenactment by his attorneys was accurate, Durst said, "They are a full-service law firm." That is certainly true. Like I said, a moment of comedy in a very twisted and sad case. And in the end, the jury convicted Robert Durst of the murder of Susan Berman, and Durst died in prison shortly after. Well, we're going to finish up our conversation with Alex Jones. That's right. The InfoWars founder and host faced some huge lawsuits from families of victims of the Sandy Hook Elementary School shooting, as well as an FBI agent. You see, Jones repeatedly claimed on his broadcast that the shooting was fake, that it was staged, that it was a hoax, that the parents were crisis actors. So he was sued for various claims, including defamation. And Jones lost both lawsuits out in Texas and Connecticut through default judgments, meaning he refused to participate in court-ordered discovery during the case. You know, how each side is supposed to hand over the other side evidence? Well, Alex Jones, according to the court, really didn't do that. That's a big no-no. So the judges entered orders that he automatically lost these lawsuits. So now it was a question for the juries in Connecticut and Texas. How much would Alex Jones owe the plaintiffs in damages? How much would he have to pay up? What would his punishment be for losing? Now I will tell you, again, very sad cases when you think about what happened here, right? But with Alex Jones in these courtrooms, there was a fair share of ridiculous moments in court. Like when the judge out in Texas, the Honorable Maya Gamble, said he needed to spit out his gum, or was it gum?
Spit your gum out, Mr. Jones.
It's not gum.
What is it? Because you're not allowed food or gum of any kind in the courtroom.
I had my tooth pulled a week and a half ago, and I had some gauze in there earlier, and it's been causing me to have some pain.
So you're chewing on your gauze?
Would you like me to show you?
No, I
Right
just
here?
want you to answer my question.
No, I was massaging the hole in my mouth with my tongue. I'll show you right here.
I don't want to see
All right.
the inside of your mouth.
Oh, no, there's no gum. Hole.
Sit down.
You can't make this stuff up. I do want to highlight, though, one particularly light moment. I do have to give you a little bit of context here. So Norm Pattis, who was Alex Jones's attorney out in Connecticut, He was quite loud and vocal during the course of that trial. And Judge Barbara Bellis, who is the judge overseeing this case, she would get into these screaming matches with him, telling him not to interrupt and to quiet down.
He's not an expert, and so what one does isn't what we're
But
here to
that's-
show. We're here to show what he did.
Right, but
And the
that's a
purpose
different,
is being
no,
offered
Attorney
in
Pattis,
the same
Attorney
line.
Pattis, Attorney Pattis. How many times do I have to say when I'm speaking, you stop? I'm not gonna have the comments anymore. I'm not gonna have it. I'm not gonna have it.
Do you expect me to lay silently when they're directed at me, but inappropriately? Do you expect me to roll over for my client? It's not gonna happen.
Okay, now with that in mind, Jones himself got on the stand, but he had trouble hearing Pattis's objections as he was being questioned by the plaintiff's attorney. So Judge Bellis ends up making requests that she never thought she would.
After Bill Oldenburg and after Judge Bellis, who's next, Mr. Jones? Objection.
I mean, I guess if somebody's on national TV, I'm sorry.
Again, no, Mr. Thomas. Again, no, we're objecting. And I sustained it's 2-1, and you still answered.
Okay, I'm not hearing him.
Can you be louder? I never thought I would say this, Attorney Pattis.
Yes, Judge, I can be louder. How's that?
A little secret is I have serious hearing damage.
Okay, so.
And I need to get a hearing aid soon, so.
So your client cannot hear. So.
Sorry, seriously, I can't hear you anymore.
Yeah, the Jones trial's full of characters. And thanks to different lawsuits against Alex Jones, he's now been ordered to pay more than $1 billion for spreading lies and bizarre theories about what was a very real and serious and deadly tragedy. You know, looking back, you have to.
Okay, well, I don't like. Well, I mean, Jesse's fine, but sometimes just too much. Right, I think Scott's going to go live about 1:30. I think 1:30 ish. So we'll play. These are quite funny, so that's why I like to play these. This is one of the most heated courtroom moments of all time. So watch this bad boy whilst we wait for the Turtleboy hearing, which is now, I believe, scheduled for 3:00 and not 2:00. So, but these are funny to go through, right? So these are all around the country. So there's not just one. These are like everywhere in America.
I agree with the family. I hope you die in prison as well.
You better hope I never get out of jail. Your wife.
Hi, Coco.
Your wife is getting.
Shame on you, girl.
That is enough.
I don't know.
That is enough, Mr. Deputy.
You know what? I've had enough. You cut her throat twice. You stabbed her 8 times. You cold-blooded fucking killer.
Okay, I think this is going to be fucking wild. Yes, this is going to be wild. There might be some words and some swearing, but fuck it, let's go.
We start off with Quincy Tuttle. Who's charged with firearm theft and unlawful possession of a weapon on school premises in Vancouver, Washington. Tuttle was taken into custody at Frontier Middle School when his friends saw a handgun, 400 rounds of ammunition, and kitchen knives in his backpack. Allegedly, Tuttle had plans to kill another student who had bullied his friend for being gay. In court, Tuttle hopes the judge would let him stay home during the trial process.
Is someone at home to monitor him? I'm home all day. You're home all day? Okay. And as far as any issues regarding firearms or any firearms in the home at this time? No. Okay. Any other dangerous weapons that are in the home? So, that being said, Your Honor, I'd ask the court to possibly consider releasing the parents.
The parents promised to look after him, but the judge wasn't buying it.
I have concerns about the mental health issues, the ideation, the anger. I've been told this morning that now there's locks on the front door and back door, but as of yesterday, they were non-operational. So I feel that at this point, he needs to be held in order to protect him from himself and also the community. So that's going to be my decision today.
But when a kid with anger issues doesn't get what he wants, things get dangerous. At first, it was just tears.
Since you've got the problem, right? What are we going to do next? What are we going to do next? Come on. Don't fight me on this. Let's go.
But things quickly escalated. Quincy exploded.
Different, let's go there.
Get the up.
He yanked his shirt out of the attorney's grasp and bolted toward the doors. In the end, Quincy was sentenced to 2 years in juvie, as well as mandatory anger management classes. Quincy might have let out a few curse words, but what happens when someone's foul rant is so bad it causes a delay in court?
You pussy. You pussy. You pussy. You started it in this. You pussy. And he do not tell you pussy. Fuck what?
Like in the case of de jure Maurice Hall, who's facing charges for possession of a weapon by a convicted felon and attempted murder in Orangeburg, South Carolina. Hall was arrested after going on a shooting spree where he fired shots into both a crowded nightclub and then later a home with children inside. Hall was handcuffed and brought to court to decide his bond, but before the judge could begin, Hall exploded.
Man, get me out of the car, man. I don't even want to be here for this shit, man. This nigga's pussy. He don't stare at me, boy. You pussy. You pussy. You pussy.
Hall spewed curse words so nasty that the other guards had to step in.
You started it in this. You pussy. And he do not tell you pussy. Fuck what? Fuck what?
Hall showed no signs of stopping, so the guards had to take action.
Man, I don't give a fuck about none of that. Fuck what? It ain't over with. You pussy, what?
Hall refused to calm down, even as he was dragged out of court.
You pussy, you started it, pussy. You pussy. You pussy. You got to go on me, pussy. You fuck not up, what? What?
But if you thought that would be the end of it, think again.
All right, let's bring them. Let's bring your victims back. We're not going to deny there, right?
Hall walked back into court with a smile on his face, but that smile wouldn't stay for very long. Because of Hall's mouth and his criminal record, the judge temporarily denied his bond.
Mr. Hall, based on what I'm hearing, and seemingly there's going to be some other stuff that's coming on, I do feel that this court should defer your bond to be set over in General Sessions Court as opposed to me setting it today, which means that you will be going before the General Session judge in order for that judge to set your bond. You understand me?
Yes, sir.
This particular day, time we're going to deny the bond on Mr. Hall.
The judge denied bond because of Hall's dirty mouth, but how does that compare to a defendant who flips tables and screams like a madman?
Stop taking me off like that! If my mom and my doctors knew what you guys were doing to me, I have a broken hand!
Like in the case of Zachariah Kraft, who's charged with assaulting peace officers in Belgrade, Montana. Kraft was already in court for disorderly conduct in an unrelated case. However, when the judge laid out Kraft's charges, things didn't go over well.
I don't understand why I'm getting charged with a felony. I've been doing my best.
As the judge explained his charges, Kraft suddenly erupted.
You took me on my bed!
It's a yes or no question, all right?
Stop taking me off like that! If my mom and my doctors knew what you guys were doing to me, I have a broken hand!
Officers grabbed Kraft and wrestled him to the ground.
Stop. I have a broken hand!
Well, if he has a broken hand, he's got even more broken hand now after that.
Then Kraft was carried out of the room. According to Lieutenant Jared, a supervisor at the jail, Kraft's outburst was quickly dealt with.
He's been placed in an isolated holding cell where he's not going to get anybody else in trouble, and we can keep a close eye on him and make sure he doesn't harm himself.
Kraft's outburst was violent but harmless. But how can that compare to a defendant who begs for the death penalty?
You need to be careful. Do you understand?
Well, he did that. That's what's happening anyway. He's framed.
All right.
That's the way it is. Justice will be served.
Like in the case of Jonathan Sander, who's facing 3 counts of homicide in Raleigh, North Carolina. Sander was arrested when a neighborly dispute led him to kill his neighbor. His neighbor's wife and her mother. During the interrogation, Sanders' voice was chillingly calm.
It just went blank, and the last thing I remember was seeing Sandy laying on the floor.
In court, Sanders showed even less remorse.
Yeah, with no blood under it.
Mr. Sander, please be quiet.
It's fact.
Mr. Sander, Mr. Sander.
What were her last words?
What everybody else did that's watching this.
What?
No blood under that wound.
Sander was so disruptive that even the judge was sick of him.
Mr. Sander, please be.
This is my life involved. I was frank.
Remove him from the courtroom, please.
Remove me from the courtroom.
Hey, stop it!
Hey, yeah.
His actions were even more heartless, considering the only surviving family member was in the audience watching him.
My wife, once she got shot, she said 3 words. 3 words. Oh my God. Nothing. She vanished.
Salvatore Mazzea could barely give his testimony.
I saw him with a gun point at my wife, and I tried to go back in the dining room to get something heavy to hit him over the head, but I didn't have a chance.
And Sanders' repeated outbursts made things even more difficult.
Laundry room?
Yes.
And
You're telling me I blasted through the laundry room door
Mr.
5
Sander,
times,
get him out of
and
here.
you sat
Get him out of
there
here.
with your
Get him out of
face
here.
Mr.
Sander, Mr. Sander, Mr. Sander.
Sanders claimed he only shot 1 bullet. He blamed the 3 deaths on Salvatore Mazzea himself.
When I did shoot Sandy, I shot him low on his stomach 1 time. That's the one with the bullets that made the black marks. I barely wounded him, and I left. After I left, Sal Mazzella shot and killed his family. Why? For insurance money.
There was only one time Sanders showed emotion in court, and it was this.
Hey, Dad, I really, really love you. I also miss you. I miss you every day. I remember when we used to buy Hot Wheels and watch SpongeBob. If you were never to come back, I will be so sad. I will cry every day.
Sanders' wife came to court and read him letters from their 3 young children.
The family and cats miss you. I hope you get out of jail soon. Love, your best friend. I'm sorry.
But shockingly, Sanders wanted to set his own sentence.
You need to be careful. Do you understand?
Put me to death. That's what's happening anyway. It's framed.
All right.
That's the way it is. And justice will be served.
He asked the judge for the death penalty. Then, the moment he was waiting for.
We, the jury, by unanimous verdict, find the defendant, John Frederick Sander, to be guilty of first-degree murder of Sandy Mazzella.
The judge did not grant Sanders' request. Instead, he sentenced him to life in prison.
And when you take your last breath, you're going to die alone, and you're going to die forgotten.
Sanders' theory that Mazzea killed his own family was too ridiculous to entertain. But what happens when the defendant calls their judge every ugly name under the sun?
who is this bitch in Cynthia Cuba? Tell me.
I think you allegedly tried to hit with the pliers.
Like in the case of Sherry Lynn, who's facing charges for felony battery and violently resisting arrest in Miami, Florida. Lynn was arrested after beating and or stabbing a woman named Cynthia Cuba with a pair of pliers. In court, things start off with a bang.
But have you ever been treated for any mental health issues?
Why don't you fuck yourself first?
Another judge might have found that offensive, but Judge Grazier let out a chuckle.
I'm sorry, ma'am.
I said, go fuck yourself.
Okay, well, I'm a little busy right now.
But soon enough, she gets down to business.
And I'm ordering that you stay away from Cynthia Cuba. Do not have any contact with her, and you must stay away from her home and place of business. As to the other case...
Who is this bitch Cynthia Cuba? Tell me!
I think you allegedly tried to hit with the pliers.
Apparently, that doesn't ring a bell.
The other case, F15-1426.
I literally you'd think this is like Jen McCabe or something like that. Do you know what I mean? The way she fucking acts. Her face reminds me of Jen McCabe. No bullshit, like just the way she acts and the scowl and stuff. Fucking Jen McCabe. Great response. I'm just a bit too busy right now. All right, Jen, pipe the fuck down.
It's $5,000.
Despite the verbal onslaught, Judge Grazier ignores her, and Lynn's lawyer makes an executive decision.
$5,000 and chapter 3 is $1,000. Have a nice day, ma'am. We'll try and get you into the hospital.
The judge sent Lynn to a psychiatric hospital to undergo evaluation before trial. Lynn's verbal attacks might have been unexpected, but how can that compare to a TikTok star who takes his murderous mafia boss online persona into the real world? Like in the case of Ali Abulaban, who's charged with 2 counts of first-degree murder in San Diego, California. Abulaban went viral on TikTok for role-playing movie characters.
Speak English when you talk to me, okay? That was English. I'll have a venti, caramel, dolce. What the f*** you talking about? A venti. What is that? A large?
But on October 21st, 2021, Abulaban entered his apartment to find a horrifying scene.
Yes, ma'am. My wife and another man were, I found them dead on the couch.
Then he suddenly got hysterical.
Okay, stand by.
No, my wife, please don't.
Okay, hold on, sir.
Please don't. Sorry.
Tell me what you saw when you went in there.
I saw my wife on the couch. Put my wife on her head.
Wife is on her?
I don't know who he is. I know him. He's been great.
Ray? Okay, look. Your wife was shot in the face. Is that what you said?
Yeah, on the forehead. He had 2 or 3 bullets in the head.
He claimed his wife, Anna, had been shot to death alongside another man in their apartment. But when police got there, Abulaban was gone. The bodies of Anna, Abulaban, and their mutual friend Ray were found on the couch. Abulaban claimed he stumbled upon the crime scene after coming home from work. But little did he know, their neighbor's Ring camera recorded the entire thing. Through investigation, police discovered that Anna had filed for divorce due to Abulaban's controlling nature. Spiraling, Abulaban broke into his wife's apartment, installed audio recording spyware onto his daughter's tablet, and kept tabs on his wife through the tablet. When he heard another man's voice in her apartment, he snapped. After the crime, Abulaban called his mom in tears. Abulaban, who fled the crime scene after calling 911, was caught speeding down the highway. When police pulled him over, his 5-year-old daughter was found in the back seat next to a handgun. While in jail awaiting trial, Abulaban blamed Anna for his failed marriage.
My wife brought us. She wanted me to move her out here with all her friends to a life where there's Taco Tuesday, Women Wednesday, Party Saturday, Bar Sunday.
In court, however, Anna's best friend...
Oh my god, what a douchebag. What a fucking douchebag.
...and exposed the true Ali Abulaban.
He just always had to be better than everybody else in the room. He spoke down to a lot of us. It actually kind of made me distance myself toward the end because I just couldn't stand being around him. He made everybody in the room feel uncomfortable.
Then the court heard audio messages that left viewers disgusted.
We never had a kid together because of how stupid you are. And I can't wait to divorce you. You're going to be sitting on the couch, drinking your tequila, sitting next to your gym rat boyfriend with tattoos who doesn't have the brain to hold a conversation. And you're going to watch Netflix one day and you're going to see my face on Netflix. Hey, isn't that your husband? And your daughter is my so you're going to see my face for the rest of your life.
Despite his tears, Abulaban could not convince the jury he was innocent, especially not when he does this.
I'm not going to tolerate this.
During cross-examination, Abulaban could barely contain his anger.
You were looking up trash cans because
you wanted to hide some bodies, correct?
I'm sorry. You're out of your mind.
You were also researching teen porn videos, correct?
What? What did you just say?
That's what you were researching, correct?
Say it again?
Teen videos.
You're out your mind.
On October 19th, you were researching Sean Torres, correct?
Show me the teen you just said. You want to paint me some kind of child molester? Show me what you just said. I've never seen that in the Discovery. I've been incarcerated 3 years. You never showed that to my team. Where did you get that?
It's in your phone.
Do it. Show it.
Obviously, his conviction wasn't enough to convince the jury.
We, the jury in the above entitled cause, find the defendant, Ali Nasser Abulaban, guilty of the crime of murder in the first degree.
Abulaban couldn't believe his ears, but he's not out of the woods yet. Watch Abulaban's reaction as he finally learns his sentence.
The bottom line here is he will die in prison. He will never be a free man. He will take his last breath there. Please.
Abulaban's strange courtroom behavior didn't earn him any sympathy points from the jury. But what happens when a defendant gets into a fist fight with the courtroom security guards? Like in the case of Anthony Matthews, who's in court facing traffic violation charges in Dayton, Ohio. Matthews, representing himself, constantly interrupted the judge during proceedings.
I did not care to take part in fraud, not at all.
When the judge threatened to hold Matthews in contempt of court, things got violent. Matthews got into a fight with the deputies, and soon he started throwing punches. A team of 5 deputies got Matthews under control, but not without some injuries. The next day in court, Matthew appeared with a swollen eye, but he had a surprising change of heart.
Yesterday's proceeding was in error on my behalf. Totally, I take full blame for my actions.
Because of Matthews' sincere apology, the judge mercifully sentenced him to probation and time served. Exchanging punches with the guards is one thing, but what happens when a defendant leaps over the podium to attack their judge?
This is one hell of a leap. Is it? I think this was in Vegas, I think, if I remember correctly.
In accordance with the laws of the state of Nevada, this court.
Like in the case of Deobra Redden, who's facing battery charges in Las Vegas, Nevada. Arrested after picking a fight with police officers, Redden tried to convince the judge to let him go.
So basically, I would like to tell the courts here, like, based on my history, like, I feel that, like, I shouldn't be, like, sent to prison for a second time.
Redden truly expected to walk free, but Judge Holthus had other ideas.
Have you looked at your criminal history? Have you looked at your criminal history?
Actually, just I looked at it.
I mean, you lived it, I suppose.
I just looked at it,
Yeah.
This is the moment Redden learned his sentence.
I appreciate that, but I think it's time that he gets a taste of something else because I just can't with that history. In accordance with the laws of the state of Nevada, this court.
Let's rewind.
I appreciate that, but I think it's time that he gets a taste of something else because I just can't with that history.
After that, it takes a moment for her words to settle in. But once it does, Redden explodes. Redden leapt over the podium, dragged Judge Holthus to the ground, and continued beating her, even as court employees rushed to her aid. Finally, they pulled Redden off the judge, but it took more than that to subdue him. Redden punched the employees, and the employees punched back. Meanwhile, Judge Holthus is still on the ground. Clearly shaken by the attack, the judge is barely able to stand. Thankfully, she wasn't seriously injured. But that's not the last she would see of Redden. The next time Redden appeared in court, he was in a spit mask, handcuffs, and boxing gloves. Surprisingly, Judge Holthus stayed on the case, and she was about to announce Redden's sentence.
All right, that being said, in accordance with the laws of the state of Nevada, this court does now sentence 19 to 48 months in the Nevada Department of Corrections.
Redden got up to 4 years for the original crime. As for his attack, that sentence has yet to be released. Redden's actions may seem shockingly violent, but how can that compare to a defendant who left his victims in a pool of their own blood? Like in the case of Bampumim Teixeira, who's charged with home invasion, kidnapping, armed robbery, and 2 counts of first-degree murder in Boston, Massachusetts. On May 5th, anesthesiologist Lena Bolanos walked into her Boston penthouse, unaware that she and her fiancé...
I've never heard of this before. I've not heard about this case from Boston, Massachusetts. I imagine some of you have heard of it before. I haven't.
...say were being stalked.
Tonight, 2 doctors murdered inside a luxury South Boston penthouse identified. 49-year-old Dr. Richard Field and 38-year-old Lena Bolanos, both anesthesiologists. They were killed last night.
Friends of the victims called police after receiving text messages saying, "Call 911, gunman in house," and other worrying statements. Police got there quickly, so quickly that they caught the murderer still at the crime scene.
The officers encountered that intruder, turned out to be Teixeira, in a darkened interior hallway. The officers believed that this assailant either pointed or fired a weapon at them in this dark hallway.
Officers returned fire, shooting Teixeira in the hand, abdomen, and leg before handcuffing him and taking him to the hospital. Barely conscious in his hospital bed, Teixeira was formally charged with the murders.
Count 1, charge of murder, with the alleged victim being Richard Field. Count 2, the crime of murder, the alleged victim being Lena Bolanos.
In court, though, he displayed more of an aggravated demeanor.
You better hope I never get out of jail. Because if I go, your wife is getting.
If that wasn't bad enough, Teixeira then did this.
You want to know his last words? Be quiet. He said no. Be quiet. You would have died in the hallway or die inside. And he get him out of here. Get him out of here.
Teixeira was forcibly removed from the courtroom. Meanwhile, the victim's family members broke down. For family's protection, the judge refused to allow Teixeira back inside the courtroom for the sentencing hearing. This is his reaction to learning his sentence.
Offense 001, charging murder in the first degree. The court, in consideration of this offense, orders you committed to the Massachusetts Correctional Institution at Cedar Junction for and during the term of natural life without the possibility of parole.
Teixeira will serve a double life sentence for his crimes. Teixeira's lawyer tried in vain to keep Teixeira from ruining his own case. But how does that compare to a prosecutor who does their job so badly that the judge has to step in?
I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that.
Like in the case of Kyle Rittenhouse, who's charged with 5 counts of homicide in Kenosha, Wisconsin. In 2020, 17-year-old Kyle Rittenhouse joined a racial justice protest in Kenosha, Wisconsin, armed with an assault rifle. Rittenhouse claimed he intended to be a medic and brought the rifle for self-defense only. However, he quickly realized he was out of his depth and ran toward police to escape the fight. Then he claims protesters followed him, threatening to get him. That's when he fired the gun. Now in court, Rittenhouse is facing charges for killing 2 protesters and wounding 1 more. His attorney painted a perfect picture of self-defense.
It wasn't until you pointed your gun at him that he fired, right?
Correct.
However, the prosecution had a bit more trouble.
Pardon me?
That was before the
Don't get brazen with me.
The prosecuting attorney tried to use Rittenhouse's silence against him, a direct violation of his Fifth Amendment right.
I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that.
But instead of admitting his mistake, he insisted the judge was the one in the wrong.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you. I want,
May I respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay.
Well, I said you were over the line, close to, or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Even the defense attorney was fed up.
He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
But eventually, the jury came back with their verdict.
The defendant will rise, face the jury, and hearken to its verdicts.
We, the jury, find the defendant, Kyle H. Rittenhouse, not guilty.
Members of the jury, are these your unanimous verdicts? Is there anyone who does not agree with the verdicts as read? Would you wish the jury polled?
Rittenhouse almost fainted with relief when he heard his sentence. But how does that compare to a defendant whose sentence fills him with murderous rage?
The bruises, some of the bruises were in the shape of a belt buckle.
I ain't gonna let you sit here and say no crazy shit about me, man.
Like in the case of Elise Ortiz Nieves, who's facing charges for felony murder and first-degree child abuse in Grand Rapids, Michigan. On June 13th, 2017, Ortiz was babysitting his girlfriend's 7 children when he realized one of them, 4-year-old Giovanni, wasn't breathing.
Kent County Sheriff's Department says that he was watching 7 kids this morning who live here at this house on Green Meadow Street Southeast. Deputies received a call about a 4-year-old who was not breathing.
He was rushed to the hospital where he later died from blunt force trauma. At the hospital, doctors found evidence of child abuse, 2 broken ribs, cigarette burns, and bruises in various stages of healing. In court, Ortiz came face to face with the cold, hard truth.
You beat this child, you brutalized this child, and you tortured this child.
However, Ortiz maintained his innocence.
I'm going to continue to say I will take a lie detector test to prove that I never abused any of Sonia's kids or never abused Giovanni and never intentionally meant to hurt Giovanni but to help him.
The judge didn't believe him.
There is no question whatsoever that you committed this murder and that you beat this little boy to death.
Man, I ain't gonna let you sit here and say no crazy shit about me, man. No, man, because he's saying he don't even know, man.
Sir, the testimony showed that you put this child and other child in a shower with ice cold water.
The judge tried to maintain order, but Ortiz was out for blood. It took 3 deputies, but Ortiz was eventually overpowered. After that, the judge called him back to hear his sentence.
You are the lowest form of human life that I've been able to observe or see. You are a monster, and quite frankly, you are evil. What you did was sickening and disgusting. We're done. Take him to prison, please.
Ortiz was sentenced to life without parole. In a twist of fate, Giovanni's mother was also arrested for failure to protect her children from Ortiz's abuse and for lying on the stand about the lack of violence in the home.
My first charge is perjury. I lied under oath for a man who I thought loved and cared for me. And I have to live with the fact that I failed my children. I wanted to apologize to my family, my children, my lawyer, and the court.
She seemed remorseful.
Madeline Soto's mother. This should be the same for Madeline Soto, who died at the hands of her boyfriend. Her mother should also be put in prison for not protecting young Madeline. Her abuse went on for like 6-7 years. So if you know the case, you'll know what I'm talking about. And that poor girl had so much abuse for 6-7 years, and the mother turned a blind eye. So that mother should also be in prison. Fucking pieces of shit.
But that all changed once she was actually put in jail.
And everybody knows me as a person, knows I'm a great parent, so I don't care about what anybody has to say. They're just trying to make an example out of me.
Are you a good mother?
Of course. I work 3 jobs to support my children with no assistance.
She will serve 5 to 10 years in prison. These evil parents' courtroom behavior was despicable. But what happens when a defendant calls their judge a slur?
Here, once you get it, we'll get it fixed. Is there something that you wish to say to me?
No, it's my brother.
Like in the case of Adam Satterley, who's facing drug charges in Louisville, Kentucky. Satterley was in court again after breaking the conditions of his bond. Then Judge Stevens revoked his bond, prompting this outburst.
Taking into consideration the cost of $5,000, 10%. You have a bond returned to you. I've signed this order here. Once you get it, then we'll get it fixed.
Judge Stevens immediately called Satterley back in.
Is there something that you wish to say to me?
No, it's my brother.
Oh, was that to your brother? Because
Yes,
I
sir.
heard you say a racial epithet.
No, I didn't mean it like that.
Oh, you didn't mean it like
No.
that? Well, I'll tell you what. I'm going to hold you in contempt of court for having said that. And you don't speak those words in here.
Yes,
and
sir.
that word particularly,
Yes,
you
sir.
don't use that word. I'm going to give you 60 days for having used that word. I'm holding you in contempt right now for having done it in this courtroom. It's disrespectful. Don't ever do it again.
Judge Stevens sentenced Satterley to 60 days for contempt. After spending his first night in jail, Satterley seemed to have a change of heart.
I apologize. It wasn't intended for you. I was mad at my brother, that's all it was.
All right. Well, you can have a seat.
But would the judge accept his apology?
I don't know how it could be directed at your brother, but at any rate, I accept your apology. I'm going to credit your time served at this point, and you will be returned to your previous bond, $5,000, 10%.
The judge dropped the contempt charge and placed him on a new bond, $500. Satterley barely avoided a prison sentence. But how does that compare to a wife killer who taunts his victim's family in court?
Shame on you, Cheryl. That is enough. I don't know. That is enough, Mr. Deputy.
You caught her throat twice. You stabbed her 8 times. You cold-blooded fucking killer.
Like in the case of William Demby Jr., who's charged with felonious assault and murder in Columbia Station, Ohio. On August 11th, 2011, prison guard William Demby called 911.
Yeah, I killed her.
You killed her?
Yeah.
Who did you
No, I
kill?
sent somebody. 14900 Cowley.
Who did you kill, Demby?
My wife.
Demby claimed that he came home from work, got into a dispute with his wife, and stabbed her with a military-grade knife. She fell through a second-story window while attempting to escape. Then, Demby went to the backyard, where she fell and continued stabbing her.
Hey, yo, wife at 14900 Cowley Road.
They got a fight?
You know, like almost a yeah. Me? Yeah, I killed her.
Police officers arrived to find his wife's body nude in the backyard. Debbie was arrested at the scene. In court, Debbie claimed his wife Holly and mother-in-law Cheryl were emotionally abusive.
Shame on you, Cheryl. That is enough. I don't know. That is enough,
Mr. Deputy, once again, you speak to me about your relationship, if you wish, between you and Holly Denby. I'm not interested in your position with regard to her members of her family.
Despite this warning, Denby continued on.
I had no right doing what I did. Obviously, I wasn't thinking. I was in a place where I had no control over my actions. I can't explain it. I can't understand how and why I did what I did. I may never know. But one thing I do know, that Stewie's well-being should be the #1 priority. But it isn't.
Out of nowhere, Holly's family exploded.
But I've had enough. You cut her throat twice. You stabbed her 8 times. You cold-blooded fucking killer. Fuck! I've had enough of her fault.
Despite the commotion, Denby was unfazed. In the end, the judge sentenced Denby to a total of 20 years to life. Denby incited anger with just his words. But what happens when a defendant takes on 5 security guards at once? Like in the case of Adrian Dunn, who's facing murder charges in San Antonio, Texas. On July 16, 2012, Dunn fatally shot 23-year-old Rakeem Charles during a drug deal gone wrong. Now in court, Dunn is facing a harsh sentence.
There will never be somebody like her son who has to suffer, and this family who has to suffer because of the defendant. And that's why we're asking you for a life sentence.
Dunn was shocked at the request, but that's nothing compared to his reaction to learning his sentence. The judge sentenced Dunn to life in prison. Dunn, in disbelief, refused to accept the verdict. He fought with deputies, pleading for his freedom, but it was no use.
Come on, man, y'all.
Dunn exploded after getting an unexpectedly harsh sentence. But how does that compare to a defendant who says he's too handsome to be on trial?
A young gentleman like me, young, charismatic, and fetching in these county blues, why would I be subjected to competency hearing or to evaluation when I'm clearly cognate?
Like in the case of Jimmy Carter Kim, who's charged with kidnapping, sexual exploitation of children, and possession of child pornography in Las Vegas. In November of 2015, Kim spotted a 15-year-old walking to her friend's house. He pulled up to her in a white van, kidnapped her, and held her hostage in his house. He gave her a bucket, barely any food, and had a camera recording her at all times. After a month of starvation and sexual abuse, she escaped to a nearby gas station and called the police. In court, Kim's lawyer tried to test him for insanity, but Kim refused to talk with doctors.
Dr. Faglini was unable to make a determination because the defendant refused to participate. Motion?
Once he realized his mistake, however, he tried backpedaling.
Pardon me?
Can I have a say in this?
Well, I tried to give you a say, but you refused to talk to the doctor.
Because I don't see what the relevance of me, why is my competency in question?
Because your lawyer challenged your competency or questioned it.
My lawyer is going against my will. He's going against my choices. He's not notifying me or informing me of any of these things.
Fed up with Kim's excuses, the judge laid things bare.
But Nevada law isn't what you want it to be. It is what it is. And Nevada law is once your competency is raised as an issue, then 2 doctors have to say you're okay.
I understand that, but with legitimate reasons.
And one doctor says you're not okay as far as competency legally, and then another doctor says you refuse to talk to them. So I appreciate that you don't agree with Nevada law. I apologize that you don't agree with it. It doesn't really matter whether you agree with it or not.
That's when Kim changed his strategy, to the shock and entertainment of the court.
Well, can I ask you something? A young gentleman like me, young, charismatic, and fetching in these county blues, why would I be subjected to competency hearing or to evaluation when I'm clearly cognate of everything I'm doing?
Now sporting a British accent, Kim told the judge he was too fetching to be in chains.
If only fetching were the standard, I'm
Yeah,
not
wish it
going to
was,
argue with you. I appreciate and respect that you don't agree with Nevada law. I respect that. I respect you. In the meantime, you're going to Laser Stein. Thank you.
Kim's strategy didn't work, but he didn't drop the accent.
State versus Eldrion C31328. Defendant.
Kim tried to use a non-existent face card and a phony British accent.
Yeah, what the fuck was that accent? What, mate? Oh, geezer? Fucking hell.
Accent to get out of jail. But how does that compare to a defendant who tries to earn freedom by calling his murdered victim a pig?
I sort of remember this one. I think this one's a disgusting one. Heck? Shut it, heck. Shut it.
And what I believe happened is I slept with Jan Cornell and Leanne Deller, and they were just too much of a pig not to wash their sheets.
Like in the case of Joseph Zeeler, who's charged with double homicide and sexual assault in Cape Coral, Florida. Back in 1990, mother Jan Cornell came home to a nightmare. Her 11-year-old daughter, Robin Cornell, and Robin's babysitter, Lisa, out of jail. But how does that compare to a defendant who tries to earn freedom by calling his murdered victim a pig?
And what I believe happened is I slept with Jan Cornell and Leanne Deller, and they were just too much of a pig not to wash their sheets.
Like in the case of Joseph Zeeler, who's charged with double homicide and sexual assault in Cape Coral, Florida. Back in 1990, mother Jan Cornell came home to a nightmare. Her 11-year-old daughter, Robin Cornell, and Robin's babysitter, Lisa Story, had both been brutally sexually assaulted and murdered. The only clue? A stain on Robin's bedsheets. For 20 years, the crime went unsolved until
We got him.
Zeeler was arrested on an unrelated charge, but when police put his DNA in the system, it came up a match.
26 years ago, a stain was found, and they found DNA 26 years ago from an individual, and they matched the two.
Now in court, Zeeler was determined to make this process as painful as possible.
That's a piece of paper right here that
Mr.
they're trying to hide from you.
Mr.
Right here.
Seiler.
I still see the body of 11-year-old
Mr.
Robin
Seiler.
Cornell with the hand, with the hair of her killer.
The jury will step out.
At first, Zeeler claimed he was innocent.
Do you know Jan Cornell?
No, I don't know Jan Cornell.
Do you know Lisa Story?
No,
Do you know Robin Cornell?
no.
But then he completely contradicted himself.
Now, did you tell the people who this letter's addressed to that you slept with Jan Cornell, Janice, and a friend of hers in 1989, and therefore that's why your DNA is in the Courtyards North condominium?
Yes, I thought so because she didn't wash her sheets.
He says he did assault the girls, but it was months before the murder. In fact, Zeeler claims to know the real culprit behind this attack.
Did you profess your innocence by claiming that it was a relative of yours that did this murder?
Yes, I was trying to defend myself because no one would listen to me.
It calls for a yes or no. Did you, in the letter, profess your innocence or allege your innocence by saying that a relative of yours had done these murders?
Yes.
Then things get even worse.
And what I believe happened is I slept with Jan Cornell and Leanne Deller, and they were just too much of a pig not to wash their sheets.
The prosecutor could barely believe his ears.
Your DNA would have still been there 5 months later.
Yes.
And that's because they're pigs and they don't wash their sheets, right?
Exactly.
You know that?
Well, I assume that, just like you're assuming that
But just so the record's clear, when I said they're pigs and they wash their sheets, that's what you said.
Absolutely.
After that ruckus, it was time for Zeeler to learn the jury's verdict.
At least 8 jurors recommend that Joseph Adam Zeiler should be sentenced to death. Yes, by a vote of 10 for a sentence of death and 2 for a sentence of life in prison without the possibility of parole for 25 years.
Zeeler stayed calm, but underneath, he was plotting revenge. It started during the sentencing hearing when Zeeler motioned his attorney over to him. But when his attorney leans close, wham! Zeeler elbows his attorney in the face.
What's up?
Zeeler is tackled to the floor. Meanwhile, his wounded attorney returns to his seat.
Are you okay? I'm fine. I used to box. I've taken a lot better shots than that.
Calling the victim's mother a pig is bad enough. But how can that compare to calling the judge a bitch?
You gonna raise your voice at me?
Oh my God.
You raise your voice to me, I raise my voice to you. You just in a row.
Like in the case of Michael Gaines, who's charged with battery of law enforcement personnel in Wichita, Kansas. In 2008, Gaines got into a jailhouse fight with 2 prison guards. During the fight, Gaines punched, kicked, and even spit on the guards, a fact made more complex by Gaines's positive HIV diagnosis. In court, Gaines was clearly agitated.
All the evidence shows that you deliberately.
Yeah, okay. Yeah.
Things escalated quickly.
I know
The words were that you deliberately were hawking up.
Bullshit. I didn't hawk up no saliva, okay? That's bullshit. And you're gonna believe those lies. That's what I'm talking about, deputy.
Look at me.
It's like eating. You ain't gotta scream at me.
The judge actually laughed in disbelief.
You gonna raise your voice at me?
Oh my God.
You raise your voice to me, I raise my voice to you. You just in a row.
But he didn't stop with the judge. He insulted everyone.
I appreciate Mr. Gaines making my point for me.
You
Very well received.
maggot mother.
And I don't think I have to take insults from
I know. You. You's a.
He's a tough guy now.
You's a.
But I think
You's a. You'll be a after I get sentenced.
With Gaines and the prosecutor hurling curses back and forth, the judge can't stop laughing.
I think Mr. Gaines has forfeited to me. He's put his.
I'm ready to go. I'm ready to go. You punk.
Then things quickly sour.
I'm talking or you're taken out of the courtroom.
You's a maggot.
Yeah, you're a tough guy.
You's a maggot. You should have died when you was a baby. Maggot.
Anytime, Mr. Gaines.
Shut up. You's a maggot. Should have died when you was a baby. Still born.
Gaines's attack, plus his dirty mouth, earned him an extra 13 and a half years in prison. Gaines's life was ruined by hurling one single curse word at the judge. But what happens when an inmate unleashes a whole host of them?
I am going to appoint the public defender for you.
That's the horse. You do whatever the you want.
Like in the case of Dale Greenman, who's charged with theft in Orlando, Florida. Greenman was arrested after stealing Gatorade, a pack of cigarettes, and a lighter from 7-Eleven. His bond was set at $250, but he's in court hoping the state will have an even better offer. However, he's about to get disappointed.
You were arrested for petty theft. Did you find probable cause? Miss Kenny Swanson, did you have an offer?
I did not, Your Honor.
No offer? Is that due to the out-of-state criminal history?
Yes, Your Honor.
Prior to the theft, Greenman had been charged with tampering with evidence in another state.
So, Mr. Greenman, you have prior history out of state, and so the state may enhance this offense to a felony based on your prior. So I can't do anything with your case today.
The judge just told Greenman he wouldn't be eligible for any deals, and he doesn't take the news well.
That's the horse. You do whatever the you want.
Excuse me?
My name is Mr. Greenman. I'm the federal witness of the United States federal government. I demand back you. Let's get a damn round of long y'all did and figure out what you're doing.
All right, he can be removed once y'all get him out.
Now.
After that emotional outburst, Greenman was dragged out of court and into jail. The judge, however, seemed completely unfazed.
All right then. No contact with any victims or witnesses in the case. And I'm going to set his bond at $1,000.
The officers returned to wipe down the podium, which was now full of Greenman's spit. But how can spit compare to a defendant who hails Hitler in the courtroom?
One day, my spirit will rise from my grave, and you all know that I was right.
Like in the case of Frazier Glenn Cross, who's charged with triple homicide in Overland Park, Kansas. Cross, an established white supremacist, was arrested after he shot and killed 3 people outside a Jewish community center and retirement home in 2014. He killed 53-year-old Terry Lamano, 69-year-old William Corcoran, and his 14-year-old grandson, Reet Underwood, none of whom were Jewish. Police got there within minutes, but it was too late. Now in handcuffs, Cross faced the ultimate punishment, the death penalty. However, he wasn't scared.
I spent 20 years in the Army, 2 tours in Vietnam.
Let me tell you, Mr. Miller.
Stop. I earned the right of speech. Stop. Freedom of speech. Stop. So you a damn whore for the damn Jews. Sitting in their own judgment. You are a damn whore for the Jews.
Don't take a break.
Cross was thrown out of court, but when he came back, he said something even more unhinged.
The state must prove my criminal intent. I submit that I had no criminal intent. I had a patriotic intent to stop the genocide against my people.
He even said he regretted his actions, but not for the reason you think.
I do apologize for those who died. And I thought they were Jews. I wouldn't have shot them otherwise.
His only goal was to spread his racist views. So when the judge refused to give him internet access in jail, he blew his top.
I don't even want to participate in this trial if you're going to gag me. Let me stay in my cell.
Judge, let your attorneys talk.
I fire him right now. I don't have an attorney.
Thank you,
I think you just want to protect the Jews. You don't want me to tell the truth about the Jews.
But that's nothing compared to his reaction after learning his sentence.
To carry out the sentence of death by lethal injection as provided by Kansas law.
One day, my spirit will rise from my grave, and you all know that I was right.
In the end, Cross died in prison at the age of 80. Cross's courtroom behavior was nothing short of shocking. But what happens when a defendant is desperate to stay out of prison?
11 years. Yeah. For being innocent. You're kidding me. 11 years. That's
11 years.
There's no more. 11? That's enough. I could die now.
Like in the case of Jack Whitaker, who's charged with manslaughter in Portland, Oregon. In April of 2010, Jack Whitaker was high on meth when he crashed into the car of Kayla Wilson, who was 5 months pregnant.
On April 15, 2010, he was high on meth when he lost control of his Jeep and smashed nearly head-on into Kayla's Buick as she drove home from a job interview.
The crash sent Kayla into a coma. A few weeks later, she successfully delivered her baby through C-section. However, she remained in a near vegetative state for 8 years before ultimately succumbing to her injuries. In court, Kayla's dad couldn't hold back his tears.
I had to let go of the Kayla I once knew and accept the new Kayla I had. She could talk and she could move.
However, during the emotional testimony, Whitaker loudly interrupted.
Kayla is 21 years old and has been in a hospital bed for 2 years. This April,
I'm in jail for 2 years for not doing it.
She will never know her mom and dad again.
I didn't do it. I didn't do it.
He claimed innocence, even after the jury said otherwise.
And just because the jury found me guilty does not mean that I'm guilty. And that's why I cannot show remorse, because I did not do it.
Interrupting the victim's father is bad enough, but Whitaker doesn't stop there. Next, he interrupted the judge.
Mr. Whitaker, you had a chance already. This is my opportunity.
Yeah, well, I didn't do it.
Then it was time for Whitaker to learn his fate.
This is you consent to 11 years.
11 years.
Yeah.
For being innocent. You're kidding me. 11 years.
11 years.
There's no more. 11? That's enough. I could die now.
Whitaker, still in disbelief, allowed deputies to put him in handcuffs. While Whitaker used his words as weapons, how does that compare to a defendant who uses his own bodily fluids?
There's no way I'm going to try this case or have any further proceedings, or I have to see you for one further set. Set preliminary hearing next week. Targeting.
Like in the case of Bass Webb, who's charged with 2 counts of attempted murder in Paris, Kentucky. Webb had just gotten out of jail when, apparently, he decided he wanted to go back. Pulling out of the parking lot, Webb spotted 2 prison guards going to work. That's when he floored it and attempted to run them over.
The surveillance video from the Bourbon County Jail, which shows a car barreled down on 2 jailers, hitting and nearly killing them.
One guard was able to escape, but another guard had to be hospitalized for his injuries. In court, Judge Dixon refused to work on the case for a very personal reason.
There's no way I'm going to try this case or have any further proceedings, or I have to see you for one further set. Set preliminary.
Webb's victims were close personal friends of hers. However, when she sent Webb away, Webb retaliated.
Set preliminary hearing next week.
Webb launched a spitball right at Judge Dixon's face and landed it. She forced Webb to watch as she cleaned her face. Then she sent him away for good. But if you thought you'd seen the last of him, think again. While awaiting trial, Webb incited a violent prison riot. Webb refused to yield, even after SWAT teams were brought in.
Out in the sub-day room, refusing to return to their cells. They are armed with weapons.
They sprayed him with pepper bullets. But that only made things worse. Webb, who had ripped a telephone box from the wall, slung it at a corrections officer. Eventually, SWAT teams sprayed tear gas to scatter and capture the rioters. After Webb was subdued, a new judge finally revealed Webb's sentence.
I will accept the jury's recommendation of 5 years on count 1, enhanced to 15 years pursuant to the persistent felony offender first degree.
Webb was sentenced to 15 years for the riot and another 37 for the attempted murders. Webb's bad behavior made his judge drop the case. But how can that compare to a judge who screams at the defendant from the podium?
You were relentless. You stabbed, you stabbed, you stabbed, you stabbed, you stabbed until he was dead.
Like in the case of Camilla Gamet, who's charged with first-degree murder in Jackson, Michigan. Gamet was arrested in the vicious killing of her boyfriend, Marcel Hill. According to the evidence, she bludgeoned Hill with a floor lamp, frying pan, a nightstand, and a large knife. Hill later died from blood loss. However, Gamet claimed the murder was actually self-defense.
What had woke me up was when the glass broke. It was just loud glass, and I didn't know at first what it was.
She said she woke up to a loud sound and thought an intruder had broken in.
So I started trying to turn on the lamp, and all the while I'm doing this, I was getting hit in my head.
After realizing it was her boyfriend attacking her, Gamet says she fought back with whatever she could find.
I never went and got the knife. The knife was already there. I started swinging the lamp, and the lamp had hit Marcel. And I turned, and he was still hitting me.
She claims she didn't realize he was dead until it was too late.
It really did hit me like I didn't really realize that I had stabbed him. I just kind of, in my mind, like I just thought I was fighting him, and it happened so fast. And I ran out the house and I started calling 911. By the time they got there, it was too late.
However, Judge McBain didn't buy her story.
You gutted him like a fish in that apartment too. You were relentless. You stabbed, you stabbed, you stabbed, you stabbed, you stabbed until he was dead. You didn't think he was an intruder. You know, maybe one stab wound, okay. Maybe that's self-defense. But you put in 11 more to make sure he was good and dead.
Gamet maintained her innocence even after the jury found her guilty.
I just want to say that I stick by the truth, which is that I did react in self-defense. I did love Marcel, and
basically at trial, the way I was portrayed, mostly everything was lies. There was a little bit of truth, but mostly I was convicted off of lies.
Gamet's lack of remorse was Judge McBain's last straw.
I agree with the family. I hope you die in prison as well. You know, if this was a death penalty state, you'd be getting the chair.
Gamet was sentenced to life in prison for the murder. Gamet may have gotten an earful from the judge, but how can that compare to a defendant who has to be carried out of court after killing an innocent child? Like in the case of Desmond Jones, who's facing charges of engaging in organized criminal activity in Dallas, Texas. In 2017, a high-ranking member of a rival South Dallas drug gang stole thousands of dollars worth of marijuana from Jones's house. In retribution, Jones and a group of gang members kidnapped 13-year-old Siobhan Rindle, a relative of the rival gang member's girlfriend, and held her for days until ultimately shooting her to death. Rindle's parents reported the kidnapping, and after finding the preteen's body, they traced the crime back to Jones. In court, Rindle's cousin said Jones kidnapped the girl for ransom.
They was like, you better not get the police involved, bring us our drugs, and they hung up the phone.
What did the person say?
If he don't bring me back the drugs, then I'm going to kill him.
According to documents, Rindle was killed after seeing her kidnapper's face. During the trial, Jones showed no remorse, but that would all change after sentencing. The judge sentenced Jones to 99 years in prison, and Jones had a breakdown. Jones cursed and threatened the victim's family. Then, things escalated.
Out! Out! Sit down, Jones, sit down. Sit down!
At first, Jones followed the deputy's instructions, but not for long. Desmond was carried out by the cops with his mother wailing in the background.
I'm good. I'm good.
Desmond's crime was unthinkable, but what would happen if the victim of a heinous crime turned out to be the mastermind behind it all? Like in the case of Jussie Smollett, who was charged with 5 felony counts of disorderly conduct in Chicago, Illinois. Smollett, who played Jamal Lyon in Empire, made a panicked 911 call after 2 men broke into his house. Smollett claimed the attackers, motivated by homophobia and racism, put a noose around his neck.
Do you want to take it off or anything? Yeah, I do. I just want to see.
During news interviews, Smollett revealed more details about the attack.
Walking, and then I heard Empire. So I turned around and I said, did you just say to me? And I see, he said, this MAGA country punches me right in the face. So I punched his ass back. And I want a little gay boy who might watch this to see that I fought back.
He claimed the attackers fled after threatening him. And after weeks of investigation, police finally revealed their findings.
You're gonna pay $3,500
to stage this attack and drag Chicago's reputation through the mud in the process.
The real culprit of this hate crime was Smollett himself. Police discovered that he paid brothers Abel and Ola Osundario to stage the attack, all in an attempt to get attention and a higher salary for his role on Empire. After that, people saw his interview in a whole new light.
You do such a disservice when you lie about things like this. I still want to believe, with everything that has happened, that there's something called justice.
Smollett was arrested for his crimes. The public was shocked and outraged at his lies. But that can't compare to the outrage of Smollett's judge.
Your very name has become an adverb for lying. And I cannot imagine what could be worse than that. You let that dark, narcissistic, selfish, and arrogant side come out, and you persisted with it for years on this case.
Then it was time for Smollett to learn his sentence.
I'm fashioning the following sentence, and here's your sentence. I'm sentencing you to 30 months felony probation, and the probation is going to be to this court. You will pay restitution to the city of Chicago in the amount of $120,106. You are fined $25,000, which is the maximum fine. And you will spend the first 150 days of your sentence in the Cook County Jail. And that will start today, right here, right now.
But if you thought Smollett would go away quietly, think again.
No, I would just like to say to Your Honor that I am not sorry. I am innocent, and I am not sorry. If I did this, then it means that I stuck my fist in the fears of Black Americans in this country for over 400 years and the fears of the LGBTQ community. Your Honor, I respect you and I respect the jury, but I did not do this, and I am not suicidal. And if anything happens to me when I go in there, I did not do it to myself, and you must all know that.
As Smollett was led away, he had one last word.
I am not suicidal. I am not suicidal, and I am innocent. I could have said that I was guilty a long time ago.
Smollett's fake activism may have seemed over the top, but how can that compare to a defendant who tries to flip the podium?
Oh, let's not. Not right now.
Like in the case of Donald Roberts, who's charged with robbery, assault with intent to rob, larceny, and refusing fingerprinting in Ann Arbor, Michigan. Roberts, who was representing himself, had just finished complaining about the small book selection in the library jail.
I think that's sufficient for the time being. But
Then, Assistant Prosecutor Brenda Taylor interrupts.
Your Honor, I'm asking the court to use the report dated July 25th of Dr. Smith for purposes of finding incompetency, and I'm asking the court to find the defendant incompetent and to order him to the Forensic Center for treatment and restoring of competency.
Roberts seems upset about the change in topic.
I don't want to reiterate
No, I've already ruled on that anyway.
This time, it's Roberts' turn to interrupt.
What about my discovery? Let's talk about that.
Oh, let's not. Not right now.
Upset at the judge's dismissal, Roberts attempted to flip the podium. When he couldn't lift it, he instead slammed into a lawyer, attempting to inflict maximum damage as spectators fled and deputies closed in. Officers quickly subdued Roberts, narrowly missing what could have been a violent explosion. After that display, the judge forbade Roberts from representing himself, appointing a public defender instead. Later, Roberts pled no contest to the larceny charge. The court dropped the other charges and sentenced Roberts to 22 months in jail. While Donald Roberts' courtroom actions can be blamed on mental illness, what happens when a defendant refuses to get arrested? Like in the case of Michael McDonald, who's charged with violating his bond in Las Vegas, Nevada. 1 year ago, McDonald was involved in a nasty divorce. So nasty that his ex-wife filed a restraining order to keep him away from their kids after he broke into their house. However, just months afterwards, McDonald violated the restraining order.
When the defendant Michael McDonald was released on his own recognizance last April by Judge Israel, one of his release conditions was to have no contact with the individual, his ex-wife being Candace Ruiz. Approximately a month ago in June, he then mailed a number of items to his wife's address, although they were addressed to the children.
McDonald sent gifts to his 2 children, something McDonald's attorney says he didn't know was against the rules.
He sent 2 gifts, that's it. No nasty notes with them, no diagrams, no nothing. Mr. McDonald is not violent nor a threat to the community. He has had no allegations of violence. He has stayed substantively away.
His attorney asked for the judge to forgive the trespass, but the judge had other ideas.
I would note that back in the family court, he constantly violated orders. He would always insist that the order said something else. Because of his bizarre behavior, putting a tracking device on his wife's vehicle, and so I'm seeing the same type of conduct, and it's an obsession.
This is the moment McDonald hears the judge's final decision.
I'm not sure that he is capable of controlling himself because he wasn't before. So based upon that, I am granting the motion.
McDonald's request was just denied, and now he's going to jail. McDonald flips out.
Put your hands behind your back. Put your hands behind your back. Fred, can you please tell my mental health already done? Dude. Come on.
Upset with the decision, he resists arrest, but that only makes things worse.
Put your back.
Mike, calm down. Just relax. Mike, take a deep breath.
I got mentally about to see my kids. Come on.
Mike, calm down. Dude.
His attorney tries to get him to calm down, but it clearly doesn't work.
Guys, come on. You're gonna really throw me in jail because I miss my kids. Come on. Assistance in 15 Charlie. 15 Charlie. Stop. Come on, please, guys. Please, I don't want to.
Deputies struggle to get McDonald under control. Meanwhile, his lawyers keep trying to calm him down.
Mike, stop fighting with him. I was having to come over there and help him with cuffs on you. Don't fight with him.
I'm gonna case you.
Don't fight with him. With the handcuffs on.
Finally, the lawyer's patience snaps.
Mike, put the handcuffs on. Or I'll put them on myself.
Craig, come on.
I'm on your side, Mike. Put your battle on.
Surprisingly, that worked.
I just want to see my kids now. I'm getting prosecuted as an enemy of the state. I just want to. I've done nothing.
McDonald was finally handcuffed and taken to jail. The judge sentenced him to 2 to 6 years in prison. These deputies had to wrestle McDonald into handcuffs. But how does that compare to a defendant who has to be carried out by her elbows? Like in the case of Sarah Bunch, who's charged with manslaughter, arson, and attempted tampering with evidence in Northwood, Ohio. In December of 2008, Bunch was arrested at the scene of an arson after firefighters found the body of 60-year-old Robert Porter shot to death inside of his burning home. Police accused Bunch of shooting Porter and then committing arson to cover up her crime. However, Bunch claims she shot Porter in self-defense as he was attempting to assault her. In court, the judge had trouble believing Bunch's story.
Having a hard time understand how someone's coming towards you and the second shot is in the back of their head. Can you explain that to me?
Bunch burst into tears defending her character.
I really was a good person. I had 2 jobs. You know, I was my kid. I was doing what I needed to do.
However, despite her apparent remorse, Bunch refused to apologize to the family.
The last and certainly the most vivid memory his grandchildren have of him is him laying dead in a casket over a senseless, and to them, confusing act of violence.
Throughout the trial, Bunch constantly rolled her eyes in disrespect, but her attitude quickly changed when the judge announced his sentence.
13 years?
When the judge sentenced her to 13 years, Bunch screamed, cried, and fought deputies all the way out of the courtroom door. But she wasn't the only one who got upset.
Guys, I'm gonna tell you something.
Her father in the audience also exploded. However, this courtroom explosion is nothing compared to that of Alan McCarty Jr.
You wanna fucking take my kids from me and act like that? Fuck you and that fucking bitch.
This is Alan McCarty Jr., who's charged with threatening a judge in Daytona Beach, Florida. It all started when McCarty, who was going through a nasty divorce, lost custody of his children. Enraged, he called the courthouse to air his grievances.
Communications, Warhurst.
Yeah, I want to report a crime that's about to happen.
What do you mean a crime that's about to happen?
Yeah, there's about to be a crime that's going to happen if my kids don't come back to me, you stupid. Because your stupid judges don't want to bring people to courtrooms. I got a gun pointed at your building.
Sir, what is going on?
Who the are you calling, sir, you stupid? Don't call me names. You call me names, I'm going to call you some. I ain't your sir, you dumb. Where's your judge warrant at? You going to bring that out in handcuffs and I'm going to execute that right in the street.
Okay.
Do you hear me, you stupid?
Okay, I'm going to disconnect the line, sir.
When that receptionist hung up, McCarty tried another line.
Communications, Braithwaite, how can I help you?
Yeah, I need to put your judge on the phone.
Yeah, I'm sorry.
You hear me? Put your stupid judge warrant on the
Right, hang on, people. Let me get my sister on. This is my beautiful sister, the one you all want to see. Here she is. Hang on, my darling.
Hi.
Hey, yo.
What's
How
going
are you?
on? Hold on.
Oh, I'm
good.
so
How are
excited.
you?
Yeah, I'm good. I'm so excited
I know,
to
it's
see
good
you.
To see you, handsome. Hold on, it's looking at me. Hold on. I'm trying to flip it. Everyone's waving to the camera, and I'm like, wait. Hold on.
Hang on.
Hold on. Oh my God, Erica, stop. Oh, there it goes. I'm so special.
There
There we
you
go.
are.
Say
Oh,
hi.
look at them posing.
Maria, Lauren, Leanne, Diane. We got
Oh, look
some
at her.
Barbara. I don't know everybody's name. Oklahoma. I'm gonna call her Oklahoma.
Right, let me
Came
make
from
it bigger.
Oklahoma. There's Ross. It's Ross's birthday. Everyone say
Happy
birthday to Ross.
birthday.
Yeah, happy birthday. I told you. There we go.
Let me make
Oh
this
wait, so
bigger.
my wife's missing. Oh, there she is. There's Brandy. I said we did happy birthday Ross to Dylan, and everyone yelled it. Yeah.
I love
We'll
it.
sing. All right. I love you guys. Here's Scotty. Hey, GFY. What's up, baby?
Hey, GFY.
My girl.
My darling. Yeah, she's
We need to
awesome.
do something before the summer officially ends. I am officially on vacation, but we drop our daughter off on 8/21 next Thursday, so I'm free after that, guys. Okay. I love you
There you
all, and I'll
go.
talk to you in a little bit. Here's Scotty.
Love you, darling.
Do you want it
Ta-ra.
towards you or away from you? Is that good?
Dylan?
Scotty, how are
How are
you?
ya?
Good. Nice to see you, buddy.
Yeah, we got a good crowd here lined up. I don't know how many people are trying to get in, but
That's good. I've just trying to adjust the screen. I am, so bear with me whilst you're speaking. Scotty too hotty. I love that. Good crowd, Scott.
yeah. A lot of people were here early too.
Timmer.
Dylan's live. Want to say hi? Dylan.
What's up, bitches? Love it.
Well, to our chagrin, we just saw Robert Cosgrove come up the stairs and enter the courthouse.
Okay. Let me make this full. There we
Apparently,
go.
the evil DA Meatball has reanimated Cosgrove once again.
Okay.
So he's here.
Okay, that's all right though. But look at the crowd. There's a hell of a crowd there, man, isn't there?
Get some shade here. People are trying to stay in the shade. They haven't kicked him off the stairs yet.
Has Aiden's not there yet, is he?
No, I haven't seen Aiden yet. I mean, we've gotten word that Bradle had to go to another courthouse, and he might be running late, more like 2:30. Aiden was trying to get the hearing postponed till 3. I don't know if that happened yet or not.
Well, Aiden tweeted about 10 minutes ago saying that it should start at 2:15 to 2:30.
Yeah, that was the estimated time of arrival for Bradel to get back to this courthouse.
Yeah, so Aidan tweeted that about 15 minutes ago, Scott, as well, to confirm.
I mean, after lunch ends here at 2, they might start letting the crowd in to the courtroom if it's still the big courtroom, we hope.
No, hopefully you're all right. Are you going to go in, Scott?
I usually do not.
Okay.
And I would have had a bed in line already. I mean, that big courtroom, if there's no other people in there, can fit up to 100 people. They'll probably let 80 in if it's the big courtroom.
Yeah. Well, what in totality do you know what in totality Aidan is facing today? What is everything this hearing's about, Scott?
Well, I mean, the last several hearings, it's been the games that Cosgrove and the Commonwealth have been playing with the discovery.
Yeah.
So, Aidan and his team, Bradel and Betterow, they have all kinds of discovery, but it's all been sealed. And then last night, Cosgrove dumped a bunch more discovery onto Aidan and his team, and Cosgrove wants the original thumb drive back that has 4,000 blank pages, because Bradel's saying he wants to investigate why the DA's office handed him a thumb drive with 4,000 blank pages. Like, Bradel is going to hero this and get to the bottom of the DA's shenanigans.
Yeah.
But I mean, this is basically another discovery hearing, however that works out. And you guarantee you what Cosgrove's going to do is go in front of the judge and say, hey, we just handed them, another 3,000 pages of discovery last night at 10 p.m. And then obviously Bradel is like, well, wait a minute. They just gave it to me at the last hour, which is what DA Morrissey likes to do in all these cases. You've seen it with Rosemary Scarpiccio. They dump a bunch of discovery on her the night before she has to come into court. And then Judge Krupp is asking Attorney Scarpiccio why she isn't prepared. And she's like, well, Your Honor, games people play, the DA office just dumped all this discovery on me last night.
Yeah.
The DAs in Massachusetts love to do that.
There's a hearing tomorrow, I believe, again, isn't there?
Yeah, well, Krupp had to make sure they came back before the end of the week because the clock is ticking.
Yeah.
All of Proctor's messages, his phone is set to turn into a pumpkin at midnight on Monday. And all these defense attorneys that are involved defending anybody that was investigated by DA Morrissey's state police detective group, including Proctor that got his dirty hands on it. All those attorneys are like, wait a minute. Information in Proctor's phone is pertinent to my client's case. DA Morrissey would love nothing more to have Proctor's phone gone forever Monday.
Yeah. Yeah, we do not need that. We do not need that. It's just complicated.
There's too many defendants with cases pending.
Yeah.
Where Proctor's phone could be pertinent to their case.
Yeah.
I mean, I get what the DOJ and the U.S. attorney are saying is, the Karen Reed case is over. The Proctor phone stuff has to go away. But what's happened is these other defendants in other cases that Proctor had his hands on are like, well, wait a minute, there might be stuff in Proctor's phone that pertains to my client.
Yeah. Yeah.
So, I mean, you just can't let Proctor disappear in his phone because there might be stuff in Proctor's phone that pertains to the Walshe case or pertains to the King case. The Commonwealth fired Proctor and they just want the Proctor problem to go away, but they also want to make Proctor their scapegoat and tell the public, hey, never mind about Proctor, it's over, Karen Reed trial's over. And these other defense attorneys are like, no, wait a minute. Proctor was an investigator on my client's case. We want to see his phone too.
Yeah. And how many others that we don't know about? Yeah, exactly.
So, I mean, Krupp basically said, hey, we got to come back before Monday. So that's on the docket for tomorrow.
Yeah, tomorrow afternoon. That'd be interesting. Look at that. Look how dedicated people are on the floor and everything. It looks hot, though. It looks hot, Scott.
It's not too bad if you're over here under these shade trees in front of the courthouse.
Okay. Look at all these people.
That's a good showing here for Aiden.
It's a great show for Aiden. Look at all of them.
I mean, I don't see how this whole continued pursuit of Aiden is not ill-fated by the DA's office.
Yeah.
But obviously, they're still going forward with it. And, Meatball Morrissey has the ruse of the independent prosecutor in Cosgrove, which is a joke. Because obviously, Morrissey legally can say, hey, I'm not persecuting Turtleboy. I'm conflicted here. We have an independent, quote unquote, prosecutor in Cosgrove prosecuting this case. But we all know that's a joke.
Yeah.
We all know Cosgrove is in the back pocket of Morrissey. I mean, Robert Cosgrove was an ADA in the Norfolk County District Attorney's Office for years and years before he became a Massachusetts judge.
How long was he a judge for? How long was he a judge?
If anybody Googles Robert Cosgrove as a judge, there's some lawyer websites that'll give you the whole bio on any judge in Massachusetts. I've scanned his before. I know for a fact, I can't give you years.
That's fine.
That Cosgrove was the ADA in Norfolk County, ironically. And then he was a judge for a while, and then he retired. So one of the things Aiden jokes about, as far as Robert Cosgrove is concerned, is he calls him a triple dipper, because he has a state retirement as an assistant district attorney.
Yeah.
And he also now has a separate retirement as a judge.
Wow.
So now he's being paid by Morrissey's slush fund to be the special prosecutor in this case. So he's, getting a third income. So Aiden jokes saying Cosgrove's a triple dipper.
Wow.
And then we saw those emails that came out from Meatball asking for $1 million from the State House, to hire Brennan and Aperture in the Karen Reed case. God knows what Morrissey spent on Mello and Cosgrove and the state police team that arrested Aiden at his home in Holden. I mean, there's been a lot of money spent, just on this persecution of Turtleboy. Never mind the outrageous $1 million or more they spent on the two prosecutions of Karen Reed.
Yeah. Yeah.
And for some reason, Michael Morrissey, he started his political career in 1977 as a state rep. And then he became a state senator. And then he became, Norfolk County District Attorney. So Michael Morrissey's been in elected office in Massachusetts since 1977. And he has a lot of connections in the State House. One could argue he has more political power than Attorney General Andrea Campbell or Governor Maura Healey. I mean, you think about when Meatball was a state senator, the Senate president was Billy Bolger, Whitey Bulger's brother, who was the gangster on the lam.
Yeah.
And guess who Meatball hires as the special prosecutor in Karen Reed trial 2?
Brennan.
Hank Brennan, Whitey Bulger's attorney.
Yeah, not by coincidence. Hippie Chick says he definitely knows where some bodies are.
I mean, I picture Meatball Morrissey having so much political clout that even the attorney general and Governor Maura Healey bend a knee to him. That's how much political power Morrissey has going back to 1977.
Yeah.
I mean, Maura Healey and Andrea Campbell are babies in the political matrix that comprises Massachusetts politics.
And when does his term come to an end? As in,
If he decides to go for another term, the election would be next fall, 2026.
2026. Okay.
And Michael Morrissey has a huge war chest, and part of campaign finance reform that a lot of us want to see. So if Morrissey decides, oh, I'm going to retire, he can take his $2 million war chest or whatever it is and just dump it into the DNC, and that money would go to the next Democrat of choice for the Democratic Party in Massachusetts,
hi
which is
Tracy.
basically the mono party that runs Massachusetts.
That's fine. We got Tracy Murray in the chat. We would much prefer Tracy over Dana. Hello, Tracy, my darling. Scott McGinnis is joining us live from Dead and People. If you got any questions for Scott, put them in the chat. We'll try and ask Scott some questions. But there's a good crowd out there, Scott, and there's a queue to go in. We think that hearing's going to start between 2:15 and 2:30. People, so
they might let the crowd start going in after lunch at 2 p.m. But
2
like you
p.m.
said, Bradel might be a little late.
There you go. There you go. No, there's I'd say the weather's not too bad. Luckily, there's shade there. Otherwise, that would be unbearable being out there. You know, if it wasn't for the shade. So this is a lot of dedication from people giving their time for Aiden, which is good.
Yeah, I mean, it helps a little bit. It's summertime, and maybe people are using vacation time or whatever.
Yeah, but whatever it is to see this amount of people for Aiden is nice. He would be happy with this, to see people coming to support him. So,
yeah, I mean, if this still remains in the large courtroom, like I said, 80 to 100 people in there,
mm-hmm.
a good portion of this crowd will probably be able to get into the courtroom.
Good.
I mean, but I don't know what we're actually going to see take place in the courtroom. I just expect more BS from Cosgrove. The killer bees, Bradel and Betterow got dumped all this discovery last night, literally.
Yeah, I saw that this morning. How is that even possible? How is Cosgrove not pulled up on this?
Well, the funny thing is, Cosgrove wanted the original thumb drive back, and Cosgrove wants to investigate why the DA's office gave him the original thumb drive with 4,000 blank pages.
Yeah, is Bedrow there today?
If I'm Aiden and his defense team, I'm like, yeah, Cosgrove, you ain't getting back the original.
But
Figure it out.
Do you think Bedrow was there, or will he be online?
No, I heard rumor on the street that Betterow can't make it here today. He's going to be Zoom.
There you go.
Obviously, Bradel would be the only in-person attorney.
Oh, there you go. And Sheila Texas says, I heard he's on vacation. Wonder if he will come in by Zoom. There you go. Well, Bradel's more than competent anyway, so. And it's probably not going to be a very long hearing, I imagine. Scott.
No, I mean, Judge Doolin, people are kind of liking his personality. He's jovial. It seems like he could possibly, make decisions more in Aiden and his team's favor. But I don't know. I mean, there's so much stuff that's been sealed that, Aiden and his attorneys are like itching to get out, but they can't unless the judge allows it. And now who knows what was in this new discovery that got dumped on him last night. Bradel, his sole job isn't defending Turtleboy. He's got other cases. That's one of the reasons he's going to be delayed getting here today. Like I said, it's like the DA office does this on purpose to defense attorneys. They dump discovery in real late the night before the hearing. So now the defense attorney looks like a fool in front of the judge. They don't obey discovery deadlines. they'll complete a certificate of completion for final discovery, then a case goes to trial, then the DA starts introducing new discovery that shouldn't be allowed by the judges, and the judges let it in anyways. So the DAs get away with this stuff all the time, and they do it all across the board in all the cases. It's not just Karen Reed or Turtleboy. You see it happening with Rosemary Scarpiccio's cases.
Yeah. But this is a good question as well. You may know the answer to this, but Wikicycle said, how long are they going to be able to keep kicking the can down the road without turning over discovery? Is there a time limit?
Exactly. Now, like I said, they dumped all this discovery on Aiden last night. So I guarantee you're going to see Cosgrove. So if, Bradel gets up there and Bettero's on Zoom and they say, hey, we were looking for this discovery since Aiden was arrested in October of 2023. They still have his phones. They're still playing games, Your Honor.
Yeah.
Cosgrove's going to get up there and say, no, Your Honor, we're doing the right thing. We gave him 3,000 more pages last night.
Yeah.
And then the judge would be like, well, can we get anything done today? And then you can picture somebody like Bradel or Bettero saying, well, Your Honor, we need more time to go through all this late discovery. It's a game that the DA's office plays on purpose. So then the judge will be forced to give another date and kick the can down the road.
Yeah. Because how long has this been going on for now, Scott? Do you know?
Well, like I said, Aiden was arrested, I believe it was October 2023 when they had a search warrant to search his home and take all his devices, which he's never gotten back, by the way. And then they were delaying this as they continued the 2 Karen Reed prosecutions. It's just been talk about kicking the can down the road. This has taken forever. And now Aiden is like,
It's a snowstorm.
Aiden is like Morrissey's like fixation is it's like he's like mad trying to take down Turtleboy.
To Morrissey.
Hey, Brandy.
Look
Look at that, Brandy.
We're gonna send it to Morrissey and Tamara.
There you go.
And anyone else who I feel appropriate. Aren't we so cute though? I'm like, everyone looks so cute.
Love it.
They bring the Morrissey sign. Yeah. Yeah, they don't even need signs. Just give Morrissey the middle finger. Yeah.
Oh, that's why you're hiding on here. It's freaking.
Yeah, I know. It's a
10
little...
degrees colder right now.
I know. Couldn't do this in the Karen Reed trial. Stand on this lawn. I'm surprised we haven't been yelled at.
Taped off. Yellow caution tape.
Yeah.
When are you gonna let us in?
They said you're gonna run late, but Bradel's up at Salem.
Oh yeah.
Yeah.
2:15 to 2:30.
Yeah, but they still could let people sit in the
Oh,
court.
I know.
I'm sweating.
I know.
Make people sit out here for another half an hour because Bradel's gonna be late. Just let them in anyways.
Yeah, that's true. But they don't care about the people, though, do they? That's the problem.
Is that why you live with Dylan?
Yeah.
Tell people
Hey.
stop some assholes.
Hey, Joe.
Dylan, Anne Marie's at home in the AC.
Hey, Marie.
She's smart.
Anne Marie, there you go, and Joe, there you go. We can see Eric.
Well, I'm gonna hand the phone back off.
Yeah, it's fine. I'll hand it to whoever.
'Cause I've been trying to hold my sign and flag this whole time, and on my handshake.
Give it to Brandy if you want. If Eric doesn't want it.
Yeah, I don't care. Give it to Brandy for a couple minutes. Brandy, take it for a couple minutes.
Who is it?
Yeah, it's just Dylan.
Oh, right. I got to pre-warn everyone. Right. I
Stop
won't get
being
a
lying.
word
It's
in now.
complaining. That doesn't mean.
Hi guys, hold on a second. Let me just go put my phone down.
We won't get a word in edgeways now, people. We got Brandy on. So.
Did you guys see the picture though?
I told you. Yes, it's gorgeous. Look at that.
I don't know if you can see what number one. Can you hold that a second? Yeah. Thanks. All right. Let me try something real quick. Hi. I'm sweating bullets, but I miss you guys.
Hey, there she is. How are you doing?
Good. We're sweating out here. We're dying. We're sweating.
Looking good though. All looking good out there.
But we miss you. We miss everyone. I hope everyone's having a good summer.
Yeah, I think so.
And
I
hi,
think
Tracy.
so.
Oh, you said happy birthday to Ross. I'll tell him. Hi, Jen. How are you? Welcome, welcome. Hi, Lauren. How are you? It's hard to hear you. Let me go back up here. Come over here. Let me go back up here. Sorry. What up? I was like, in your. Say hi. Oh, there's St. Ross. He's doing the thing. Look at.
Happy birthday! That's Dana. So happy birthday to St. Ross.
I'm gonna try to turn it around.
There you go. That was a birthday one. That's a bit different from Dana.
So this is the stairs crew. These we all got here early. Like a weird thing.
There you go. Hi, Dan.
We got the Lawrence, Maria, everybody.
Yeah.
We met that guy in the sunglasses over there. See him?
Oh, yeah,
Next to the
yeah.
cowboy hat. So he was
Yeah.
just filming us from over there earlier. We didn't know who he was. So me and Maria were like, "Hi, who are you? What are you doing?" But he's from Mexico City. He's a Turtleboy fan. He's a supporter, and I guess he grew up here in Westwood or something. But he's flying back home, but he wanted to stop here because he knew there was a hearing. So we got people from all over here today.
It looks good. It look good crowd.
Yeah, it goes back down there, all the way down the street. It's just hitting the corner now. I think there was a lot more people last time, but it's also 90 degrees. I don't know.
I
But
know.
yeah, how are you doing? Are you getting ready? Are you getting ready for round 2 of us?
Oh, I am. I needed a break so I could
Yeah,
come
you
back
did.
and see you, and you're like 100 miles per hour, so I needed a break.
Yeah. Oh, thank you, J Mac. I just saw your thing now. My bow. It's my daughter's, but sometimes I wear their things.
Yeah, I know. There's Jen. Jen's there as well.
Hi, Dylan. Say hi. Hi, Dylan.
Hey, allegedly. Hey, allegedly.
Allegedly. Brandy Lane,
Yes.
allegedly.
Love it. Love it. Nice to
Yeah,
see her.
Yes. 4 years. That girl must be so hot in the sweater. I feel bad.
The head hen is there as well.
Yeah,
Looking
that
over.
him's always here.
Always there with
Taking notes.
Lauren.
He's taking his notes.
Taking notes. I
He's
love it.
he's always working.
Hey, what up, bitches?
I forgot
it.
to make Ross a sash. Happy birthday. See this? Can you read this? You guys.
Oh, I
Take
can
that
see
in.
that. I can see it. Do I look like I care?
Screenshot it. Study it.
Let's go, Sacco. Let's go, Sacco.
Sacco. Mr. Jason. Mr.
Haley.
Jason. How's it going? Hello.
Hey, Jace.
Jace, it's Dylan. Dylan,
I
the
s-
ultimate corner.
Haley.
Yeah. Yes. Hi, how are you? Good. I'm on with Dylan right now. Oh, hi.
Hey.
Yeah, so is everybody?
Brandy, keep speaking, Brandy.
Okay, I'll try.
Just, yeah,
This is
I don't have
Dylan
to.
with the alternate corner. Hi, Dylan. Yes.
Hello.
Hello. All right, yeah, I got it for a minute.
Yeah, that's fine. I'm still
Till
going to
they
hear.
let me in, and then I'm running in that AC. I'm
Yeah,
bolting.
that's fine. That's fine. Hello, ladies.
But this is Erica's phone. She's coming in too, so I can just. I can take the phone with me. I'll sneak you in there.
That guy.
Try to get. Maybe we can go live inside the courtroom.
Don't get in trouble.
No, I can't get in trouble. I got no sunglasses or hat on today, so people can see the real me. And so I'm like, I gotta behave.
I know. I
No,
know.
you ever see that movie Big Daddy? When they're like, oh, if you put the sunglasses on, no one can see you. I feel
Yeah,
like that's me. Like I
I've heard
believe
of it.
that. I believe it. Hi guys. It's this way.
okay.
Hello, Maria.
Me, so I walk with it this way.
I'm just being ghetto and smoking my.
Oh, sorry.
I know, right?
I love your hat. Mike forgot's hat.
Thank you.
Let me show the pin. Just on pin.
Just en route.
Yes. If you haven't gone to justonroute.com, you should give it a visit. Give it a visit. Hello.
Yeah.
Hello, darling. Hello.
ADD, so I can't stand.
Me too.
Corral with a wild.
And there's Tim. We love Tim up there. Oh, I know. I talked. Oh my god. Oh my god.
Yeah, go to the side door right now.
Mother, father, brother, sister. Mother, father, brother, sister. Another picture? Sorry, I feel sick. It's so hot. I'm gonna get a heat stroke. Ay. It's like 10 degrees difference when you go in the like shade. Yeah. Under the thing and everything. But let's see. When Scott comes back, can you please ask him if he knows anything about Morrissey's old law firm being hired as consultants with taxpayer funds, and if he still has ties there? I will. I saw that too. It's all money laundering. Michael Morrissey has been money laundering since the 80s. Look into that. Follow the money. You'll get the. It's all RICO. I don't know why they don't move him yet. I don't know. I just hope they all take him down when they do go down. But I will ask him as soon as he comes back. I'm just like, I need another water, so I didn't want to walk yet. Ugh. Say hello.
Keep getting things in my hand. I'm like, what's in my hand?
Yeah, is it charging? It is, right?
Yes. In the cable.
Look at this charger. Sticks to the back of the phone. It's magnetic.
TikTok.
Isn't that cool? TikTok. Yeah, TikTok. Excuse me, sorry. Sidewalk. You guys want to go see the line again?
Yeah, you take us wherever you want.
Yeah. Wait a minute, you're in disguise. I know, I'm in disguise today. I know, I gotta behave. I don't know. It's too hot. Too hot. Say hi to Dylan. In the chat. Yeah. All right.
Hi, Rodney.
Can see you in a couple of months.
Yeah. Yeah, sorry, I didn't mean to interrupt. Hi. All right, so here's the line. I got some people up there. Got some people here. Hi. We're on with Dylan. Say hi.
Oh, hello. Look at all these beautiful people.
Yeah. Said all these beautiful ladies. No dirty tricks. Dylan's full of dirty tricks. That's why we love him.
Yeah.
Listen, I did not listen. I feel so bad. I went up to her earlier and I touched her arm to say hi and she jumped a mile. She's like, you just took 5 years off my life. Sorry. I didn't mean to. Hi. We're on with Dylan if you want to say hi. Hi, Dylan. Yeah, it's back to the end of the corner now. So, yeah, it's a good line. Oh, and we got sweethearts at the end. They saved the best for last. Oh,
Joe, how are you? Good to see you. Nice to see you as always.
I'm on with Dylan if you want to say
Okay. Hi, Dylan.
I haven't seen
Hey,
you in so
Peter.
long. You want to say hi to Dylan in the chat?
Get out here.
Hi, Neil.
Get on
Hello.
the plane. Get out here, Dylan.
Yeah, you heard him. That's an order. Yeah. It's hot, huh?
It's warm. Yeah. Good day for a pool party.
Yeah. Pool party at my house after. If it's a dismissal, all right? If it's a dismissal, it's Ross's birthday, so
Hello,
we'll
Lisa.
celebrate.
Hi, Heather.
Robin said hi, and J Mac had the honey. Oops, sorry, behind you. I love you. Yeah. Wait, are they letting us in? What's going on? What I missed? What I missed? And I missed. I need the stick. I need the stick. Are you recording still? Yeah. Well, no, I'm on with Dylan. Are you recording me right now? Just your head and your face. Oh, yeah. The answer, yes. Just your head. Hi, Dylan.
Hey, Gracie Lou.
Hi. Is that Dylan? Yeah. Hi.
Hey, Lauren.
Oh, Betty.
Hey, Betty.
Hey. Hi. Hi, Dylan. Say hi.
Hello. How are we, everybody?
She was the number one here today. She was first in line. Yep.
There you go.
We got out here early. I was like, no one's going to be here. And Erica was here. And then everyone came pretty quick, though. But, let's see. There's the doors.
Why don't they let you in?
I don't know, because they like to watch us suffer. because it's the
Maybe.
government. So if we have to sit out here in rain and sleet and snow and 99-degree weather, they're gonna make us because they're not nice people.
No.
They're about making money. They're not about helping people.
Well, what do you think is going to happen today?
I think there's gonna be a dismissal because I've been manifesting it for like 13 hours.
What a dismissal today? You think it's going to happen today?
It would be
Ooh.
nice. We could all celebrate a dismissal and it'd be nice. I mean, they got nothing. They can't, I mean, the amount of stuff that has been exposed, I mean, I don't know, Mellow and Cosgrove are just corrupt as they come. And clearly we're not going away. Clearly this line will keep growing. Like, we're not going to let it go. So they need to dismiss it and just, oh, look at. There's Turtleboy. You guys, he's here.
He's here. Here he is.
Oh, yeah, sorry. Just kidding. No. Oh, don't do it. No. Don't. Oh, all right. Oh, that. Thank you. Thank you. He said thank you. Thank you. Woo! Woo! Yeah. Come on, dismissal day. Sign some autographs real quick. Lauren, are you doing yours right now? I don't know. Might as well.
Okay. Oh, nice.
Yes. What are these? We put you right to work. Let me go back up here. Sorry, Dylan. I like this.
That's all right.
I should have stayed up here.
Dolphin.
I don't know how to sing.
Hope I never see you again.
Love my Dana. Love the head. Love Scott McGuinness.
Thank you. Oh, I'm sorry. Love you guys. Dismissal day, it's fine.
There you go. That's Aiden
All right, here, I
arriving
gotta
in
give the
court.
phone back. Ross, give me my phone. Here, give that to Erica. Give that to Erica.
Thanks, Brandy.
Doors are opening. Huh? Yeah, of course they are. All right, I gotta get going, guys.
All right, darling. See
Love
you
you.
later. Love you too. Ta, darling. So there you go. Erica had to drop off there, obviously, because they're going into court. So Aiden's arrived, which is good. They're going into court right now. There's no stream open for court yet, as of yet, anyway. So hopefully they'll jump back on at the end as well. So, but it's all good. Hey, York City boy. Now, never seen this before. You know what? It's quite dull now, York. It's quite dull here right now. Is it nicer with you? Because it's not so nice here, if I'm being honest. It was okay today, though. The weather was okay today, in fairness. But yeah, York City, wow. Blast from past that is. Okay. You feeling sick again? Oh, no, J-Mac, that's not good. You're feeling sick again. So yeah, we will keep an eye out. I need to see where we can get the stream from. Nothing is up yet, so but obviously I have my sources, so it's fine. Aiden Cooney. Robin G, you are sweet. I don't think, has Robin G been called sweet before? I'm joking. Of course she has. Robin G is sweet. Aiden Cooney. Hearing. Right. No streams up yet, so I presume it's all going to be on Zoom rather than streams then. But that's fine. That's not a problem. Hey, Rolling Stone. How are we doing? Farmer's Market is going on. There's a French bakery that has the best pain au chocolat ever at the market. Oh, okay. I've not seen that. Right, let's look at this then. I'm going to get Young Jerks up as well. I know Mike doesn't mind. Mike isn't one of these streamers that goes around striking people. So Mike's one of the good guys. So if we do use Mike's stream, then please obviously make sure you go and like and subscribe, even though you probably are, but make sure you like his stream. Stream's supposed to start at 2:15 to 2:30. They've just opened the doors now for the public, which is good. Damn. Well, we had 200 odd earlier on. But obviously every stream in the world is going live now, so it's all good though. What's up? How are you doing, Forrest Dump? I still love this name, Forrest Dump. How are you? Nice to see you. Not seen you for ages. J Mac, you were so sweet. Robin G. No, hang on. You were so sweet, Dylan. Ignore Robin G. She's a big meanie head. I think Robin G is very sweet myself, J Mac. We'll post his link. Yes, we will. Yeah. I mean, everyone's here subscribe to him, but please make sure you like his stream if we do use it. I think we probably will use it, if I'm being honest. Forrest Dump, thank you for the 550 memberships. Thank you so much, my darling. I appreciate that. Who got them? Melissa. Oh, two Melissas. Melissa De Brigida. I don't know how to say that. Melissa Simcock. Scott McGuinness got one, actually. Melissa C. and Julie Keeley. So there you go. Scott McGuinness got a membership, which I'm glad about, because Scott does so much for so many people, and he deserves it. He's one of a kind. He's one of the best people you'll ever meet. Genuine, nice person. Even though people make shit up about him, he's a very, very good person. Well, I was in the consultant stream because he's on the stand for Cross. Oh, he's still on the stand, is he? Still on the stand. Lol, J-Mac. Delal, you're such a brat, I know, but you love me, so I love being a brat. Forrest Dump, Scotty deserves one. He does deserve one. He does a lot of work. Does a shit ton of work. There you go. I'm just going to jump on Mike's. So I'll post his thing in here, but we'll might as well just use his. Fuck it. As I say, Mike's not one of those streamers that strikes other streamers. Like, there are a few people, scumbags I call them, scumbags. If you strike another content creator, I think you're a scumbag. But Mike is not a scumbag, so it's fine. Boston Lisa's over there. Look at you, Boston Lisa. You doing dual streaming? Hi, Mike. Thanks for streaming. I am Piggy backing. Okay, so there's that. Right. We will get that up. I will do that. Hang on, I need to get this up here. So let us get his stream up so you can all see it as well. Or even if you just want to watch it with Mike, you know, that's absolutely fine as well, because in fairness, we are using his stream right now. So, do you know what? Let me bring it down for a second. And I will gift some memberships for him. So, as to say thank you to him, I'll gift 5 memberships. This will be my contribution to say thank you to Mike for use of his stream. I have to take it down because my bank details will come up. So, hey, Dennis Sweeney. So there you go. You can see the Alter Corner sent 5 Young Jux gift memberships. Oh, Boston Lisa got one. There you go. There you go. So thanks to Mike. I know, as I say, he doesn't mind anyway, but there you go. Fucking hell. Look who's here. Erin Hack is in the stream. No worries, Mike. So there you go. I was going to say thank you, but I'll thank him afterwards. Aaron Hack, you cheating mofo in both streams. Look at you, caught out there, weren't you? It's going to start between 2:15 and 2:30 is the estimate Aidan gave, but we don't really know. So one shot I'm not yet banned in. So hippie chick. Dennis Sweeney, how are you, sir? It's a warm one down there today. And Robin G got caught as well. Another cheater. I'm joking. I encourage you all to go over there and like his stream. And also, if DB, go watch it there. It's absolutely fine. I mean, I support Mike. I'm sure Mike supports me as well. So, Sea-Dog. Now, Sea-Dog, I have not seen Sea-Dog, the Sailor Man, for ages. How you doing, brother? How you doing? As I say, I've not seen you in what feels like probably a year now. I hope you're doing well. Hope everything's going well for you. And yeah, hope the Sea-Dog's a sailor man. Hopefully the sailing's going well, my brother. Aha! Soul Goodman. There you go. Right. I fucking hippie chick. There you go. I mean, all these cheaters. For once, I'm there as well, so we could all cheat together. It's for Mike. It's fine. We could all cheat together. I am just back here now. I will get confused and put something stupid in the other chat. So you're just going to put stupid things in this chat instead. Okay, that's fine. That's fine. Read my comment there. Let's have a look. Robin G. Haha, Iron Hat, they'll caught you. And is there anything else? No. I don't. I caught you all. Well, I thought you were cheating, Iron Hat. Always cheating. Always cheating. Nah. There's what? No. What else did you say? Hang on. I don't know what else you said. I can't. I'm going up. I can't see anything, Robin G. Oh, that was it. 5. I got you. You can't cheat. When I'm cheating myself, you guys are cheating with me. It's fine. Right, hang on. Aidan just tweeted. Let's have a look to see what Aidan tweeted. He says, "Big crowd of caught." He was. Dennis. He says, time for a trip to Unimpound Town. So this is Aidan. Let's get this up here for you guys so you can see it. Hang on. So Bradle's still not there. So Aaron Hack, you're always in the weeds somewhere. Let's have a look here. So this is what we got here. Hang on, let me share this then. I'll go off mics for a second and share this. Share. Oh shit, not that one. There you go. So Aidan Kearney, time for a trip to Unimpound Town. I'll save him in the toilets. Hopefully I'm not sure, men or women's toilets. I don't know, but because there's cubicles. So there you go. You can see Howie Carr's live, Young Jerks is live, Grant Smith Ellis is live, Dallas Cowboys is live, Las Vegas Raiders is also live. Robin G says, no limit to reach for the stars, no mountain too high. I've fucked up this song. Right, before we get going, you give me no choice. Let me just do this, and then we'll transition. I'll get the stream back up. So bear with me whilst I do this. Press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Right, so there's Mike there. He's there, so we'll leave that there for a second. So please make sure you like the stream. Let's look at Grant's chat. Do you want to look at Grant's chat? Okay, let's get Grant's chat up then. Hang on then, let's get into Grant's chat to see Grant's chat. Let me open her up then. Bear with me. Grant Smith Ellis. Grant Smith Ellis. I'm not going to put him on because I don't want to hear what he's going to say, but I am interested to see who's in his chat because he's a tool. Or as he says, oh my fucking god! I just heard him for 1 second. And I was like, oh my days. I caught that. I didn't. Right. I'm only going to put this on for literally 10 seconds, and then we're going off it because I can't stand when he goes off. He's got Peggy, Paula, Showtime. Right. What's he watching then?
Damn predators. Find out. I'm a towel. Somebody this morning was like, Grant, you say hilarious things on Twitter.
Oh, so
and I was like,
he's
well,
on.
you try dealing with this level of stress every day. Makes somebody wants to defenstrate themselves. Not actually. Defenstration is the word I use for frustration. Don't defenstrate yourself. Please do not do that. I would be very, very sad. If you look up the word defenstration and you think it involves fences, it does not involve fences. Let me just tell you right now, it does not involve fences. It is not a good thing. Don't do it.
I remember Peggy, wasn't she? She used to do the rounds everywhere for free Karen Reid. Did she go the other side or something? Anyway, that's enough of watching him. I don't know how he has video, Robin G. I don't know how he has video. That's weird. He's in court. He's in there. So he definitely has court. Right. Mike will have it though. Mike will get it. I mean, I could get it as well, but I just yeah. We'll just wait for Mike. It's easier. Yeah, how does he have it? Because Mike doesn't have it. Oh, hang on, maybe he does. No, he doesn't. I wasn't live. Now I'm live. Yeah, there you go. That's the same Kelly. Peggy. Peggy's a caps lady. Yeah, I remember her. Yeah. He is a weasel. He is an absolute weasel. Grant Smith Ellis. Jeepers. He's different in person, though. He is different in person. I'll give him that to what he is online. I met him in Dedham. He is different. You can actually have a... when there's no cameras around, you can have a conversation with him. But he's still a little bit out there, should we say. So, yeah, we'll just wait for... I don't know how he had that and Mike doesn't, but we'll wait for Mike. We'll stick with Mike. So, as I say, it's not supposed to start for another 7 minutes minimum. So Bradle was in Salem, so that makes sense. Salem, and then I thought that was Eden, but it's Adam Schefter. Oops, that's a bit different. So Brandy thinks that this will be dismissed today. I do not think that it will be dismissed today. I think it should be dismissed. Oh yeah, here he is, Scott McInnes. Scott gave us a really good insight earlier on about all the things. So yeah, you gave us a lot of good stuff there, Scott, and thank you again for streaming and conversing with us. Scotty, hey Dennis, Scotty was online with us in a little bit. Yes, he had another hearing in Salem, so he's expected to arrive at 2:15 to 2:30. Let's hope Dennis doesn't drive Tim from Salem. Driving Tim from Salem. Scott, you got a membership? Oh yes, Scott, you got a membership. Yes. Forrest Dump gave you a membership. So congratulations, Scott. You are now a member, thanks to Forrest Dump, who I've not seen for ages, not seen Sea Dog for ages as well. Bedro's not there for court today, KD. He's not. Okay, sorry, I'm just texting. I can't do two things at once. So Bedra's on holiday, so it would be good, Sea Dog. It would be good. But yeah, so he might be on Zoom, but he is on holiday, so it may not be. You know, so we'll have to see. Let's have another look here to see. I'll just do another search just in case. Right, no, I don't want UEDB. That's not the one I want. Let's do a quick search. It doesn't really matter. What will happen is once the court starts, we'll get video anyway, so it's all good. It's all good. I think most people are just waiting for the Zoom. Young jerks. Yeah, that's weird because Amy has it as well. Amy's got video as well. Grant, fucking hell. I don't even want to show you what Grant's doing right now. Yeah, everyone seems to have it except for Mike. I don't know why. And yeah, that's weird. Obviously, I don't know. I'm not on the Zoom link, so I mean, if you okay, I'll pause it. I'll bring it up. This is what Grant's doing right now. I've paused it. What is this? I don't even know what this is. What's he doing with that? What the fuck is that? What is that? You can do, Katie. I just don't have it. That's all. So if you get it, message me on Messenger if you got the link for it. That is what? What is that yellow thing that he's got on his lap? Doolan, I think. Doolan for today. Robin G, I think. I don't even know what he's doing with that thing.
Is a prior case at sidebar. Now, you might be saying to yourself, sir, why are you holding a fluffy bunny that you call
I was asking that. I was, yeah.
Pete bunny towel while sitting behind the bench? Well, I'm not actually behind the bench. I'm a sleeveless T-shirt to troll Sean McCabe. See my nice little tattoo?
Right. Thank you, Grant. That's my annual grant. I've done enough now. I've done enough now. Thank you, Grant. Hang on. How's Young Jerks? Is he? No, he's still there. Let's go. All right then. Okay, hang on. Well, I don't watch him, so I wouldn't even check that out anyway, to be quite honest with you. But Scott McGuinness, Braidl's walking in now. Okay, so they're about to start. Fine. Waiting for the host to start the meeting. Fine. Share screen. It's just Young Jerks. I don't know why his is not working. Yeah. Because he's got waiting for the host to start the meeting. So maybe they're just ticking everyone individually. Maybe. I don't know. Mike's just in line. I don't know. Maybe. So they're at Cyber. So it's in session. The judge is at Cyber, essentially. So Grant said that the judge is at Cyber. So he is live. Right, why is there nothing? Archie says Courtroom 1. I don't know. This is Mike's stream, so I don't really know why he's not on it, because everyone else is on it. Hey, Alex, how are you, my darling? Nice to see you, Alex. Nice to hear from you, Alex. No, he's not been accepted yet. No, I'm gonna just to appease people until Mike does get it. I'm gonna jump on. Hey, York City. Okay, I got you. I gotta jump on. What I'm gonna do is I'm going to jump on Amy and Kelly's stream. There's no
What we've talked about is defense investigator and the representative from the Commonwealth that'll also inspect will coordinate a date, contact Mr. Liu, that's the owner of the property, and it can be inspected at that time.
Okay, that's fine. So Judge, I'd ask the court to allow the order. So the landlord, my private investigator spoke with a landlord who would be cooperative as.
Okay, so Mike's changing it, they said. So hang on then. That does make sense though. So Erin, when they get back, tell me if he gets
One
back.
of two tenants. It appears the other tenant may be less cooperative.
Hey Julie.
I have to have him in front of me.
How are you doing, Julie? Hope you're well, my darling. Nice to see you. From Oregon, Duck County, Duck State. No, I know Amy won't mind. It's just I've given 5 memberships now, so I just want to make sure. Do you know what I mean? But yeah, please go and talk time with Amy and Kelly. Obviously, they won't mind. I know that. It's just more of a thing. There you go. Hang on. Oh, I
today before providing counsel with some other records we have received. If defense counsel signs it, then I would ask Your Honor to review and sign as well. I could end up.
Have you shown it to Mr. Sergeant?
Yeah, I'll sign it briefly, but
why don't you sign it? I'll sign it, and then we'll get done.
If you're on mute, please mute. I mean, if you're on Zoom, please mute your cell phone.
I believe.
Thanks, Katie.
And I believe.
College football, I love it. Beaver State, there you go. We got a few people from Oregon here, Julie. There's a few people from Oregon that frequent this chat and are very much Bo and Justin Herbert and fans. So yeah, Dave is not here, but he's 69 and from Oregon. He loves Oregon University. And your KD Santos as well from Oregon. Love it. Love our Oregon people here. Okay, hang on then. They've not started yet, so love the Ducks. There you go. Yeah, they've not. The court's not started yet, so you know everyone can chill out. Okay, I'll just put it in chat. This is their stream because we are using it. So if you can make sure you go and like their channel, so I give it a like there. That's 9 likes now. That would be great. Support the ladies over there. They're on sidebar, so that's why we are. That's why we can't hear anything before anyone starts. Yeah, no, Mike's not in. Mike's in room 25. I think they're in room 1 or something. No, Dennis is in Canton, Julie. But we're all Duck fans. We love Bo Nix, Justin Herbert. You know. They got off. Front bar or side bar?
And then motion to, and then, motion to impound. Hey, how you doing?
Thank you. Okay.
Oh my God. That's great. The Norfolk Superior Court, I'm sorry, the Essex Superior Court closed because the air conditioner. Yeah. Huh. So my God, Joe. Okay.
You're welcome, Julie. Welcome to the channel.
Yes, we did, yeah. And you went through it and everything? Well, no, I don't think it's from you, but there's an attachment that expire.
The links are invalid.
The links are you presume they expire. I presume it's the same. So they're gone or dead for us. Lost evidence.
It's a problem. No, they probably have a better thing.
They probably have what? Right, they lost evidence. I don't know now, they lost evidence. Yeah. Right.
Good afternoon.
Good afternoon.
Counsel, are we ready?
Yes. Yeah. Would you mind talking at the podium, because I can't hear you half the time when you're talking this way to the judge. It's my vacation. Sure. You're taking away my advantages here. Sorry.
If you get a vote on session, turn off your cell phone, please.
For the record, before the court numbers 4, 5, and 9, Commonwealth versus Hayden Carney, 23 CR 313, 24 CR 43, and 25 CR 88. Carney is present. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth.
Good afternoon. Timothy Bradle for the defendant, I bet. Nice to see you.
For the defense.
How are you? I'm Mr. Carney.
Judge, this is my client, Aiden Carney, in the middle.
Good afternoon. All right. What do we have today?
Well, we have a bit of an agenda here for you, Your Honor.
Go right ahead.
Can I go through?
Yeah, go ahead.
Thank you. Your Honor, we're back here on discovery issues that have been going on. As you know, the automatic discovery certainly is due at or before the pretrial conference, which was like over a year ago. And we've been going back and forth with this. And if you just peruse the docket, I'm not going to go through it because I know these kind of tedious discovery hearings are awful for everybody. But if you peruse the docket, you'll see all kinds of motions to compel. Yeah, sure.
Yeah. Yeah, go ahead, Mr. Bradle. I'm sorry, I left my notes. I took some notes.
No, that's okay. I appreciate you taking.
Yeah, and then I.
I'm going to wait for you.
No, Mr. Summers went to get it. Takes good care of me. Mr. Bradel, go right ahead.
Thank you, Your Honor. So if you peruse the docket, Judge, you'll see all kinds of motions to compel, and it's just not happening. It's just not happening. So putting the issue of, whether it's an intentional thing or a, just not getting it right kind of thing, nonetheless, we need these items. They're exculpatory. If this was just regular discovery, I might ask for a ruling that the Commonwealth may not use certain items they haven't given us, but this is exculpatory stuff that we need. One of the most important highlights, Your Honor.
So I went through it. These
Yeah,
are
go
what
ahead.
my notes are. You want access to different items in a form that you can see on your computer, right?
Right. We can't open what we got.
You want something about somebody that's allegedly a government agent, right?
Yes.
You want digital copies of some documents. You want videos that were taken by the Commonwealth of the rolling rally. The Brady list, right?
Yes.
All right. Is there anything else?
Yes, Your Honor.
Go ahead.
There's a whole host of items.
Yeah, go ahead.
So the first thing, Judge, is that I don't know if you heard, but it was all over the media, but we got 4,000 blank pages after we were here last time when the Commonwealth said, we gave them 5,000 pages. 4,000 were blank. And now the Commonwealth wants us to give back the thumb drive that has some things on it minus the 4,000 pages. So last time we gave something back, we never saw it again, and they still don't want to give it to us. And that's the Gattani extraction.
Yeah, I read that.
The redacted extraction.
There's another motion, a pro se motion on that.
Yeah. So, I'm sorry. Go ahead, Judge.
No, go ahead.
So it's been like 9 months, and we don't have the redacted extraction that the Commonwealth promised me. I look back at my emails on July 9th, 2024, saying it would be ready for pickup. And it just never happened. So now they are apparently doing a 180 in their filing saying, go get it from your friends, Mr. Carney. And I don't really understand that. I don't think it's a serious response. And the Commonwealth owes us the discovery, the redacted discovery. And I ask that you order that forthwith.
Okay. Let me hear from Mr. Cosgrove on that.
All right. Many of these issues, Your Honor, I addressed in my filing. I have been working diligently to get Mr. Bradel the discovery, despite some obstacles. If Your Honor would be kind enough to go through the list that you just went through with Mr. Bradel one by one, I will respond to them individually.
Yeah. The Commonwealth video of the rolling rally.
All right. The Commonwealth has provided at least 2 copies of the video to the rolling rally, one of them in the format specifically requested by Mr. Kearney. The last time it was provided was, I think, about 6 months ago. The first I heard that he was having a problem with it was the motion that he filed on the last date. As I indicated to Your Honor in my filing, I had notified Mr. Bradel of dates that he could come over to the office and we would attempt to show him the video and resolve that, which was his suggestion in the first place.
Oh, yeah, I remember reading
and I got no response.
Mr. Bradel, when are you going to go over to see Mr. Cosgrove and look at this?
So, Judge, that's a separate category, okay? I don't think,
Let me start with this. When are you going to go over to Mr.
Yeah, we'll be happy to go over it. We're not concerned with that aspect of it. We're concerned with the stuff that they were supposed to give us. We can put that aside, the stuff that they tried to give us and it didn't work, that it's not the right format. Nobody can open it short of Bill Gates. And, that stuff, I'm confident with our team, there's some really good computer people on our team that can figure it out. And we've said to them, just do this. and they haven't done that. So if we have to
Mr.
go over there,
Cosgrove
fine.
has said to you, come to the office.
Yeah.
We'll do it.
Yeah, we will, and that's not what this hearing is about as far as we're concerned. There's a ton of other stuff
Okay,
that doesn't require that.
that's fine. Go ahead, Mr. Cosgrove.
And the second item, Your Honor.
Let's see. I have, the Brady list.
I had indicated to Mr. Bradel that I would provide that information 30 days before evidentiary hearing or trial, whichever came first.
I think, and then you said you'd give it to him by September 3rd in your memo?
Yes.
I'll order that. I'll order you to give it to him by September 3rd. So that takes care of that.
What's next, Your Honor?
Okay. Let's see. We have, I think we get to then the, supposedly somebody working as a government agent.
Oh, that would be Catherine Peter, I believe.
Yeah. All right. So tell me about that.
Well, Catherine Peter is relevant basically to the Lindsay Gattani cases. She is a former employee, as I understand it, of Mr. Kearney. He and she had a falling out over issues that don't concern the Commonwealth long before this case was originated, and basically exchanged negative posts about one another. From time to time, she has emailed usually Lieutenant Tully.
No, I'm not interested in the specifics, but more so, I think in your filing that I have in front of me, you have replaced the defective thumb drive. Am I correct?
Yes.
Mr. Bradel, do you have that?
We do, Judge.
All right. So then that's taken care of.
Yes.
All right, great. All right, that's good. Provide.
Yes, sir.
Okay. So then we go to the next one, which is a digital copy of all communications from District Attorney Morrissey to civilian witnesses. And it gives a list of names. And then it says that from Mr. Bradel's point of view, that the Commonwealth hasn't provided complete discovery. Go right ahead, Mr. Cosgrove.
Well, I don't know what he thinks he's missing, number one. Number two, what the Commonwealth is obligated to do under the rule is to provide statements of witnesses.
Yeah.
It's not obligated to provide the electronic information which may accompany it, any more than when it turns over a photograph, it's required to provide who the photographer was, that sort of information. I think this information, I have an inquiry in, would be difficult to access and provide. The Commonwealth has spent literally days assembling statements of witnesses, which are voluminous because it includes all kinds of emails that the witnesses have made to the district attorney's office, and those have been harvested by means of an electronic system called ETOS by using term searches, and then people have gone through them and screened them, and I have screened them for compliance with Rule 14, generously construed, and those have been turned over. I can conceive of certain situations where electronic information might be exculpatory, and I think that's an issue that can be raised on a email by email basis. For example, if it were, if you had an email from somebody and their location at the time that they sent the email undid or provided an alibi or something like that, that would be exculpatory. It should be turned over. But in the ordinary course, all this does is provide information to the defendant that is irrelevant and is not required to be turned over. I think these are issues that can wait for a determination as we approach trial as to whether something is material and admissible.
Okay. Mr. Bradle, can you comment on that?
Yes, Judge. So this is the metadata issue?
This is the individual, well, it's a digital copy of all communications from District Attorney Morrissey to civilian witnesses.
Oh, yes. Okay. Thank you, Your Honor.
And it lists a whole slew of people.
Sure. So, Judge, the Commonwealth in this case has been going to the mattresses, so to speak, to keep this stuff from us. And meanwhile, the employer of the special prosecutor has released a FOIA of these items, which, just to move ahead for a sec, the fact that they released all this stuff pretty much obliterates this Commonwealth's impoundment privacy argument. But while we've been going back and forth with all this court time with keeping things secret from the defense here, the district attorney's office released 4,000 text messages from Trooper Tully as a FOIA request to the general public, while we, as defendants in a criminal matter with constitutional rights attached, have got nothing. So it's out there, this FOIA request from the employer of the special prosecutor, but not from this special prosecutor. So in terms of the integrity of this stuff, we need the special prosecutor here to give us the items in the context of this case.
The 4,000 text messages, were they related to this case, Mr. Bradle, or related to other cases?
Well, it's relevant to the Reed matter, to our matter, it's all the same alleged victims. It's actually emails, not text messages. Okay. But it's 4,000 pages of stuff that we've been wrangling back and forth about. Meanwhile, the district attorney's office releases them in a FOIA like a week ago. That has been bandied all over media while we've been trying to get this stuff for a long time.
Okay.
Yes, it's a good thing that we're getting it.
Yeah.
But we need the government in this case to give us what they are contending is that stuff.
Let me just go to Mr. Cosgrove for a minute. Mr. Cosgrove, were you aware of that?
The short answer is no.
Yeah.
It's, I guess, part of the price of having an independent special prosecutor, Your Honor. I don't work out of the office. I haven't been to the office within the last 2 weeks, I think. So I was not aware of that. I was aware that 12 news organizations had filed FOIA requests for information in the Karen Reed case.
Sure.
But I wasn't aware of what particularly had been released. I'll look into that.
Okay.
I will say that when Mr. Bradle says he's received nothing, that is flatly untrue.
Okay.
I agree, Judge. We got about 200 and something pages out of what was supposed to be 5,000.
So I remember the last time we were here, Mr. Cosgrove, you had said that there were 5,000 pages, so some large amount of pages. I'm not going to say 5, it might have been 3.
It was about 5,000. I think it was 4,700 and something.
Okay. Was some of that blank or?
Well, the only information I have with respect to that was a letter from Mr. Bedrow that arrived 5 days later complaining that the bulk of those pages were blank. I do not know why they would be. I haven't been able to figure out why they would be. As a result of that letter, I went back to the DA's office and sat down with one of their electronics people and had them make an entire new copy off of my laptop. And I actually added a little material that had come in since, provided by one of the prosecutors in the Reed case. But the bulk of it was the same 5,000 pages. I then went through that personally with the electronics person sitting by my side and ensured that each and every page was reproduced on the copy that I sent to the defendant. So,
have you sent that to Mr. Bradle or Mr. Betterow?
I've sent it to Mr. Bradle, and I'm informed that he's got it, so I'm not quite sure why we're still talking about it.
Got it yesterday, Judge.
All right.
So haven't been able to go fully through it.
Yeah, no, sure.
It supports all sorts of other things that we're here for as well.
All right. But you did get it. Okay.
Yes.
All right. Then the next thing would be, the next thing I see, and Mr. Bradle didn't think this was much of an issue, was the video of the Commonwealth surveillance from the rolling rally. Has that been?
I think we addressed that, Your Honor.
We can go to the office, and I'm sure that.
Yeah, okay, so that's fine. So that takes care of that. That's good.
Thank you.
And then,
Judge, before we move on, I don't want you to go too far off of this. So I know it's tempting to think that these 4,000 blank pages is the same thing as the 4,000 FOIA. They're different. So the first thumb drive thing with the 4,000 blank pages has been remedied, okay? But the FOIA thing that should have been given to us has never been given to us, but they're responding to FOIAs about it to everybody but Mr. Carney. So
I get that, but Mr. Cosgrove says he's going to look into that, and I'm sure he'll give it to you.
Okay, so I just didn't want you to think that was the same.
No,
4,000.
I didn't.
It's different.
Yeah, I didn't think that.
Okay.
All right, I didn't think that. All right. Then I think it's just am I correct, Mr. Bradle? Is that the list, or are there more?
There is more, Judge.
Yeah, tell me the rest.
All right, sure. So within the thumb drive, the thumb drive that was just remedied and given to us, there's all sorts of attachments, and we have a disagreement about this. There's all sorts of attachments from Ms. Peter to the state trooper team and Mr. Mello, I believe it was. I don't think Mr. Cosgrove was on the case then, where Ms. Peter is repeatedly providing attachments of things to the state troopers, and she's literally working on videos for the state troopers that were exhibits in the grand jury.
Let me just hold on for a second. Yep. Mr. Cosgrove, is that part of the 5,000 pages?
Yes.
All right. So then there, you got it at least.
I wish I could say we did have it.
Yeah.
If you hit the attachment, you get that message saying nothing's there. I printed out a few of them, but I'm sure you can just take my word for it, Judge. It says no attachment, nothing found, et cetera, et cetera. They don't come up.
So that's a technical issue. I'm sure you can figure that out.
So I think it's worse. I think it's it's actually a lot. Sorry, Judge.
Over again. He says you are good to go.
Yes. All right. I'll see you shortly. Okay. Thank you very much. See you in a minute. Thanks. Bye.
Bye-bye.
Bye.
So, Your Honor, it's actually...
When does the Zoom?
Yeah. It's actually a lost evidence issue, Your Honor. It's not gee, we can't open it issue.
Yeah.
It's gone. I think they lost the evidence. And for whatever reason, the attachment has been taken away on the other end, okay? So this is a real bit of prejudice and a distinct bit of harm to the defense that Ms. Peter, who is a government agent, who's provided, and we'll get to this.
Let me just ask Mr. Cosgrove before you go into all of that.
Sure.
Mr. Cosgrove, to the best of your knowledge, has that been turned over to Mr. Bradle and Mr. Betterow?
Has what been turned over?
Has any of the attachments that Mr. Bradle has just referred to?
Depending on what the attachment is, some of the attachments are visible simply by clicking on it. Others that specifically Mr. Betterow has inquired about, to the extent that I can resurrect them, I have sent them along to him and will continue to do that. I haven't worked my way entirely through his letter. But what happened, Your Honor, is this. Lieutenant Tully, who was the recipient of most of these, has the practice of not clicking on unsolicited links that are sent to him on email, so he doesn't access them. Now, if someone is sending him a reference to something that is online, he may check with that person and ask the person, where can I find it online? And then he will go himself and look for it online. For example, Mr. Kearney's YouTube presentations that were introduced to the grand jury. All of those were things that Lieutenant Tully found himself online. He may have been pointed to them by Ms. Peter. He may have been pointed to them by one of the alleged victims who complained about them. May have been pointed to them by multiple sources. But he never clicked on whatever it was that was sent, in part because he's working off a computer system, an office computer system, and there's caution about infecting it with unsolicited links. So these were never accessed, in effect, by the Commonwealth. If the links are now dead, we've never seen them. The links are dead presumably because whoever sent them took them off the internet. So
this would be some text from somebody with a link to a video or something else. And so you'd have the text, but not what the attachment is?
You'd have the text, you'd have a link to a video.
I get it, okay.
You click on the link now and nothing happens. Whether if Lieutenant Tully had clicked on the link 6 months or a year or 18 months, it would have taken him somewhere. Probably would, but he didn't.
Okay, gotcha. All right. Mr. Bradle.
A couple of things, Your Honor.
Go ahead.
A bit of a red herring to kind of suggest that, oh, some crazy person from the internet is sending me something and I don't want to look at it. That's not this. This is a government agent, Catherine Peter, sending them stuff that she's working with them. And you know, you mentioned an evidentiary hearing the other day, Judge. I think we should have an evidentiary hearing on this discovery stuff. Let's bring in Mrs. Peter and let's find this stuff because this is important stuff, and I'll tell you why in a second. But this isn't some unknown person. This is someone who repeatedly emails the state police and Mr. Mello, so in other words, and the government and the prosecution and the Commonwealth, and is actively assisting the Commonwealth, providing links to certain things. So they're gone. And so let me just jump ahead. One of the things that's missing is Miss Peter, and we know this from the new emails that we got last night. Miss Peter changed the titles of Mr. Carney's shows that were these 4-hour shows, Your Honor, that had innocent titles, like, you know, for example, Karen Reed case, where's Michael Proctor? Amiri King wants to fight Turtleboy, Canton updates, Anti-Bev Canoni out of control. So it's a title that encapsulates a 4-hour show. That was his work. Ms. Peter changed those titles, provided it to the Commonwealth, told Lieutenant Tully in the emails that we have about changing the titles, so they knew. And then they put those titles in as exhibits. We found this out, of course, after the McCarthy-Odell motion. And these titles are different. These titles are very incriminatory, and they suggest they impact Mr. Carney's alleged intent to intimidate witnesses. The titles were all changed, and I can proffer up a spreadsheet of the actual titles and then what she changed them to in these attachments that, oh, gee, now we can't open them. So do the math on that, if I may approach, Sean.
Yeah, sure. Thanks, Tom.
And so we have now learned that we have a grand jury that was listening to these video clips with titles like, you know, I'm going to kick Colin Albert's ass. And that's just me paraphrasing, but nasty titles. Give me another copy of this one. Yeah. Trying to destroy Colin's life. The actual title is Commonwealth tells more lies about John O'Keefe's GPS data. That's his real title. And these were suggested to be Mr. Carney's expressions, which of course would be used as his bad intent. And they're false and they're lies, and they were done, and we know this from the emails, from this Catherine Peter person.
Yeah, but so what does this have to do with?
So these are attachments that we can't open. There's an example of attachments that are exculpatory and incriminatory to the Commonwealth that we can't even open. So
these YouTube, so on the side of the document where it has the link, your allegation is that you can't open up any of these.
No, I'm sorry. That's if you wanted to see for yourself. But the other two columns are what Ms. Peter made those titles.
Yeah, no, I get that.
And then the regular title.
She changed it.
Yeah, and that was used.
This document, she changed it.
That was published to the grand jury as Mr. Carney's work. And it was even argued in Mr. Cosgrove's, one of his recent filings, he argued that, about how these things are so aptly titled, is what he wrote. You may remember that. And this is all false evidence.
Okay.
So, you know, this
is looking for us to do with it, though.
I'm looking to ask to take you up on your offer to have a hearing on an evidentiary hearing where we bring these people in and we get to the bottom of how Ms. Peters' work for the Commonwealth went. And that also impacts, and see, this is all interrelated, Judge. We want Attorney Mello on the stand for this too, because he's the one that presented this false evidence to the grand jury.
I'll take a look at whatever you file, but I think we're kind of getting off track a little bit in terms of what the Commonwealth owes you. That's what I'm concerned.
Okay, I hear what you're saying on that issue, but we did file a motion to disqualify Mello, who's been, you know, not able allegedly to be here, but he can be on Zoom. Whenever there's a hearing where Mr. Carney's bail might get revoked, he's right on the Zoom watching. But you know, that's another thing we'd like to do here today is ask the court to schedule an evidentiary hearing on.
Gotta write a motion.
We did, Judge. I filed two
for an evidentiary hearing. Is there a new one?
Yes, a motion to disqualify. We have two pending. In fact, Judge Rayburn, I believe it was, set the hearing, and he alleged that he was sick and couldn't come, and it's been in abeyance forever. Okay. So we have, Judge. I don't want to, you know, bury the court.
Talk to you, Mr. Cosgrove. Sure.
Did you see when they mentioned about Mello, about getting him to testify, the judge instantly went, let's put that in writing, let's put that in right. He didn't like that. He's never ever going to allow Mello to come up to testify or be questioned. So no chance. So this is, oh, thank you. See, Josie, Jersey Jen will still stay. I am trying to keep my man boobs under control. This is an insight into all of you about. I'll tell you now after this.
So you see, Judge, how everything's interrelated. And with respect to the disqualification issue, this is another issue where Mello's involved in this, what we would contend is a conspiracy to put false evidence in front of the grand jury that we figured out. And it was used and argued it was a misrepresentation of Mr. Carney's intent. Because when you would put a title like that on something.
So this is what I'm trying to get you back to, though, Mr.
All right, go ahead, Judge.
What do you need? What else do you say that Mr. Cosgrove has as the special prosecutor that he hasn't turned over to you? We went through that list of items. I just want to get you back on track.
Sure, okay. So, Judge, there's a November 1st email that we can't get the links off of that, and that's important. If I could just have one moment.
Yeah.
And that's the exact email with the links to this, fake links to this that we can't open. And it's not a thing like, it's not a thing where, oh, well, let's go back to the office and fix it. It literally says, Google Docs, it says, sorry, the file you have requested does not exist. So it's gone.
Okay.
So why did this person make it go away? And I think we know why, but that's why I want to ask you for that hearing too. But so we want the government to, in writing, tell us what links they have and what links, where did they go? We want them to respond in writing to why there's lost evidence.
Okay, let me just talk to Mr.
They have what we have, and they can figure out where they went to the same extent that the Commonwealth can. The Commonwealth has not deleted any links.
All right, I'll take that under advisement. What else you got?
It says, Judge, literally, the files have been deleted.
Okay.
It doesn't say they've been deleted by the Commonwealth.
So would the court consider ordering the Commonwealth to, we'll tell them what links we can't open, and they need to give some sort of an explanation why this is lost evidence.
Why don't you give us a list of the links that can't be opened?
All right, thank you.
And send it to Mr. Cosgrove and Mr. Cosgrove, but just ask perhaps if you give us an explanation as to why they can't be opened.
Sure, I will give you an explanation. I will consult with our experts, but I can almost guarantee, Your Honor, that the explanation is going to be that whoever is at the other end of the link removes the content.
That very well might be it, but I think if it was in writing, it would probably be the best.
Yeah, I'm happy to do that, Your Honor.
That's great. What else, Mr. Grader? What else?
So, Judge, we talked about the Gitani redacted extraction, excuse me. So can I get a copy of that? We don't have it. We've been looking for it for 9 months. Can you order?
What is it, the redacted?
The redacted extraction.
Okay.
Of her phone.
So you had the document at one point.
We had it. Judge Krupp ordered us to destroy it and give it back, which we did.
Yeah.
And it was 9 months ago, we never got it back.
The redaction back.
Right.
Okay. Mr. Cosgrove.
I object.
Okay. Tell me why.
Well, there's a long history on this, Your Honor, and I went into it in one of my memoranda at length. In the original course, the Commonwealth and the defense entered into an agreement that they would return the original extraction and that we would provide them with a redacted version limited to those things that we felt they were entitled to under Rule 14. I asked Lieutenant Tully to prepare that. He did that. I sent Mr. Bradle a notice. I don't recall when, but the date is in my memorandum saying it's available at the office. Come over, pick it up, or let us know how you want to get it. And I believe I also indicated that there was some additional material on the thumb drive with that extraction. Mr. Bradle never picked it up. In the meantime, came back to court for various reasons that are, I believe, still presently impounded, although I believe Mr. Kearney referred to them on one of his YouTube shows. For various reasons, Mr. Bradle indicated that he needed to keep the original thumb drive. Those reasons were unrelated to any issues in this case, but I was persuaded that he should be able to do that, at least temporarily. We struck an agreement with respect to the use of that thumb drive, and there was a subsequent reduction of that or a modification of that to writing at Mr. Bradle's request that was endorsed by the court. And then in the Commonwealth's view, which the defense, I believe, still disputes, Mr. Kearney immediately went out and violated those restrictions. So I then filed a motion in front of Judge Krupp requesting an order that the thumb drive be returned. Now, at that point, Your Honor, the defense had the full unredacted thumb drive in its possession, custody, and control for some 9 months. Mr. Kearney had publicly stated on his YouTube presentations that he had provided the contents, a duplicate of the contents of that thumb drive to any number of other people. But the physical thumb drive was ordered returned by Judge Krupp, and it was returned. In the meantime, the defendant had been presenting what I would consider to be various material irrelevant to the case, designed to embarrass and humiliate Ms. Gattani. There was a reference, for example, to her DoorDash orders. There was the defendant picking out a phone number more or less at random and said, well, here's a number that she apparently calls a lot. Let's see who this is, and calling out the number live and dialing it live on his YouTube show. There was a reference to her ex-husband's daughters, if I have it correctly, and what they thought of Ms. Gattani, so forth and so on. Judge Krupp allowed that motion at a provision that I agreed to, but I think was initially suggested by Mr. Bradel. The defense was allowed 2 weeks before they turned the thumb drive over, or approximately that amount, to take notes on anything they thought was relevant on the thumb drive, and then it was returned. As far as I'm concerned, they had it. They had an opportunity to examine it. I assume they did examine it. If they have time to go into the kind of trivia and side roads that Mr. Kearney went on to. I don't think at this point that the Commonwealth has an obligation to jump through further hoops and re-provide them with a different version.
All right, I'll take that under advisement.
May I be heard on that, Judge?
I think you already were. But I'll give you 30 seconds. Go ahead.
Yeah, Judge, there's no violation. If there was a violation by my client, I say bring it on. There's never been an allegation of a violation. If there was a violation, you know this Commonwealth would have done something about it. There was never a violation. They agreed to give it back. We don't have it. We were allowed to take note of it, but we were ordered by Judge Krupp to destroy it and not have any of it until we got the redacted one back.
Let me ask you this. Did you have it for 9 months?
Yes.
Thereabouts?
Yes.
Did you have a chance to look at it?
Yes, we looked at it, but we were told to destroy it. We don't have any evidence from it. It's destroyed. We were told, ordered by Judge Krupp to destroy it. We need another copy of it. We need the extracted copy of it.
You need the redacted copy.
Right. We're happy to take the redacted copy,
That's
of course.
Fine. All right, under advisement.
All
What
right,
else you got, Mr. Bradle?
Judge, so just have one moment, please.
Yeah, no, take your time.
Judge, impoundment. As I alluded to earlier, the fact that the sovereign of the special prosecutor here has already released much of the items the government here is trying to keep private, I think it's completely...
Are these impounded or under a protective order?
Judge, I would say that I don't think it matters, Judge.
I think legally it does, doesn't it?
Well, it's a similar examination, Judge, okay? It's a protective order. Things are impounded by either a judicial order keeping judicial documents private, or you could say, and I think the parlance is that if something is under a protective order, it's impounded from view from people.
Right.
So I think it's just sort of a parlance issue. I think, frankly, the government was splitting hairs when it was trying to say
but
that.
You have all the documents, right? Everything that's under a protective order, you have as the county's lawyer.
Judge, we have the documents that are under a protective order, because as I alluded to last time, you know, we're sort of under the gun of having to agree to it to get them, and we need these documents. So at the time, but this is a serious deprivation of the public's right to know, Judge. The public is the victim here. And, you know, these are documents that are kept private for no good reason. Whether it's, you want to call it an impoundment or a protective order, there's no legal basis for it, Your Honor. As I said last time, things that show government malfeasance.
What's the basis for a protective order, though? We were discussing that today. Do you have any case law that you could point to on exactly what it is that the government, the hoops that they have to jump through to get a protective order?
Judge, I filed 8 pages on it last time.
Yeah, but what's the, give me some of the cases that you think are the most important. Because that was actually something we were working on today, trying to.
Well, Judge, the first order of business on that is that the burden's on the Commonwealth here.
Yeah, no, I agree.
So,
I agree.
you know,
Maybe I should ask that question to Mr. Cosgrove. But I'll ask it to you first, and then I'll go to Mr. Cosgrove, because the burden is on the Commonwealth. I agree with that. But these protective orders are already in place. So I understand you have the constitutional argument that you and Mr. Betterow have profit about the public's right to know. I get that part. But just in terms of a practical.
Thank you.
Yeah.
1 second, please, Your Honor.
Yeah. No, take your time.
So, Judge, paragraph 3 of my filing last time, Aiden Carney's motion to release case documents from impoundment. Paragraph 3, New England Internet Cafe, LLC versus Clerk of Superior Court, Suffolk County, 462 Mass 76. Public has a right of access to judicial documents and a right to understand and observe the operation and work of the judicial branch. They're presumptively public documents. There's a common law right of access to judicial records. So that's sort of that's where we start, is that these records need to be in the public's view. And so the burden is on the government to say why. And then just to carry through, just going to allude to what I said last time, is that when there's corruption or malfeasance, embarrassment, that's not a reason to hide documents from the public. That's a reason to show the documents to the public of the government's missteps. And in this case, there's been a lot of them. And that's really what the government is saying, like, oh, we can't have Mr. Proctor's emails because there's a safety issue. You know, there's always a safety issue. It's either children or a safety issue. There's no safety issue. There's no children involved. It's just embarrassment. He's well on record to show all sorts of horrible things that he's said in his texts or emails or wherever. But, and so the idea that we're going to hide any more of it is ridiculous. And the other issue, Judge, is that of the ones that we get, there's never the full story. There's like one screenshot of someone's text, and then there's no responses. There's no, you know, there's just a one little thing that they hope we're going to look at and be satisfied with. There's never any context to this stuff. So that's another discovery aspect.
Let me give the floor to Mr. Cosgrove then about the protective orders. I agree with your filings, Mr. Cosgrove, that these are protective orders as opposed to impounded. So I'll start with that.
All right, Your Honor, and let me just say, as I previously indicated, the release of certain public records is new to me. If Mr. Bradel wants to go through the public records that were released and compare them with the material that is presently under protective order and identify any of those particular things, I'm happy to assent to their release from the protective order, because obviously if they're out there, they're out there, and the protective order isn't really serving any purpose as to those particular materials. Now, with that said, in terms of cases, Your Honor, I would direct Your Honor's attention to the case law in particular cited on page 2 and 3 of my brief that talks about the validity of discovery orders in terms of discovery protective orders as opposed to things that are actually documents filed with the court. I think that's the pertinent case law to direct you to.
Okay.
I would also, Your Honor, like to direct you, if I could, to a YouTube presentation, which is essentially a commentary on the opposition I filed. Mr. Kearney did about an hour and 10 minutes of his own commentary on my filing. It's in YouTube episode 795, entitled, and I'll leave it to the defense to correct me if I get the title wrong, Cosgrove Gets Frisky, What Happened on the Cape, Twitter Shenanigans. And if you start at about 141 at that presentation, and if you can stand it, Your Honor, follow through to about 350, you'll hear Mr. Kearney's explanation as to what he wants these matters released for. And I would characterize his comments somewhat tendentiously as saying, apart from some quibbles about whether I got the titles of his YouTube shows correctly, Mr. Kearney's response is, everything Cosgrove says I want to do with these documents is exactly what I want to do, and so what?
Well, Judge, if you look at my filing, there's about 35 cases in there that talk about all this stuff dead on point. And there's no Turtleboy exception to the First Amendment, okay? Everybody out there has got this stuff, and Mr. Kearney is not allowed to look at it or use it. It's ridiculous. Every journalist on Twitter is citing this stuff, and he's got to sit here. The guy that broke half of the stuff in the Karen Reed case, he's got to sit here and not touch it, and not do anything. It's ridiculous. It's totally abhorrent. And
so these 400 things that were released on the FOIA request.
4,000.
4,000. 4,000. Oh. Do you have a copy of those?
Everybody's got a copy of those.
Yeah.
I don't have a copy, Your Honor, but I assume I could get it.
I'm not surprised.
All right. Perhaps, I know it's voluminous, but...
we can give you a link, Judge. It's easy. It's nothing.
Okay.
You'd like a link?
Yeah, that's fine. If you could just maybe write it out.
No problem.
All right. Do we have anything else?
We do, Judge. I'm sorry.
What else we got?
A lot here today.
I just would like to make one more submission.
Yeah, go right ahead.
With respect to the issue that we're on. One of the points that I made, Your Honor, in my memorandum is that there's a cycle here, which is that Mr. Kearney continues to post things about the witnesses in his case and the Karen Reed case on a regular basis. That provokes typically the witnesses to complain to the district attorney's office. That generates statements which need to be turned over in discovery. And I made the point that turning over much of this material, I don't know what public interest there is, for example, in an email where someone says she received an anonymous threatening phone call, which she attributes to a Kearney post, whether rightly or wrongly, other than to, I just don't know what the public interest is in that kind of thing. The public does not have an interest in going through everybody's cell phone, underwear drawer, et cetera, et cetera. So just to drive home the point that Mr. Kearney is continuing on a almost daily basis to publish tendentious commentary about these people, I want to call to Your Honor's attention something that came to my attention this morning that he posted 24 hours ago. If I could.
Yep, let me take a look at it. Thank you.
I think he missed a few of his usual targets, but most of them are there. I'm not suggesting that this is a violation I'm not suggesting that it's criminally actionable. I am suggesting that it would help Your Honor conceptualize the use that he's going to make to any of this material that's under protective order.
Tell Cosgrove to shut up. What has any of this got to do with this hearing or this trial? People are in their feelings. Tell them to grow up.
Okay. I looked at it. I get the point.
All right, that's all I have, Your Honor.
All right. Mr. Brito, what else you got?
Judge, I can, just watching you peruse Mr. Carney's publications, okay? Thomas Paine, Samuel Adams, Mark Twain would be spinning their graves if they saw that a judge was looking at First Amendment protected satire, jokes, criticism, as if there's some risk that this stuff should be sanctionable. It's just completely antithetical to the First Amendment, Your Honor.
Okay, I don't want Mark Twain to feel poorly about me.
Really?
So,
Judge, it's just ridiculous. That the government, you know, proffers that as some sort of evidence of something is just completely beyond the pale, okay? This is all First Amendment protected.
I get your point. I get your point.
So
you've made it very well.
So there's a few more things, Judge, about this impounding these.
The impoundment I get. So I get your arguments on that.
One little
fact. Do you have any other discovery issues?
Yes.
What else you
I'll
got?
give you one quick fact.
Yeah.
These people that the government is trying to protect with these impoundment orders that they need, or protective orders, they're doing interviews. The McCabe, the Alberts, Proctor, they've all done nationwide interviews. And yet the government wants to say, oh, we need to protect them from safety because of keep their stuff private. They're doing interviews. So that ship has sailed, Your Honor. All of their stuff needs to be unimpounded for our use, for our ability to use it without these constraints, and for the public's right to know, Judge. It just needs to be out there. There's no reason to keep it.
No, I get your point. All right. Is there any other pieces of discovery that,
yes, Judge,
that you want to argue about? Because I have, I got some other things we have to do, some other cases. We have 2 other cases left. Mr. Brito, I don't want to rush you, but
going back to the Mello issue, Judge. So Prosecutor Mello was the one that was working with Ms. Peter on these phony clips, and we need his emails too on this stuff. And I hope you're not going to say, oh, okay, file a Rule 17, because I did that with respect to Morrissey's emails, and I was told by Judge Krupp, and I think it's the law of the case now, that no, that's a Rule 14 issue because it's in the possession of the prosecuting authority. So it should be Rule 14 discovery that Mello is communicating with Kate Peter, and it's been undisputed and it's been revealed in this case 100% that Mello's been talking on the phone with the other complainant here, Gattani, and we have only incomplete screenshots and inconsistent screenshots with respect to what's on the phones versus what really happened. And we need a written explanation from the government as to why there's inconsistencies in the discovery, and I'll tell you what that is in a second. But also, we need the full text report. We have these cherry-picked little texts. And like I said before, it's obvious that it was a string, and we get like one email with no responses or no prior context. And it's like they're hoping we just go away as they give us one thing. But it's not, the context isn't there, the full email strings aren't there. And we've made this complaint many times and it doesn't go anywhere. So I'd ask that you order the Commonwealth to either give us the stuff or respond in writing why they can't find it, don't know what I'm talking about, or whatever their position's gonna be.
These are the Mello emails you're talking about?
So we want Mello emails because he's talking directly to Gattani and Peter.
Yeah.
And we have a couple snippets of them. but it's clear there's other ones from the context that we don't have.
All right, I got you.
Yep, thank you.
All right, Mr. Cosgrove.
Well, I believe I turned over the Mello emails in the last round of discovery, and that generated a chiding letter from Mr. Betterow saying that you've had these for a couple of months now. We should have got them sooner. So I'm not, so far as I know, they have the Mello emails.
Right.
Okay. That being said, I think we should pick another date.
So Judge, just the last thing on that. If I
No, go ahead.
Sorry.
No, go ahead. That's fine.
For example, Judge, there's a very important group text between Morrissey, Proctor, Tully, and others. And we have like one email from it that points up an extremely provocative issue relative to Proctor saying, why don't we just arrest them about my client? And there's no other discovery on it. There's a perfect example of cherry picking, why we need answers on this stuff. We need more. And there's also, Judge, there's inconsistencies in what we were given, where there'll be, and here's my last thing. Well, there's a list of text messages from discovery that we've been given. And then online, Ms. Peter, it's related to this Ms. Peter again, she publishes a string of text. It's the same string, and there's more emails, or text rather, there's more text in her string that she published online than in the discovery we got. So it's kind of a smoking gun that something was taken out of the discovery we got out of an extraction. And sure enough, we checked with Celebrate, the extractor has that ability to unclick a box to deprive the recipient of something, and the recipient has no idea. So there's a smoking gun here, Judge, that's why this isn't a normal case. I don't think you've ever heard me talking this deep about getting discovery. And here we are because of real reasons, Your Honor. And I hope that the court can give us this relief.
Okay.
Thank you.
All right, why don't we pick a date or anything further that you might have?
Does the court want to suggest a date? I haven't had too much luck suggesting dates myself lately.
We think September?
So, Judge, in the meantime, would the court order production of some of those written responses? And
yeah, I'll issue an order on the written responses.
Thank you.
I'm sorry, what written response?
I think he's asked you to give written responses as to, for instance, the links and things like that. What can be open, what can't.
Oh, yes. Well, I just indicate that Your Honor indicated that Mr. Breda was going to provide me with a list that I would respond to. So I would just hope your order would take that into account.
Fair enough, Mr. Cosgrove. Fair enough.
And Judge, just to the suggestion that, we should tell him what links we can't open. We can't open a single link. There you go. Compliance.
All right. Give me a date that works for the both of you.
September
24th, 25th?
I can't do the 25th.
24th is fine.
That'll be at 2 p.m.
We'll see you on September 24th at 2.
Spicy Bradle.
Mr. Carney, your cases are continued to September 24th at 2 p.m. for further discovery.
Okay, thank you all.
That's a Wednesday, 24th. Wow. Spicy Bradle. Thank you. Oh. Hang on, hot mic, hang on.
Cite that as some sort of problem.
Hot mic.
Or Ethan. He's not here.
Damn.
Hey, Colin. No.
Okay, that's the end of it. Fine. That was annoying. Right, what I was going to say earlier on was this, right? This is a prime example of the Commonwealth playing games. Imagine this, right? Imagine if this was you going through this, how much this would cost. I'm not saying that Aiden's lucky, because that's not what I mean. I can't get the right words here, because obviously Aiden would rather not be prosecuted. But like, people are donating, he's got a good show and stuff. But you guys here, myself included, this is why people take deals, or this is why people get public defenders who are rubbish, because it's all about that. Osito says the money, the moolah. Most of us would not be able to afford this. Attorneys cost thousands upon thousands, tens of thousands. So all these additional hearings cost money. The fact that we now got an additional one on the 24th, 25th, whatever it was, of September, that's more thousands of dollars. Today's cost Aiden however much for Bradle to be there, the work that Bradle's put together to be there, obviously Bedro as well. This is, you're talking about, this is going to cost Aiden hundreds of thousands by the end of it. So these additional hearings are the reason people are taking deals. This is the reason why people, can you imagine, Bradle, right, is a top-notch attorney, like probably one of the best you can get in Massachusetts, especially. The fact is, if you're a public defender doesn't give a shit about you. Public defender's not gonna like push for you. They just be like, yeah, whatever. They're not gonna look at your case. They're just gonna turn up, half-ass, and then push you into doing a deal. And if it goes to court, they don't really care, because it's like, who cares? I'm not saying that that's true about all attorneys, but most public defenders probably don't want to be there. So this is just an example of how the Commonwealth do these kind of things to try and drain you. They did it to Karen Reid, and they're doing it to Aiden now. So to us, it's just another hearing. To Aiden, this is like tens of thousands again. The Commonwealth doesn't care because they are spending our money. The Commonwealth they got so much money that makes no difference to them. They can spend it on Cosgrove, everything, you know. It's not. It's been moved, Coco. It's going to be next year now. Aaron Spencer's trial is going to be next year, my darling. I believe it's going to be in January, I think, but it's no longer in September, my darling. I wanted to hear the next case to see how. Oh, okay. Hang on. If it's on, we will. Okay. We. Oh no, he's ended the stream. He ended the stream. Sorry. I'm getting paid to spend. So yeah, Cosgrove, all these people, they literally don't care. They're just like that. They got money. They rub it on their titties, and they just enjoy it because they know. If Karen Reid was a waitress, she'd be unjustly in prison right now. She would have had to take a deal, or she would be in prison right now. Yes. And people might think, oh no, she wouldn't. No, she would be, because the might of the Commonwealth would have thrown everything at her. She had to have Alan Jackson. She had to have obviously Yannetti, Little, Bob Alessi, all those interns, all the paralegals that we don't know and see, all the experts. She would never have been able to afford Arca, Dr. Russell, all these people. So unfortunately, it's true. If you don't have the money, you'll be ended up in prison. You have no chance. No, you wouldn't. You wouldn't. It's very unfortunate, you know. Kicked out. Yes. There's some good public defenders, punch a clock on. Yes, I agree. There are a few, and there are obviously a few that will do it pro bono. You know, I'm not talking about current people now. I'm talking. There are some. There are attorneys that have to do X amount of pro bono work per year, and they will. You know, you're lucky to get them. Happy days, but they're like 1% of the makeup. You know, so yeah. Unfortunately, it's very low. And also, if you get a public defender that is very young, eager, wants to fight, you know, make a name for themselves, again, that's different. No, they don't. Morrissey has to beg people for it. I don't know what that is for. Sorry, Robin. I don't know what that message is for. No, they don't. Morrissey has to beg people for it. I don't know what that is. I was just being nosy. I know. You're a nosy bitch. I know. But most people here are nosy. We figured that one out. It's all good. I figured I did. That's why all courts need cameras live. Yes. State has money. Yes. You know, they do. For noble trials. They find ways of doing it. You know, Morrissey had to ask the Speaker of the House or Speaker, wherever he was, for extra money. But he would have spent the money anyway. He would have found the money somehow. There's endless pots for them. They push the can down the road. He would have spent that money and then added on to the next year's budget and then added on to another year's budget. They can spend whatever they want. If they're determined to prosecute somebody, they will find the money. It's never an issue. It's never. It's the same for every state. You know, that's why they can spend millions on cases, because in the moment right now, sometimes they don't have it, but they get it from other portions. Also, some of them are political, so they get political parties that donate towards cases and stuff like that. So they would have had more. If they wanted another billion, they would have got it. Cosgrove Show, the judge, TB Richard Madness. Oh, you know, that's just ridiculous. You know, as Bradel said, like, this is ridiculous. Judge isn't corrupt. I think he's trying to show respect to Cosgrove. Yes, I agree. He's trying to be respectful. I do agree with you there. He's trying to be respectful. But I think he's cracking up because he's like, this is a joke that we're even here, you know. So most public defenders have to take an enormous number of cases to make a decent living, so they get overwhelmed. Absolutely. Absolutely. That's also true. No state doesn't have money more, so you have to beg. No, but yeah, that's just a thing. Anyway, I covered that. So not only that, but public defenders can't get a top-notch, expensive experts. No, in a lot of cases, public defenders, so they get allocated. So for people that don't know, you have to put in a request for stuff. So for Sarah Boone, for instance, they had difficulty in securing experts for her because the court or the state would only pay X amount for a state expert, and it would be something like, say, $50 an hour or something, where they might want to charge $120. It's at the discretion of the state, but 9 times out of 10, it wouldn't be. Later, yep, and I bet he didn't want to crack up. There you go. Robbie G. Morrissey went to the state for the extra million he wanted for current retrial. He was over his budget and was asked for more. Morrissey went to state for extra million he wanted for current read. He was over his budget and was asking for more. Yes. Let's talk in steps about it. Yeah, we'll go and watch it in a little bit. We'll go and watch it in a little bit. Why are we live? Because RTS is live. I'm not going to punk their stream. So, respectfully, it's Sarah Boone, so that's true as well. No, I got it. I miss Wise. I got you now. I know. No, I don't want to, spike their stream. If they're streaming, we'll watch it in a second now. My thought exactly. Wicked, psyched. Brennan Aperture. Thought. Oh, you were saying thought, yeah. Anyway, there's a lot for that. All right. Grant's. Oh, what's Grant's? I had him up just now. Don't know why I had him up, but he was up on my stream right now. They're still going wild. The financial disparity is even worse than the federal level. That's why they have a great conviction rate. That's true as well. That's true as well. When a defendant sells their home, the feds know they're ready to take a plea deal. Yes. It sucks, do you know what I mean? It sucks, you know? There's, I always use the thing about Matt Moore. He's a millionaire and he lost everything to pay for his bills and stuff, you know? So it all sucks. Right, hang on. Bye-bye, baby. Say goodbye. I don't have that. I just went to check. I don't have Resistance live. I might have been banned. Nope, I don't have Resistance or Silence live, if I'm being honest, so do not have it. Right. Oh, you said, why aren't we live with that? Just because, I don't know. Erica doesn't like to be on stream. She doesn't like it. And Scott, I mean, I'm not going to ask him again. Do you know what I mean? So I don't really want to bother people. Yeah. I wasn't even planning on getting Scott on at the beginning, to be quite honest with you. Scott was supposed to do Resistance, I think, and then Dana couldn't set it up. So Scott said he'd jump on. So, but I didn't ask him. He just came on and offered. So, yeah. Well, I'm not playing that arsehole, Lady Di, on my stream. He can go fuck himself. Right. What I might do is close it out. What you do with a drunken sailor? Put you and Dana in the same room together. Again, as we all know, right? What I'm going to do is put the other stream on. I lost the stream. I don't know where the stream is that we were finishing. Tomorrow is Brian Walshe anyway, so where is it gone? Hang on. Here we go. I got it back. This is the there's a little bit left of this heated thing, courtroom stuff. Oh, don't worry, it's no drama. It's just one person causing drama, not many people. Right, let's put this back on, and then obviously see some of you tomorrow. I'm going to play this for the next half an hour. I believe closing statements are going on in the other trial as well. So I'll watch this for a little bit. After this, then I'm going to stop stream for the night because it'll be like 7 hours by that point. So this is the end of it. There's about half an hour left of this.
The phone, you. Hey, first of all, you are not going to talk to me like that. Yeah, because Judge Warren wants to sabotage children's cases with their parents. I'm going to murder that. Where's your judge at, boy?
While McCarty talked, deputies tracked his location and arrested him. In court, McCarty was even less civil.
McCarty, President, he's under oath from the start of the trial.
No, I'm not. I'm not under oath.
I raise your right hand. I'm going to swear you in. That's your bad finger. I didn't appreciate that.
But he didn't stop at gestures.
My daddy owns the building and I look like a fucking idiot, huh? Brought your dress today, you little fucking prick. Shut the fuck up. I'm trying to think over here. Fuck.
Other room. It's done. Yes, sir.
The judge ordered deputies to take McCarty to a separate room so he could still hear the proceedings but not interrupt. However, things didn't go quite according to plan.
Talked to you about this before. Mr. McCarty has chosen to voluntarily absent himself as opposed to. Sorry, we got to deal with it, folks. I've chosen that one as opposed to duct tape.
Eventually, the judge brought McCarty back in on one condition.
I'm going to tell you to be quiet. You need to be quiet. There's not going to be a second time. If there's a second time, I'm going to duct tape.
I'm going to tell you, you just threatened my life, duct tape. Did everybody just hear that? You just threatened to duct tape me? Really? In the courtroom, a judge just threatened to duct tape me.
No, I said
you just said on record you're going to duct tape me.
Obviously, McCarty didn't take that threat too well.
No, I refuse. No, I refuse. I refuse. He threatened to duct tape me. He threatened to duct tape me. The judge threatened my life. I am scared. I want to be removed.
His tantrum showed no signs of stopping.
You threatened my life. I want to be removed from this room. You threatened my life. I want to be removed.
Finally, the judge gave in.
I am in fear of you right now, and I want to be removed.
See you.
I want to be removed. Thank you.
See you on Thursday for your trial.
Bring the dress. Little sweetie.
But the trial wasn't over yet, and the show had to go on.
Number one, you threatened the unborn child of the prosecutor directly.
What a bunch of you stupid piece of
Then also
You threatened my life, you
in the
you
back room.
Suck my dick.
Again, removing McCarty from the scene did nothing to calm him down. McCarty was still in the back room when the judge revealed his fate.
Count one, I'm going to adjudicate him guilty, sentence him to 15 years in Florida State Prison. As to count two, I'm going to adjudicate him guilty, sentence him to 5 years to run consecutive to count one.
McCarty was sentenced to 20 years in prison. McCarty's threats are horrible enough, but how does that compare to a KKK member whose hate crime left 3 train passengers dead? Like in the case of Jeremy Christian, who's facing charges for 2 murders and 1 attempted murder in Portland, Oregon. It all started on May 26, 2017, when Christian boarded a public transport bus after a night of drinking and immediately started threatening the driver.
It's like, we got a Christian or Muslim bus driver, I'll stab you too.
One passenger, Demetria Hester, asked Christian to stop, but then his target became her.
As I got off the train, he lunged at me with a Gatorade bottle filled with fluid and hit me in my right eye. And I grabbed my mace and sprayed him in the face with mace.
Christian fled without further incident, but the next day he boarded the train again. When he started yelling at 2 black teenagers in a hijab, bystanders stepped in to defend them. Micah Fletcher repeatedly pushed Christian into a seat, but that only made things worse. He ordered Christian to get off the train. That's when Christian took out a knife. He fatally stabbed Talisan Namkai Mechi and Ricky Best and slashed Micah Fletcher before leaving the train. He stormed off, brandishing the bloody knife. Minutes later, police found Christian walking down the street and surrounded him. In court, Christian showed zero remorse.
I shoved 2 people who confronted me while I was sitting in my seat.
And I said, what are you gonna do? We're gonna fight, but I'm not backing down. That's what happened. They wanted to fight. I do regret that 2 people died, but I do not regret my actions that led to their death.
It seems impossible, but he became even more vile when his first victim, Demetria Hester, took the stand.
You are a waste of breath. And when you die and go to hell, I hope you rot.
See you there, bitch.
Now, hey.
Go back to Tennessee too.
What do I tell you?
Go back to Tennessee too.
You can.
We don't want you here. All your race baiting bullshit. You ain't gonna be mayor either, bitch. You ain't gonna be mayor either, bitch. You fucking hoe. You fucking hoe. You fucking up my whole city. George Floyd. George Floyd. I should have killed you, bitch. I should have killed you, bitch. Everybody knows you're alive. Everybody knows you're alive, huh?
Then his other victims took the stand.
Was there? He said, kill yourself. He was saying, fuck Muslims. Saying, go back to Saudi Arabia.
Telling us that because of our religion or because of our color that we don't deserve to be here and that we don't deserve to live. But I feel like that doesn't make sense. Like, I was born and raised in Portland, Oregon, so.
Christian claimed he used self-defense against the 3 men who stood up against him, but the defense attorney had other ideas.
Self-defense does not apply because he provoked it because he was the initial aggressor.
Then the jury came back with their verdict.
On count 1, the verdict is guilty. That's murder in the first degree. On count 2, murder in the first degree. The verdict is guilty. On count 3, attempted murder in the first degree. The verdict is guilty.
After that, it was time for Christian to learn his sentence.
On count 1, imposing, it is a sentence of life imprisonment without the possibility of release or parole. On count 2, that is the charge of murder in the first degree through life imprisonment without the possibility of release or parole for the reasons mentioned in count 1.
Christian was sentenced to 2 consecutive life terms without the possibility of parole. Christian's verbal courtroom assault was directed at his victims. But what happens when a defendant verbally assaults a judge?
22 years!
Like in the case of Manson Bryant, who's facing charges for burglary and kidnapping near Cleveland, Ohio. Bryant was in court after getting caught robbing a trailer home with 2 female accomplices. Unlike his accomplices, Bryant had a huge criminal rap sheet, something the judge kept in mind.
The last time before this time that I had him, I put him in prison for 4 years for a robbery. He acted out briefly on his way out of the courtroom, and I just let it go. Well, it was clear that the remorse that he was trying to portray was phony, and that he wasn't remorseful at all, and that if given the chance, if I let him loose on society, he's going to prey on other people.
However, the judge was taken by surprise at Bryant's reaction to hearing his sentence.
With credit for 231 days. The court determines that you have or will have the ability to pay restitution.
Bryant is speechless at first, but then it sinks in.
The courtroom right there. Courtroom, man. You racist as fuck. You racist as fuck. Man, 22 fucking years. Racist ass bitch. You ain't shit. Nigga, and Danny Sturgeon, legal Sturgeon told me about that bullshit.
Actually, you know.
You never gave me probation.
Wait a minute.
You never gave me a chance.
The court determines maximum imprisonment is needed. So it's 11 years on count 1 and 11 years on count 3.
Because of Bryant's outburst, the judge added another 6 years to his sentence, increasing the total from 22 to 28 years. Bryant may have verbally assaulted the judge, but what happens when a defendant physically assaults their judge? Like in the case of Melissa Hardwick, who's charged with domestic abuse and terroristic threats in Monticello, Kentucky. Back in 2008, Hardwick's husband filed for divorce and a restraining order, claiming Hardwick was domestically abusive. In response, Hardwick took her ex-husband to court to convince a judge to give her back child custody. In court, Hardwick constantly interrupted her ex-husband.
My personal life is your business, John. It has nothing to do with
Miss Hardwick,
no.
You will be held in contempt of this court if you become disruptive.
Judge Edwards threatened her with contempt, but Hardwick refused to back down.
I haven't done anything to this court. I haven't done anything to him.
She will be arrested for contempt of court.
It doesn't make any difference.
You will serve 10 days for contempt of court.
The judge followed through on the threat, and it sent Hardwick over the edge. Hardwick rushed the podium, attempting to jump it and attack Judge Edwards. Deputies pulled her down just in time, wrestling her to the floor and into a pair of handcuffs. Hardwick's fists were restrained, but not her mouth.
Get off of me!
Can't find him back.
Wait and see.
After spitting out one last threat against the judge's life, Hardwick was removed from court.
You'll be sad when it happens, Jennifer.
Meanwhile, Judge Edwards is unfazed.
A new judge will have to be appointed to represent because she will be charged criminally for the threats that were made in open court today.
She recused herself from the case, but she has one last judgment to make.
Emergency protective order will remain in place of no contact.
The judge upheld the ex-husband's restraining order. For the attack, Hardwick was sentenced to 4 months in jail, 5 years probation, and mandatory anger management classes. Attacking a judge is bad enough. How does it compare to using bodily fluids to show discontent?
You just gave it 40 years. Well, guess what? Sir,
Like in the case of Ricky Hand, who's facing charges for serial robbery in Springfield, Ohio. Back in 2016, Hand visited multiple stores in Springfield and robbed them at gunpoint. Little did he know, this would be his last robbery. The owner sees Hand in the security cameras and he gets ready.
No! Get the hell!
Scared for his life, Hand makes a break for it. Meanwhile, the owner calls 911.
Yeah, this is John's drive-through, West Main Street. A guy just tried to rob me and I shot him. He ran out the back door. Okay, is he injured? I think I hit him.
Hours later, they find the culprit at a hospital, getting treatment for gunshot wounds. During the interrogation, Hand shockingly admitted to everything.
I did a crime, I ain't gonna lie. I just wanted to.
There have been probably a half a dozen or more robberies. Now you're looking at John's, you're looking at this break into this beauty salon. The beauty salon's a bonus because I didn't even know anything about that, and you told me that.
I'm going to prison for a long time.
Well, you know that.
Despite his confession, Hand hoped that the judge would go easy on him during trial. But when he heard his sentence,
Did you just give me 40 years, sir?
he was in for a rude awakening.
You just gave me 40 years. Well, guess what?
Enraged at his sentence, Hand decided to take his revenge.
Sir, what's this?
Hand reached into his cast, where he had hidden a toxic mixture of his own feces and urine, and threw the biohazardous contents onto his own lawyer.
You can't play Jesus and God? What's wrong with you? Man, 40 is a death sentence, man.
Police got the enraged criminal under control, but Hand refused to calm down. Ricky's explosive outbursts are frightening enough, but how does that compare to a defendant who cusses himself into a jail sentence?
You know what? You got a bad attitude. You had a bad attitude last time you were in court. You and her are buddy. Y'all get along. Y'all were 45 days county jail.
Like in the case of Jacob Larson, who's charged with violating a restraining order in Jackson, Michigan. Judge McBain ordered Larson to comply with the order, but he refused.
I told you to just leave her alone. She was a classmate of yours. She apparently has no interest in
I want her to tell me to leave her alone.
McBain slapped Larson with a 3-day jail sentence, but Larson wasn't fazed.
You know what? I told you to leave her alone. And apparently that didn't get through loud and clear. So today, you're going to jail for 3 days.
Things only got worse.
You and her are all you know what? You got a bad attitude. You had a bad attitude last time you were in court. You were even referencing discussions about my own daughter. Okay?
You and her are buddy. Y'all get along. Y'all are
45 days county jail. Okay. 93 days in the county jail. You want to go for a year? Try it right now.
The judge was finished with the conversation, but Larson wouldn't give up.
I never threatened.
Stand up. Come. Stand up.
Buddy, motherfucker.
Stand up. You're going to jail for a year in the county. 365 days county jail.
Can't do that.
Appeal it.
I will.
Then Larson turned his attention to the victim.
I'll leave you alone. I'm going to leave you alone. Tell me right now.
Put your hands behind your back.
But this time, Larson was outmatched.
Put your hands behind your back. Chase this right now.
Then the judge joined the fight, ready to take Larson down.
Put it down. That's enough for you. Get your taser. I'll bust your fucking arm.
It didn't take long for Larson to be restrained. Eventually, Larson was dragged out of court. Judge McBain reinstated the restraining order and ordered a final sentence of 93 days in jail. That's 93 more days that Larson would have had if he kept his mouth shut. Larson's obvious lack of remorse is sickening. But how does that compare to a murderer who jeers at his victim's mother during trial? Like in the case of Shondell Jackson, who's facing charges for capital murder in Milwaukee, Wisconsin. Back in 2009, Jackson tried to rob 21-year-old Nathan Potter on his way home from class. But when Potter didn't have cash, Jackson shot and killed him. Now in court, Jackson couldn't care less about his crime, and it devastated the Potter family.
They shot him. They dragged him and kicked him to the curb. My son, my God-loving boy. What kind of people do this? But evil people.
Judge, there's nothing that can be said to bring back our Nathan. But your sentence can ensure that Shondell does not have the opportunity as a free man to inflict pain like this again. Is there such thing as pure evil? We think so.
As the judge announced his guilty verdict, both families had emotional breakdowns, but nobody expected Jackson's reaction.
I am going to go ahead on count 1, the first-degree intentional homicide conviction, and I am going to sentence Mr. Jackson to life imprisonment without possibility for extended supervision.
He turned and jeered at the family, heartlessly laughing at their pain.
No remorse whatsoever. Seem to be proud of it.
We see how evil Shondell is in court, looking at us, swearing at us, and smiling.
But Jackson's false bravado wouldn't protect him for long. At the sentencing hearing, Jackson hoped for an easy prison sentence, but after his behavior in court, the judge wasn't so merciful. She sentenced him to life in prison without parole, and Jackson lost it.
I know that that is something that is reserved for the most serious of cases, and I believe that this case rises to that level.
Jackson turned his head toward the Potter family, but deputies were ready for him. But Jackson wouldn't go down that easy. Jackson's tantrum was quickly stopped, but that didn't stop his family from causing a scene. Jackson's outburst earned him the harshest punishment possible. But what happens when a defendant decides to just walk out in the middle of sentencing?
With MSP, with 15 to be hereby suspended. James, sit up. James.
Like in the case of James Wasson, who's charged with the sexual exploitation of minors and creation of child abuse material in Houston, Texas. In May of 2020, a minor notified the police about Wasson's sexual abuse toward her. When they searched his phone and computer, they found over 500 photos and videos of him inappropriately touching multiple underage victims. Now in court, Wasson is about to face his punishment. With each sentence, the judge adds to Wasson's prison sentence.
The court hereby sentences the defendant to 10 years MSP with 3 years suspended.
But when the total climbs past 26 years, Wasson can't take it anymore.
The court also sentences the defendant to 10 years MSP with 3 years suspended on each count. Each of these counts shall run consecutive to each other. So the sentence in DC 17.
After whistling in disbelief, Wasson decides he's heard enough and tries to leave the courtroom. The police block his path.
267. I'm good to go. Is 50 years MSP? No, I'm good to go. Is 50 years with MSP, with 15 to be hereby suspended.
The higher his sentence became, the more agitated Wasson acted. But the police were ready for him.
To be hereby suspended.
James, sit up. James.
Taking out of you, man. Didn't matter.
Wasson had no choice but to sit down and listen. The judge finally revealed his verdict. 30 years in jail. To that, Wasson had only one response.
You can suck my head.
Luckily for Wasson, the judge didn't add any additional time for the insult. But how does that compare to a defendant who attacks their own attorney? Like in the case of Christopher Teal, who's charged with rape and kidnapping in Seattle, Washington. Records show that Teal, who was homeless, stalked a woman into the bathroom of a Volkswagen dealership where he held her hostage and assaulted her until store employees broke down the door. In court, Teal's handcuffs were removed to prevent jury bias.
State defendant is present in custody with counsel. This is a defense motion to continue the trial date, which the state has no objection. I'll defer to counsel and, if necessary, ask for a opportunity to respond.
Everything was going smoothly until Teal did this.
Counsel, who I'll defer to in a moment, that they are now stipulating that Mr. Teal.
Completely unprompted, Teal smacked his attorney in the back of the head. Officers tackled him, but it was too late. The damage was done. Christopher resisted the deputies, but with a team of 3 officers on his back, he was quickly overpowered. The next time Teal was allowed in court, he was tied to a chair. Surprisingly, he had something more important on his mind.
I got one question, one thing to say. I'd like to know where the they got that photo of me with my short hair. Because that was on Facebook, and I don't have a Facebook.
All right.
So you're on that. Legitimate question. Like, do they have access to Google?
Because of the attack, Teal was forced to find a new lawyer. Not that it made a difference. Teal was sentenced to 8 years in prison for his original crimes. However, the sentence for his attack has not been released.
There we go. That is everything. Happy days. There you go, everyone. We close that down. So tomorrow, well, I'm going to shut this stream down now, and I'm going over to my next stream. As in, I got 2 streams going on. It's the Nicholas Casito's closing statements, I believe, is still going. So I'm going to go over, say hello to everyone in chat there. If you want to come along, just come along. If not, that's fine. Tomorrow we got probably that trial. I'll stream again for deliberations. I'll be going all day, and then I'll do a Brian Walshe day. There's a hearing for Brian Walshe and all the others tomorrow afternoon at 2 o'clock. But what I might do is there's an Annie Elise documentary she released 2 weeks ago, showing going through the case of Anna Walshe. So I might just play that and chill out tomorrow. Might play some Anna Walshe stuff in the morning, and then watch Brian Walshe in the afternoon. Then at the hearing again, probably stream from Mike Young Jerks. But yeah, thank you, Wicked Slice. Have a good night, my darling. Thank you, everybody. Thanks for joining us. Thanks for everyone's contributions. Thanks for new people that we had in chat as well. Thank you for chatting. Please come back if you fancy it. Yeah, and that's it. That's the end of the stream. Thank you very much, everybody. Another 7+ hour stream, and then the other one, I'll go and join the chat in the other one now so we can say hello to each other. But no, you're more than welcome, Jersey Jen. Welcome back at any time. We're not everyone's cup of tea, but if you're a weirdo, you'll normally fit in quite nicely here. So thank you for coming, Jersey, and everybody else. If Dana Lennon fits in, then everybody fits in. So thanks, Dana. Thank you, everybody. Take care of yourselves. It's Wednesday night. So yeah, see some of you on the other stream in a second. Good night. Take care. God bless. Bye-bye. Bye-bye, baby.